My lord,
Appellate side mentioning.
my lord, the thing is this, my lord, your lordship is taking fixed matters. Mostly, my lord, kindly
Fixed matters.
take motions for some motions.
No, I don't understand, Mr. Ghosh. What is it that you want?
The motion, there is a
Huh. Huh. Is there a particular matter which you want to be taken?
I have, but
Which one is that?
135.
Which one is that?
Today's list is 135. It's all right.
Yes, no, that is fine. Just tell me the urgency, Mr. Ghosh. Tell me what the urgency is. I will.
No, the thing is this, my lord, they are asking, my lord, they have withheld my money. And my
Who
lord,
is they?
Indian Coal Corporation.
Indian Oil Corporation.
And in the process, my lord, I have not, there is no reason why they have
Withheld since when?
2020.
2020. And is this the first time you're mentioning the matter?
It's the second time I'm told.
Second time. The first time was in 2020.
Yeah, it was filed in 2022. It was filed in 22.
2022.
I leave it to your lordship. I'm not pressing, my lord. I leave it to your lordship.
This matter, I am for the IOC.
Yes.
Yes, how does it know? This money that they are saying that it has been withheld, there is a matter pending. Already a writ matter is pending between the same party. And by the virtue of the order of the Honorable High Court, the said.
Very well. This is not the time for arguments.
There is no order.
Let me hear the matter and then I will decide whether that other order will serve as an impediment or not. All right. What is the number, Mr. Ghosh?
135 in today's list.
135. Very well. It will be upgraded on 13th. 13th or 17th. All right.
Grateful, my lord.
Yes.
My lord, for upgradation, my lord. Item 197 of the combined list, my lord.
I can't hear you. Microphone, please. I can't hear you. Microphone, please.
Item 197 of the combined list, my lord.
Yes.
My lord, for upgradation, my lord. My lord, private restaurant, my lord, made a pond for brackish water fishery, my lord. My dwelling house is highly affected and my pond is highly affected.
Last cause of action?
Yes, my lord.
Last cause of action.
Last one, I filed the representation, my lord, but did not take any action, my lord.
Come back with dates, please. You don't know the matter. Yes. Come back with dates. Yes.
Can I have your lordship can leave to mention one matter for the extension of interim order? But I have mentioned this matter on 3rd, that is last Monday. Today is the date, my lord, for expiring the interim order. My lord has been pleased to
Very
fix
well.
the
To
matter
be mentioned tomorrow.
Grateful.
My lord, one non-prosecution matter, my lord.
Writ petition of which year?
My lord, this is 2023, my lord.
Very well. On 12th? Yes.
May I be permitted to mention a listed motion? The cause of action, last cause of action arose on 15 December 2022 when the bank stopped my transaction. It's a fixed deposit account that I have with the bank, which is pursuant to an order of this court. Lordship, the suit has been dismissed. We want to operate the account. The bank has refused on 15 December of 2022. Lordship,
When did you file the writ petition?
Lordship, in January.
And you have not listed it
The
or
matter
it's
has
running
not
in the
been
list?
listed as yet.
Not listed as yet?
Lordship.
Then why did you wait for 4 months for the matter to be
Lordship,
listed?
I have mentioned, my junior has mentioned the matter on 2 occasions.
Yes, 19th.
Lordship.
Notice to the other side, please.
My lord, item number 133 of monthly list, my lord. This matter, my lord, has heard extensively, my lord. What has happened, my lord? The emergency exit has been blocked by illegal construction. My lord was directed to give short affidavits. Affidavits are complete. My lord, on 30th January, my lord was directed to appear the matter on 14th February. Now the matter appeared, but much lower in the position, my lord, never reached, my lord.
Very well. The 25th. Notice to the other.
May I have lordship to mention urgent matter 42 item. Item number 42. They had notice on 28th that they will demolish my structure.
Who is they?
They mean the railway authority.
Say that, please.
We took settlement from the railway authority and 3 years as given. Now, the 2 years, 2020, it was agreement. Since 20 March to 21st April, there is no train was plying. And that's why no business was there. We paid the entire.
Well, if it is not taken up today, you mention it on Thursday, it will be taken up. Yes,
May I
Mr.
have
Shah.
your lordship, my lord? Your lordship had heard, my lord, the railway signaling systems matter, and lordship had passed an interim order directing inspection to be carried out in a particular manner. Well, thereafter, my lord, of course, my lord, they did not carry out. We filed a contempt application, but finally, your lordship was pleased to direct that affidavit be completed. The writ petition will be heard out on the 6th of April. 6th of April, my lord, the matter could not be taken up. The affidavits are ready, my lord, but the contempt application is, my lord, intervening because, my lord, whenever the matter is coming, it's being tagged with the contempt application. So it had been represented to your lordship that we will not press the contempt.
Yes, I remember. I had said that the contempt will first have to be listed, then the writ
The
petition.
only difficulty is, my lord, 100 crores worth of purchase orders, my lord, are on the verge of being cancelled.
Mr. Shah, I will list the contempt on 13th and
That-
then immediately
I'm
take up
very
the writ
grateful. I'm
petition.
very grateful.
13th contempt.
Lord, may I have a lordship can leave to mention about it is not in the list. My lord, since 2021, my lord, I have been supplying the articles to the state home welfare home, my lord, with the strength of the tender. The till my lord 31st March 2023. In the meantime, my lord, tender sought for, my lord, I have participated, I have been selected, my lord, without finalize the tender, my lord, the persons, my lord, the individual person have been, my lord, allowed to supply on 1st April 2023. But he has not participated in the tender.
Very well. You're not arguing the matter. What is the urgency?
Urgency is this, my lord, without finalize the tender, which I have
Last date?
last date, my lord, on 1st April 2023. So, my lord,
Very well. On 18th April.
Lord, I am supplying the numbers.
May I permit
Notice to the other side. Otherwise, no ex parte orders.
permit to mention matter? May I permitted to mention one matter, my lord? The matter is regarding,
I can't hear you. Microphone.
that matter is regarding, my lord, the petitioner took a warehouse in
Hurry up and mention, please.
godown rented, but after that they vacated the rented godown. But the security deposit amount did not release by the respondent authority, Central Warehouse Corporation.
Last, give me some dates.
Matter in the filed on
Come back
2021.
with facts. You're taking too much time. Come back with
Matter,
facts. Yes.
lastly,
No,
in the
Come
month
back
of
with
March,
facts.
I have
My lord,
placed before your
I
lordship, my
to
lord.
mention item number 140, my lord. This is a writ petition challenging the Rule 8 of the Excise Rules 2003, my lord. Your lordship has already heard the matter extensively, my lord. And the last of such hearing was made on 13th February, my lord. And the matter was
It's an assigned matter.
no, my lord. This is a matter. It's a retributory matter, my lord. Applicant
Affidavits are complete.
affidavits are complete, my lord.
Very well. First week of May. Yes.
My lord, the matter was about to appear on 23rd February, my lord.
Not before first week of
May I
May
have
or
your
last
lord-
week of April.
May I
Yes.
have your lordship to mention that, my lord, one matter by virtue of the division bench order, the matter was directed to complete the hearing by 20th January 2023. But as per the order of this honorable court, since a contempt application has been filed, the matter was running in the list under the heading contempt. So contempt matter is intervening for to complete the hearing as per directions of this honorable court. So, my lord, the split up of this,
You are the respondent in the contempt.
where I am the petitioner, my lord.
Yes. And you have filed the contempt.
Yes, my lord.
So you don't want the contempt to be heard.
Because as per division bench order, my lord, they are
Very well. 13th, I will pass necessary orders on the contempt only. Yes.
May I have your lordships kindly to mention the petitioner had registered in the adoption portal, lordship, in October 2022. On 28th of February, he has been told that he has been deregistered and now he has to re-register again. The only apprehension is, lordship, in this interregnum, his combined age of the parents would increase beyond 90 years and he would not be able to adopt an infant.
You're
lordship.
90 years.
Lordship, the combined age of the parents, the
Yes.
modern adoption rules say so, lordship. So he will not be able to
When
adopt
will
a child.
the combined age exceed 90 years?
Lordship, that has exceeded in February. In March 28th, he has been told that he has been deregistered for some technical aspects. We've taken out the writ as soon as possible, lordship, on the first week of April. First time I'm mentioning, lordship.
Very well. On 12th, notice
I'm
to the
so
other side,
grateful,
please.
lordship.
My lord, may I permit to mention one matter? This petitioner is an old aged lady, my lord. She went to Hyderabad for her medical treatment to her son. But when she came back to Kolkata, she noticed that her flat is sealed and locked and key by the housing department, West Bengal housing department. She is in distress condition, my lord.
What about her son?
Already, her son also.
No, so there must be some loans which have not been
No,
paid.
he is a tenant of housing department.
Last cause of action?
22nd February 2023,
When did you file the writ petition?
9th March.
Very well. On 12th, notice to the other side, please. Yes.
My lord, if my lord, may I permitted to mention, my lord, this matter, my lord, pursuant to a tender, my lord, the work has been completed by the, my lord, successful bidder. My lord, I am for the successful bidder, my lord, a part amount has been released, but a separate, the remaining part is not being paid despite request being made. Last request made by me was on September 2022. We filed this writ petition in the month of December. My lord, kindly includes this matter, my lord, and my lord,
Yes, first week of May, notice to the
Lord,
other
may I
side.
be permitted to mention one matter relating to the RTI application. Petitioner made RTI application. Thereafter, the RTI authority provided some false and incorrect information. Petitioners, after completion of second appeal, made a complaint. But in the complaint petition, the responding authority that the CIC is rejecting the prayer of the petitioners, and which is required in respect of the petitioners.
Dates?
Lordship, last cause of action, 2nd of August 2021. It is running in the monthly list, Lordship, 257 item.
Yes, first week of May. Yes.
May I have your lordship's leave to mention a matter which is running in the lordship's list as item 129 in the monthly list. In the meantime, the matter has gone out of the list. The urgency in this matter is, your lordship, the bank are the respondent authorities. Your lordship has extensively heard this matter. Affidavit in opposition has been filed. We have already served a reply. It is about to be heard by your lordship. In the meantime, the bank has instigated the DRT to send us a notice where there is a clear embargo given by your lordship that the bank will maintain the state of affairs.
What is the date of my order?
Your lordship's last order was dated 2nd March 2023. And the order which I am referring to, your lordship, is on
I have restrained the bank. It's under the SARFAESI Act.
it's on the SARFAESI Act, your lordship.
I will
There was a-
vacate the order, I'm telling you.
Your lordship,
It
this
okay,
was-
13th
there
listed
was a
author-
forgery and interpolation, Mr. Mithun.
13th.
30.
I will vacate the order. I'm warning you. Yes.
The matter is filed on the month of December, and but the same has not as yet been listed.
What is the
matter-
urgency?
16 December,
Come back with facts.
but
Yes.
has not as yet been listed.
No, come back with facts.
May I have your lordship's kind leave to mention item number
You have
124
to
of
tell the court what the urgency is. Yes.
item number 124 of your lordship's list, my lord. This matter is a writ petition of 2021. Last time it was heard by your lordship on 13th of February 2023, and thereafter the matter has not been called on. I have extreme urgency because in the meantime bank has declared my assets to be an NPA. I am engaged in the business of rice milling.
Anything under the SARFAESI Act?
No. I am engaged in the business of rice milling. I have
What are you saying? No. Then under which act?
under my lord, my claim is arising against the state government because I am engaged in a rice milling operation where I have raised huge amount of bills for threshing, milling and husking of rice to the state government, and more than crores of rupees are kept pending.
Yes, on 27, notice to the other side.
I am grateful, my
To
lord.
mention a matter, my lord. My lord, this matter pertains to non-issuance of eligibility cum registration certificate, my lord, under West Bengal incentive scheme, my lord. My lord, affidavits have been exchanged by
But
your lordship.
that scheme has expired on 31st March.
My lord, the state government has rejected my.
Yes, but that scheme has expired on 31st March.
My
So
lord,
what
the
remains of the
rejection
writ
is-
petition?
My lord, the rejection is bad, my lord. They have rejected me on a ground which is not, which cannot be found
Yes,
in the.
first week of May. Yes.
My lord, I am item number 55. I am withdrawing the writ petition as DRT is in charge now. That's
To
why.
be mentioned tomorrow. Yes.
Well, let me be permitted
Grateful.
to mention this application matter. This is relating to non-compliance of my RTI application. Well, for issuance of the hard copy of death certificate by the Howrah Municipal Corporation, my lord.
I can't understand. What is the urgency?
My lord, the urgency.
What do you mean by my death certificate? What is this?
My lord, death certificate, my lord. The
Come back with facts.
No,
Yes. You're
lord,
saying
the
my
fact
death
is the-
certificate I'm not getting. What is this?
My lord.
Yes.
My lord, the petitioner's uncle, he died on September.
Then why are you saying my death certificate?
No, it's not my death certificate.
What is the urgency? Hurry up, please.
My lord, the urgency is this: unless the death certificate given by to the petitioner, my lord, the petitioner is unable to
dates.
In September 2021,
First week of May. Yes.
My lord, may I permit to mention a new motion, my lord? It's regarding an arbitration matter. My lord, this is Ravi Krishna Kapoor had directed the Director of Mines and Minerals to cause an inquiry with regard to illegal sand mining. That order was passed on 13 January. My lord, the direction was supposed to be complied within a month. My lord, thereafter we have forwarded notices. My lord, nothing has been done. We have filed the writ petition 10th
Then
of
how
March.
is it before my court?
No, my lord, because we have filed under the Group 9 determination.
No, no, you're saying Justice Kapoor has
In
given
an
a
arbitration
connection.
matter, my lord. That was in an arbitration matter, my lord. It had directed the state to file a report.
Not before the first week of May. Yes.
My lord, kindly
Permitted to mention a matter for inclusion in the list. The writ pertains to challenging an inaction on the part of the Ministry of Corporate Affairs in updating the master data of the petitioner company. The last date of cause of action is of 17th of January 2023. Any day convenient to your lordship.
Last week of February. Yes.
Mentioning for upgradation of the matter, my lord, the petitioner is a 70 years old person, and his property has been acquired by the ECL in Asansol, and not paying the rent. Rather, they are renovating from February. They are started renovating the said property for their own purpose, my lord.
What is the urgency?
Well, they are not paying the
Come
rent.
back
and
with
they are-
dates. Yes.
Well, on
yes.
the February 28th February.
No, come back with dates.
Your
Yes.
lordship, may I be permitted to mention one matter, content application number 119 of 2023. We have filed the application on 24th of January 2023 against the order.
Order
Order.
dated.
The order has been passed on
Yes.
16 November 2022. 16 November 2022 by 6 weeks.
Mention on the next day. Yes.
My lord, I am mentioning for sixth time that
Only
on list-
mention again for another 10 times. Don't say that. All right.
No, my
Yes.
lord, I am mentioning for sixth time.
Yes. Anybody else? Yes.
May I have your lordship's leave to mention one matter, my lord? This one regard to the right to travel has been restricted, my lord. Right to travel abroad, my lord.
Yes.
The extreme urgency is, my lord, I have to finalize a deal, my lord. I have to travel to Singapore, my lord. This is the only urgency that I have at this moment.
Urgency. Why do you need to go?
My lord, for finalizing a business deal, my lord, I have the letter, my lord, which has been communicated to me, my lord. By
What is the last cause of action?
last cause of action is, my lord, on 17 March on the letter has been issued, my lord, where from time to time, my lord, your lordship has passed an order, my lord, interim order, my lord, allowing us to travel abroad, my lord, when there is an urgency.
Yes, 28th. Yes.
Your lordship, may I be permitted?
My lord,
Yes, you.
my lord, may I mention a can for inclusion? My lord, in a writ petition, my lord, the petitioners are seeking a refund of a sum of rupees 73 lakhs that was overcharged by the stamp authorities, my lord. My lord, there were directions for filing of affidavits. The respondents did not file affidavits till date despite writing a number of letters. The period has expired. My lord, we have filed a CAN application requesting for disbursement of the sum. My lord, it may be kindly taken up on any day. My lord, it's a sum of rupees 73 lakhs odd is lying pending with the respondent authorities for number of time.
Notice to the other
28th.
side.
Great,
Yes.
my lord.
Second round litigation, my lord, in spite of lordship direction, my lord, but they are not fulfill my criteria, my lord.
Can't
Not
understand. Yes.
supplying the instruction. Where is my lord?
I can't understand.
Item
Come back
number
with facts.
674 of the monthly list for upgradation. Urgency is that a respondent has converted a Joel Jomi for erection of a mobile tower, and for that I have intimated the concerned district level committee and the superintendent under the dates. Last cause of action was in the year 2022 April. I filed the writ petition in May.
Yes, mentioned in the last week of April.
May I have your lordship's kind leave to mention item number, my lord, 403 of your lordship's monthly list. My lord, the urgency is that, my lord, the petitioner is a small scale entrepreneur, my lord, who has been registered under the Pradhan Mantri Urban, my lord, employment generation schemes under the MSME, my lord, department. My lord, therein, my lord, the petitioner was approved for a project, my lord. Loan was sanctioned. The bank, my lord, everything was done in the month of December. 23rd of December, my lord, the bank thereafter refuses to pay the loan amount to the bank.
When did you file the?
My lord, we have filed the writ petitions in the month of January, my lord, and thereafter, my lord, since then, my lord, it could not have been taken up, my lord.
Not before you mentioned the last week of April. Yes.
My lord.
I filed a CAN application. I had filed a CAN application regarding the social welfare scheme being run by the state government of West Bengal. So, enter tender process is stopped. The pendency of the writ petition. So I filed a experience application regarding CAN.
Who are you?
I'm in favor of respondent
Respondent. When did you file the CAN?
for expeditious hearing, my lord.
When did
Application.
you file the CAN?
Yes. Last
Yes,
week of
we
March
can't even understand the
2023.
report.
My lord,
Yes,
for
yes.
non-prosecution.
You mention on the next day.
For
Yes.
non-prosecution.
Which year?
23.
Yes, Wednesday. Yes.
My lord, this is a writ petition filed in 2019 and extensively heard by lordship. This is a writ petition challenging the compulsory retirement of the employee where the disciplinary authority acted as the complaint
When
made
was
against
the
the
matter last
director.
heard?
The director complaint made.
Yes, you can't understand. Yes, you come back on the next day. Yes.
I'm for the private respondent. The petition was filed in the year 2008. I have been listed in the notary public, but due to the pendency of the writ petition, my name has not been listed and the registration has not been given a ballot.
What is the last cause of action?
The matter has not been taken at till
From 2008, the matter has not been taken.
2018.
2018, the matter has not been taken
Not
up.
been taken up.
Yes, on 24th, notice with the other side.
My lord,
Yes.
it's the lordship mentioning this matter, my lord. The petitioners are midday meal workers since November 2019. No payment has been made. My lord, only the head.
When did you file the writ petition?
It was filed on February 6, 2020. Then, my lord, it was appearing before my lord Mr. Sen. But as the court has no determination, we released on February.
Justice Sen.
Justice, my lord, Partho Sarathi, court number 12.
Yes.
Because
when was it released?
on February 2, 2023. Last week I mentioned, your lordship asked me to mention.
Yes, 24th, notice
I
with the
am
other side.
extremely grateful. Great.
Yes,
My lord, may I be permitted to mention for inclusion?
I can't hear you.
For inclusion, my lord.
Urgency?
The urgency is this, petitioner.
Yes, come back
Took
come back on the next day. Yes.
Hello, with your lordships, kindly, I'm mentioning one listed motion. And
I can't understand this.
But listed motion, my lord, earlier twice I mentioned this matter. Your lordship was pleased to direct that the matter will appear in the first week of March 2023. Thereafter, again, I mentioned, my lord,
What is the urgency in the matter?
urgency is, my lord, without serving any notice, without serving any intimation. My lord, my brother obtained a probate. On the basis of that probate, they have already sold out the property.
Last cause of action?
The last cause of action, my lord, in the month of December. I filed in
You don't know which year?
Well, 2022. When I filed in the writ petition, filed in 2023, my lord, January 2023.
Yes,
But kindly
first-
take it up, my
First
lord.
week of May. Yes.
My lord, earlier, my lord, your lordship's twice direction given, my lord, that it will.
Very well. Last week of April. Yes.
May I permit to mention the petitioner after the superannuation, petitioner deposited the money to the Lake Town post office, my lord. But they say that they denied that, but they issue the passbook, everything.
Come back on the next day. Yes.
My lord,
the new motion, my lord.
Petitioner took loan from LIC.
My lord, several times. My lord, the petitioner is 78 years old. My lord, the registered a document.
Mentioning the age of the petitioner is not relevant. If you do that, I will not list the matter. Please don't do that. I've said that repeatedly every time. Please.
My lord, registered a documents, but subsequently.
Yes, original side mentioning? Any original side mentioning?
Original side mentioning?
Madam, may I give this?
No, no. Original side mentioning?
Original.
Madam.
Original side mentioning?
Original side mentioning?
My lord, may I be permitted to mention a matter, my lord? My lord, I'm mentioning to obtain a leave, my lord, for drawing up and completion of the order dated March 23rd, 2023, my lord. My lord, there were three matters, my lord, which were disposed of by a common order. It was challenging a show cause notice that had been issued to the petitioners with regards to declaring them as a willful defaulter, my lord. My lord, at the show cause notice stage, your lordship had.
Yes, leave granted. Yes.
My lord, I'm mentioning item number 24 of my lord's list. That's a square form.
I can't understand. Please,
Hello?
microphone.
Yes, ma'am. My lord, I'm mentioning item 24 of my lord original list today. It's the square form matter GA 1835. My lord, we had completed our submissions. Mr. Dhruvo Ghosh was continuing his submissions. If my lord could fix it on any day, subject to my lord's-
the square foot. Yes.
It may be permitted to mention item 21 of today's list. My lord, the urgency is that the petitioner is an L1 bidder in multiple tenders. The petitioner is an L1 bidder in multiple tenders. He's been blacklisted without being given a hearing. My
Give
lord,
me some dates, please.
blacklisting has happened in December 2022.
Yes, come back on the next day with dates. Yes, original side, call on the list, please.
Do we mention item number 1?
This matter has been assigned to your lordship.
Yes, Who is for the respondent?
My lord, so far the warehousing corporation is concerned, my lord, they have not filed any opposition and they are not proceeding. So far Food Corporation of India is concerned.
Very well. I'm putting the matter next Monday. You please inform the.
My lord, this is an assignment.
This matter has been assigned to this court. Stop. The respondents are not present. The respondents are not represented. Stop. List this matter on 17th April 2023. Stop. Learned counsel appearing for the petitioner is requested to communicate this order directly on the respondents.
I'm good.
Next.
I'm good.
Item number 2.
My lord, I am for West Bengal Medical Council.
But I appear for the National Medical Council.
Yes, the date of the order will be changed. To me. Yes, next. তো তুমি যখন কপি পেস্ট করো তখন কি উপরে ডেটটা চেঞ্জ করো না নাকি কি করো? Next.
Item number 3.
Your lordship, is supposed to be release the matter. Your lordship
On what ground? Why should I release the matter?
Your lordship, item number 3 is WPA 20.
I can't understand. Why should I release the matter? What is it, Mr. Shah?
No, this is against the register of societies. Some documents they are not finding out, that is.
Yes, but why do you want me to release the matter?
In last 2 occasions, the writ petition has been filed in the month of December. Since then, the matter has not been listed.
For release, listed?
Yes, listed. In the list, it has been written as a for release.
For release, listed. Yes, this matter has been listed at the instance of the petitioner who sought for release of the matter. Stop. Next, learned counsel representing the petitioner is, however, not clear as to why this court should release the matter. Stop. List this matter tomorrow. Next.
Well, tomorrow, if your lordship wants hearing, will kindly take it up in the next week. In the meantime,
Let me see why they want release of the matter. Yes.
Item number 4.
Lord, item number 4 is a excise license matter. My lord, on the last occasion, hearing concluded, your lordship directed both of us to file written notes of argument.
Just 1 minute. Yes, notes have been handed up.
Yes, handed up, but record could not be, no order could be recorded on the last occasion due to difficulties, lordship.
Although this matter was directed to be listed on 6th April 2023, this court was unable to record any order by reason of a strike taken out by the employees of the court. Stop. Next. Council have handed up their respective notes. THEIR. Stop. List this matter under the heading. List this matter on 19th April 2023 under the heading for judgment.
Grateful, lordship. Grateful.
Item number 5.
In this matter, my lord, I appear on behalf of the petitioner. Lordship might recall challenges to the LOC, my lord. Initial challenge was traveling, then LOC by way of an amendment. My lord, we have concluded our submission. Learned DSG concluded our submission. Bank was supposed to conclude today, and lordship directed them to produce the LOC because in none of the affidavits, my lord, they have disclosed the LOC. Lordship wanted to see this document, and that was the last order.
Yes.
Happy, my lordship.
Where is
I
the,
am for union opinion.
where is the LOC, Mr. Singh?
Lordship, on the last occasion, your lordship was pleased. I was arguing before your lordship on the pretext that the LOC request was made as per the amended office memoranda, which is very confidential, 8th of April 2022, according to which the LOC cannot be shared with any individuals until and unless there is specific direction from the court. On the basis of that, your lordship was pleased to direct that amended office memoranda, whereby it reveals that the LOC request issued by the originator is as such confidential and it should not be shared with any individual. Lordship, I am placing that amended portion of office memorandum of issued by the Ministry of Home Affairs.
Yes. So have you produced the LOC or only the effect?
Lordship, I'm on that amended portion. And so far as the LOC is concerned, I have made a request to the bank officials. The office is in Chennai. They informed me over phone that because of the vacation, they are not in a position since as per this office
What
memorandum.
vacation?
Lordship, because of Saturday intervene, Good Friday intervene, because of that, they won't be able to send it by post. It's supposed to come from the Chennai. Be that as it may, Lordship, they had, so however, they have supplied me this office memoranda, according to which the LOC is very confidential, can only be produced as per the direction of the court.
This is the third time you're saying that. The direction was clear from the court, so produce it. That's
Lordship,
all.
yes, I shall produce a Lordship. Only a 1 week's time may be given, and I'm placing the relevant portion of this office memoranda.
Yes.
Your Lordship, the para.
Maybe be favored with a copy of this.
Lordship, I cannot, Your Lordship. Kindly see the
Very
nature.
well, he's reading out. You take down,
Very well.
Mr. Dev. Yes.
Lordship, may I place the relevant portion of the first of all, the para 3.
Yes.
Ministry of Home Affairs has now emphasized that the documents related to LOC are clarified in as classified in nature, and such classified documents are not to be disclosed to any individuals.
Yes.
Therefore, in order to preserve the sanctity and purpose of such classified documents, Ministry of Home Affairs has requested that the directions be issued to the banks not to share the LOCs issued by Bureau of Immigration with anyone. Ministry of Home Affairs has further advised that when asked by the court, bank may furnish only the LOC requests that they had sent to the Bureau of Immigration. So according to this, Lordship, we have acted. We cannot share with any individuals.
Next line.
Lordship, I was also arguing before your Lordship, by way of amendment.
Next line. Read
Lordship,
the next line.
Lordship, the MHA has further advised that when asked by the court, bank may furnish only LOC requests that they had sent to Bureau of Immigration. The same may not be shared with anyone except the court.
Yes.
In addition to sharing with the court, when asked by the court, clients may only be informed through a separate letter that the bank has requested for LOC issuance against the client. So also the petitioner is well aware that the LOC request has been made. What is the contents of LOC issued by the Bureau of Immigration then can't be shared as per this office memoranda. And the second office memoranda, I was arguing before your Lordship on the last occasion that the by way of amendment, the argument before your Lordship is that the office request for LOC cannot be made for recovery purpose. But by way of office memoranda, April 2022 and 2019, which I have placed on the last occasion,
Yes.
the very purpose is also recovery.
Yes. Which paragraph?
Lordship, paragraph number 2.
Yes.
And the category of defaulter. In this regard, reference is invited to the Department of Finances Services, later dated such and such, copy enclosed, written to all the public sector banks, informing that the heads of public sector banks had been empowered by the Ministry of Home Affairs to issue requests for opening of LOCs. DFS has advised that all the public sector banks for strict compliance with the instructions contained in the Ministry of Home Affairs guidelines as amended from time to time. So, this is important. So, that all persons who are covered under the guidelines, including fraudsters and the persons who wish to take loans and willfully default or launder money and then escape from the foreign jurisdiction to avoid paying back, are restricted from escaping from the country. Subsequently, DFS has again written to the all public sector banks by letter dated such and such requesting for appointment of nodal officers in bank for this purpose. Accordingly, various banks would have from time to time issue requests for opening of LOCs.
What is DFS?
Lordship, the DFS is Department of Finance Services.
Department of?
Financial Services. So Lordship, the very purpose of amendment prior to amendment, the LOC can only be requested when there is an interest of public interest at large, sovereign of country. All these clauses were there. But by way of amendment, the amendment talks about the contention that yes, if a person is willfully defaulted and they are not paying the dues of the bank, trying to escape the country, and by holding the public money, the bank can issue LOC.
Very well. Produce the LOC on the next day, please.
Lordship. Lordship, a week's time may be given so that I can get
Yes,
it by registered.
learned counsel appearing for the respondent bank. Hands up places the paragraphs of
Office memorandum, Your Lordship. Dated
where does it say office memorandum? Doesn't say
Ministry
that.
of Home Affairs, urgent.
A communication.
Yes, communication.
A communication dated 8th April 2022, issued by the Deputy Director of the Ministry of Finance, Department of Financial Services. Stop. Council submits that council seeks a week's adjournment, week's time to produce the LOC. Stop. List this matter on the ground that the head office of the, which bank is this?
Indian Overseas Bank, Your Lordship.
That the head office of the Indian Overseas Bank based in Chennai could not make arrangements for sending the LOC due to the Easter vacations. Stop. List this matter on 17th April 2023 as prayed for.
Lordship, much
But
obliged.
only one thing, Milord.
Yes.
No, I'm not praying. Milord, I have not cited few judgments, and one judgment was cited on behalf of the learned DSG. Milord, on that day, Milord, after they produce and conclude, Milord, give me, Milord, 2 minutes time, Milord, I would conclude.
Very well. Yes.
My lord, kindly fix it 18.
What?
Let the matter be appear on 18, my lord.
Why?
I will not on 17.
18th. Kora. Next.
Item number 6.
Lordship, item number 6, respondent number 2, Mr. Sukumar Bhattacharya appearing in this matter. Lordship, it's on court number 1. Kindly take this matter on 2 p.m. if possible. 2 p.m.
You are for the petition?
Lordship, that matter, Lordship, that wife is a co-borrower and husband and wife purchase a flat. And after that, the husband left.
Yes, 12:30.
Lordship.
12:30.
Item number 7.
Item number 7, I'm appearing for the petitioner, my lord. My lord would recall that this is this matter with regard to blacklisting, where I was blacklisted along with several other contractors. My lord, I'm led by. I was blacklisted by along with several other contractors with regard to certain works, works which were carried out for the West Bengal State Rural Development Agency, my lord.
Nobody was appearing for the state.
Yes, my lord had directed that we serve a copy on Mr. Nilotpal Chatterjee. Accordingly, we have served a copy. And my lord, I believe.
Very well. Yes, Mr. Doctor. You had finished your submissions.
Yes, more or less, but I finished only. Yes,
give
only
me
to
a-
remind your lordship, Milord, by a stroke of pen, Milord, 97 contractors, Milord, have been blacklisted. No reason why, nothing. My name, Milord, appears at serial number 54 of that list. Milord,
Which is at page?
Milord, the list starts at page 18. The covering letter
At
is at page
22.
18.
At
Yes.
22.
Yes, my name appears at 22, page 22, serial number 54.
And what is the reason given for this?
No reason. Kindly see on the right hand side column, for all the blacklisted contractors, it is the same, blacklisted and debarred from participating in any bid tender for a period of 6 months with effect
Yes,
from the date
show me the communication to Mr. Chatterjee, please.
Okay, sir. Mr. Chatterjee, Milord, he has been handed over with a copy of the writ petition, but I don't think that there's any official communication from our side. Well, on the last occasion, your lordship was pleased to direct Mr. Chatterjee to appear.
Very well. The petitioner is aggrieved. Na, prothom line ta koro. Mr. Nirotpal Chatterjee, comma, who was requested to appear in the matter, who was present in court on the last day and was requested to appear in the matter, comma, is not in court today. Stop. Learned counsel appearing for the petitioner submits that a copy of the writ petition was made over to Mr. Chatterjee on
Last Wednesday, I'm giving the date.
on 5th April 2023. Stop. Next, the impugned order dated 6th May 2022 of the West Bengal State Rural Development Agencies blacklisting, debarring several persons. Are they all individuals or entities? Several persons / entities
Yes.
from participating in bids, in tenders under the said authority, includes the name of the petitioner at item number 54 of the list. Stop. যেখানে several persons বললাম তো সেখানে বলো 97 persons / entities. Stop. Next. The impugned order is ex facie without any reasons, save that the is without any reasons. Stop. Next. Until the matter is heard out, until the state is given an opportunity to present its position, comma, the West Bengal State Rural Agency, being respondent number
1.
1, shall be restrained from giving any effect to the interim order, to the impugned order against the petitioner. Stop. Next. List this matter. On 18th April 2023, stop. Council is requested to communicate this order on the state. Stop.
I'm grateful.
Item number 8.
Would I appear for the petitioner?
I appear for the respondent number.
Mr.
I'm so sorry, ma'am. I appear for respondent number, my lord, 225.
Respondent numbers 2 to 5. Who
Yes,
is that?
yes, yes.
My lord,
Yes. You're for HRBC?
Well, I appear for HRBC.
Yes.
my lord, this is a case of, my lord, non-release of the admitted amount of the work undertaken by me. My lord,
By who?
my lord, by the petitioner, my lord, the work was
No, non-release by who?
by HRBC.
Yes.
The first document, my lord, at page 50. But admittedly, my work executed, the amount is payable. It appears, my lord, the only ground is that there is insufficiency of funds. Paragraph 50, page 50, the second paragraph. Total value of the executed work was to the tune of rupees 46 crores, including service tax. They have submitted first, second, and third and final bills after completion of the work. Interim payment was made to the agency to the tune of rupees 23 crores. till
No,
December.
and this letter is being written by HRBC to who?
But this is a certificate given by the HRBC.
Yes.
23 crores have been paid to me till December 16. Further balance amount of 23 crores is being awaited
16 December.
Yes. But the
When-
letter, the certificate is dated 1st of August 2018,
No, till December
2016.
2016.
Right.
Yes,
23 crores and odd, is further due and payable. Now, this was, the situation in 2018. Now, please turn the page, page number 51.
yes.
Please take the fourth line. The date of start of the work was 5/10/2016 and the work was completed in all respect on 15/11/2016 without imposition of any liquidated damages. The total value of the completed work is 46 crores. Now, please take the penultimate paragraph at that page. The work was undertaken on war footing and the performance of the agency was satisfactory. But these are all certificates in my favor, which are all issued by the HRBC.
Yes.
Now, thereafter, some payments have been made, which your lordship would find at page 53. The position as on 31st of May 2022 is, please take the second paragraph, admissible claim up to third RA and final bill is 46 crores. Payment till date is 32 crores. Facts and figures as per office record and subject to further scrutiny. Then, I write to them to, release my payments. They have
So
followed.
what is it, about 14 crores pending?
Yes, today, 15 crores, 23 lakhs and odd is pending. This, my lord, will find at page 60 and 61. These are the two last documents that I wish to rely. Page 60 is 24th of February of this year.
Yes.
With reference to your letter mentioned above, this is to let you know that sincere efforts have been taken since long from HRBC by making constant persuasion at appropriate levels to obtain fund for the work of dismantling and removal of concrete floors, walls, etc. of factory sheds at Shingur. But due to non-availability of fund till date, HRBC is not in a position to make payment to settle the outstanding dues of your client, Adhunik, etc. And the last document, is at page 61. But today the position is 14 crore 23 lakhs 39,362 towards the principal is outstanding. Number, the only ground, as I could understand, subject to what my learned friend submits,
Yes.
is lack of funds,
Yes.
which, your lordships have held, that the state cannot come up and say that I don't have funds, therefore I'm not going to pay. But this is my case, not only one judgment, if your lordship so desires, 95/5 SCC 730.
That's which one? Gunwant Kaur? No. On what point?
On the ground that state cannot come up and say that I don't have funds. Because otherwise, this is.
I thought you were going to cite judgments that in a writ petition, a payment of money can be made.
Yes.
On that, the last judgment is 2023, volume 2, SCC 703.
There is Justice Nariman also.
Yes.
That is Joshi Technologies, your lordship.
Yes. Joshi is 2006 for that.
2021.
2015.
2015. Yes. Yes.
It's all started with
Started
ABL
with
Corporation.
ABL, but ABL may the lordship will recollect only consequential relief.
Right, right. My learned friend is absolutely right.
But this is all about the money claim per se.
Mr. Mojumdar, 1 minute. Let me just see the decision. I will come to you.
Yes, certainly.
Yes.
95/5. 95, volume 5, Supreme Court cases 730, my lord. This is on the issue of paucity of fund. But please have a look at para 13, 1-3.
$95.5.
चाहिए तो judgment चाहिए.
Yes.
The facts stated above amply, the facts stated above amply bring out the fact that recognized private law colleges alone were singled out for hostile discrimination. The recommendations of the committee to apply new formula for grant, etc. Let me skip over those. Then my lord, about 6 lines, the burden of proof cast on the state that discrimination against recognized private colleges is based on reasonable classification. The High Court had held so, placing reliance upon such and such. We hold that yes, para 13, the last 5 lines. The High Court referred to the plea of paucity of funds pleaded by the state and then held that paucity of funds can be no reason for discriminating, placing reliance on the decision of this court in municipal council so and so. The reasoning of the High Court is also fully justified and no exception can be taken to the proposition as well. We hold so. Similarly, the High Court's conclusion that paucity of fund is no ground to deny payment, but is being upheld by the Honorable Supreme Court.
Yes.
Now, my lord, on the issue of whether, my lord, payments can be directed in a writ jurisdiction, my lord, please take, my lord, the MP Power 2023, Volume 2.
86.2.
Yes.
ওটাই এমপি পাওয়ারটা দেখাচ্ছে
চাই
হ্যাঁ
82 দেখাবো আগে
জাজমেন্ট এনে না কিছু
82.6.
Yes, 82.6. Kindly have a look to 82.5 as well, ma'am.
Yes.
This is what, my lord, is different from ABL.
Yes.
My learned friend is right in saying that ABL was consequential relief. 82.5, my lord, in my very humble submission, is somewhat different. After the contract is entered into, there may be a variety of circumstances which may provide a cause of action to a party to the contract with the state to seek relief by filing a writ petition. Then, without intending to be exhaustive, it may include the relief seeking payment of amount due to the aggrieved party from the state. The state can indeed be called upon to honor its obligation of making payment unless it be that there is a serious
The caveat was it has to be a genuine dispute.
in my case, it's an admitted amount, and my lord, the only ground as I could make out, my lord, from the documents is that lack of funds. Work completed, they say that I have carried it out, my lord, on war footing basis, etc. But I don't want to, my lord, multiply decision. But there is one decision of my lord in Ajoy Kumar Mondol.
No, don't have to show my judgment.
Well,
Yes, Mr. Mojumdar,
may I just reply? First of all, my lord, if your lordship
microphone, please.
I'm sorry, my lord. If lordship kindly takes the writ petition for once,
Yes.
it is not only about the money claim of 14 crores, they are claiming interest of 20 crores. My lord, that is, my lord, if your lordship kindly takes the writ petition.
Show me the prayer for that.
Yes, my lord. Yes, my lord. Kindly take first page 54. They are claiming an interest to the tune of rupees 20 crores, in excess of 20 crores, by applying the rate of 18%. And there,
Mr. Mojumdar, what is the arrangement that you will receive money from the state?
yes, my lord, and that is why at page,
Mr. Dotto, then the time to pay interest doesn't run.
yes.
That liability at all will fall
In fact,
on
my
the
lord,
state.
in fact, my
Yes.
lord, at page 57, your lordship will find that a representation has been made to the chief secretary.
Who has made it? The petitioner?
Yes, the petitioner.
And how do I know that the money is supposed to, is
My
going to
lord,
be
this
sourced
is
from there?
this is, my lord, this is basically dismantling and removal of concrete walls, etc. of factory shed number 1 at Singur, where, my lord, HRBC was appointed by the state government as the principal contractor. And they are basically the subcontractor, subject to Mr. Dotto, obviously.
Mr. Dotto, take the principal sum.
But for the present, I'll take the principal
Yes,
sum,
ma'am.
but my lord,
Take something because otherwise you will not get anything at all.
I will be happy for the time being with the principal amount.
Yes.
But my lord, the ground which is taken by my learned friend, that must appear from the contract itself, that this is a back-to-back payment condition. If it
Yes.
doesn't appear from the contract,
But the contract is
if
also not
if
annexed.
there is a condition in the contract to that effect,
That is
then
why,
of course,
Mr. Mojumdar, I asked you to show me
Malad,
that what is the arrangement.
Malad, I will, Malad, the contract is not annexed. Malad, if your lordship kindly post this matter 3 or 4 days later, Malad, I will come back with full instruction how the payment was to be made.
but my client says that he'll be happy with the principal.
The principal.
Malad, kindly then give us 8 weeks time, we will make payment, Malad, 8 weeks time. But they have waited so long.
You have not made payment for 5 years.
5 years.
8 weeks you will make the payment.
Malad, 8 to 12 weeks will be, Malad, 12 weeks will be good. I think, Malad, Mr. Doctor would not object to it.
It's darling with interest.
No. 12 weeks, Malad, for 4 weeks, what interest will be charged? 12 weeks, Malad, lordship will kind.
The documents.
Maybe a bit less, Milord. Subject to what your lordship feels would
Again,
be
my
proper.
lord, your lordship's list will be burdened by another contempt application, which I don't want.
Very well, 8 weeks, Milord, as
12. Let us do 12. Subject to your lordship's kind consideration.
The documents placed by learned counsel appearing for the parties before this court show that the amount due to the petitioner for work done in dismantling and removal of concrete floor, walls, and so on of a factory shed at Singur, S-I-N-G-U-R, Singur, is an admitted amount. Stop. The admissible claim, the respondent HRBC has recorded the admissible claim of the petitioner to be rupees 46,65,80,067, of which rupees 32,42,40,705 has been paid till date. Stop. Page 53 থেকে page away. This is by way of a letter dated 31st May 2022. Stop. HRBC issued further letters in 2022, the last of which is of in 2022/2023, the last of which is of 24th February 2023, which clearly states that HRBC is unable to make the payment to the petitioner as a result of non-availability of funds. Stop. The arrangement appears to be that the state government, more specifically, that the state government will release funds to HRBC, who in turn will pay to the petitioner number 1. Stop. This would also be corroborated by a letter written by the petitioner number 1 to the Chief Secretary, Government of West Bengal on 22nd December 2022. Stop. Next, whatever the case may be, certificate of 27th February 2023 admits that the petitioners are due to get payment of rupees 14,23,39,362 for the work which was satisfactorily done, and declared so by certificates issued by HRBC in August and in August 2018 and November 2019. Stop. Next, the petitioner, a learned counsel appearing for the petitioners, submits on instructions that the petitioner petitioners are willing to forego GO, একটা কথা হবে, forego the claim of interest. Stop. Next, WPA 6248 of 2023. Should I record that, or do you not want the court to record that? Willing to forego the claim of interest?
But kindly do not record that
Very well.
for the time being.
Very well. For the time being, for the time being, করে দাও. Next, WPA 6248 of 2023. I can't. Yes,
Well, only one thing, Malad, if the submission is not recorded, well, once we pay the,
I have recorded it. I have said at this, for the time being, I've recorded that.
well, that will mean that if they get the principal amount, they may again file a petition or make a claim for this interest amount. Malad, kindly, Malad, this may be settled for once and for all. That is my respectful submission before your lordship. Subject to whatever.
Mr. Mojumdar, I cannot force the petitioner to settle for this. It is, I have said on instructions. I have not said that this is my view. I have said on instructions.
Very well, Malad.
May that not be recorded, my lord. I do not know, my lord, if the client later on wants interest. Because this is an admitted
Malad,
amount.
then my lord, kindly allow us to take instruction, because my lord, if that be so, my lord, if they press for that interest claim.
Mr. Mojumdar, I have already said for the time being.
Very well.
All right.
Very.
WPA 6248 of 2023 is disposed of with a direction on the respondent HRBC. Who will the direction be on?
But it should
Have you
be
made the state a party?
State is a party. State is the first respondent.
Yes, with a direction on the respondent number 1. To release the admitted amount, comma, being the principal sum, comma, of rupees 14,23,39,362 / hyphen to the petitioner number 1 within a period of 12 weeks from date. Stop. Should I route it through you?
Yes, my lord, it has to be, my lord.
Yes. কি বললাম? To release a sum of rupees যেটা বললাম to HRBC
Grateful, my lord.
within a period of 12 weeks from date. Stop. HRBC shall disburse this amount to the petitioner within.
Well, within 4 weeks thereafter.
No. What is this?
You
You are provoking the Mr. Dotto and also the court.
No, immediately upon receipt of the money. Immediately upon receipt.
Yes, the HRBC shall disburse this amount to the petitioners immediately upon receiving the amount, which shall not be later than 7 days
Grateful.
from the date of receipt of the amount by HRBC from the respondent number 1. Stop.
I'm grateful.
Grateful, my lord. Only that, my lord, I'm sniffing a second round.
Very well.
Item number 9.
My lord, I appear for the petitioner that by my lord's order of 28th March, lordship had directed my clients to file undertakings. My lord, this writ petition was challenging the lookout circulars. My lord, I have served the bank. My lord, these are the 3 undertakings. The 3 separate affidavits by all the 3 petitioners. Only petitioner number 1 is traveling twice, once in April and once in May. The other 2 petitioners are only traveling in May. So, my lord, accordingly, my lord, all the tickets and the undertaking. But if lordship takes
Have
the.
you give the?
We have served them.
Have you
We have
served them?
The petitioner number 1, lordship will find, my lord, paragraph 2, 17th April and returning on 22nd April. And then again on 19th May and returning on 24th May. And the other,
And these three are, how are they related? This is wife of, how are these three related?
my lord, petitioner number 1 and petitioner number 2 are brothers.
Yes.
And petitioner number 3 is the sister-in-law of petitioner number 1.
No, wife of Rajiv Kabra. Rajiv Kabra is not before the court.
Rajiv Kabra is not before the court. That's the wife of the other brother.
Yes.
That's why, my lord, sister-in-law, and my lord, these two are brothers. My lord, they are all involved because these three are the family members, my lord, who were directors against whom, my lord.
So petition number 3 was also director. And these three were what kind of whole-time directors?
My lord, 2 were whole time. My lord, petitioner number 3, I am not sure, but definitely in the board, and my lord,
Also stood as guarantors.
Guarantors.
No, because if also guarantors.
Guarantors.
Because if it's independent, then there's an order protecting it.
no, not independent directors, my lord. Then it would have been on a different footing, but not independent directors.
Yes, Mr. Singh, what do you have to say?
Lordship, pursuant to your Lordship direction, Lordship has directed them to file an affidavit to travel. Our
Declaration,
contention was
undertaking.
something otherwise, your Lordship, we want to, because they are asking for crossing the LOC, we are returning the
And they can file their affidavits when a lordship have reserved the right of them filing their
Yes,
affidavits only.
petition number 1, show me the return dates, please.
Yes, my lord, petitioner number 1, lordship will kindly see, my lord, para 2 and 3.
No, the document.
Oh, I am sorry, page 8, my lord.
Yes.
Page 8, lordship will find at the top, my lord, left-hand side, 17th April. And this is, my lord, departure from Calcutta Airport. And 22nd April is, my lord, the corresponding return flight from Bangkok to. And, my lord, page 9 is the second trip, my lord. 19th May is the departure and 24th May is the return.
What is class V, Mr. Chaudhary?
V.
Says 30,000, but what is V?
I have, it must be, my lord, relating
And
to
what is TG anyway? What is TG?
Thai Airways. Thai Airways. That's the code of Thai Airways. This class, my lord, now they have, it's on the fare structure, I believe. My lord, from the net, my junior checked it, my lord. Class V is Royal Orchid Plus members. That's some sort of a frequent flyer program.
Yes. Number 2.
Number 2 is only for May, my lord. Lordship will kindly come to paragraph.
Page 7.
Page 7 is the ticket, your lordship.
Yes.
Only for May 19th and 26th.
Which paragraph have you said that you're going to come back?
My lord, page 2,
Yes.
para 2.
Very well. 3.
3, your lordship, the ticket is at page 7. 19th May is the departure and 24th May is the return. And similarly, in paragraph 2 of the affidavit, I have stated that. And para 3, I
And
have
all 3 of them are going for 3 different reasons.
all same reason.
Same
Family
reason.
marriage, my lord. Only petitioner number 1 is traveling twice, once in April to oversee the
All are
arrangements.
17th to 22nd April. Just check the dates, please.
My lord, petitioner number 1 is traveling only on April. That is, my lord, on April, my lord. Petitioner number 1 is traveling once on 7th.
No, petition number 2 is 19th May and 26th May.
Yes.
So can't be for the wedding.
19 to 26, petitioner number 1 is only returning 2 days earlier, my lord. Petitioner 2 and 3 are overstaying for 2 more days after, my lord.
How can it be 2 more days? 17th April to 22nd, and that is 19th May and 26th May.
No, the petitioner number 1 is traveling in April.
Yes.
To oversee the arrangements. The marriage, he's coming back in April. The marriage is in May. All the 3 petitioners are traveling on May. 19th May, all the 3 petitioners are traveling again. And petition numbers 2 and 3, my lord, petitioner 1 is returning on 24th. And 2 and 3 are returning on 26th, my lord. They are staying 2 days extra, my lord, to wind up the affairs.
One and three returning on 24th, who is returning on 26th?
Marriage of
Petitioner number 1.
Daughter of petitioner number 1.
in Bangkok.
Only one submission I would like to submit, your lordship, before your lordship. The petitioner has been declared as a willful default. The petitioner has been declared as a willful defaulter. And they are saying that they have no means to pay. And they are making an arrangement for marriage daughter in Thailand.
Lord, willful defaulter, the writ
That
petition
is
I
a
had mentioned.
procedure separate issue. Like, can you see the conduct? He is holding the public money, arranging money or daughters in Thailand, not paying the dues of the public money.
I don't think that's the correct perspective, my lord. I shall show them,
Very
my lord,
well,
how
yes.
willful defaulter has been
My lord,
declared.
I am appealing for the Union of India, my lord. My petitioner, in their submission is they are going to attend the marriage of their for marriage, but they have not annexed the marriage card.
In the writ petition itself, it has been disclosed. I learned it.
Writ petition, which page?
Lord, page 64. When the petition was filed, my lord, the first, my lord, intimation which was there at the time, my lord, it is there. And the petition, the averment is there on oath. We had one round of hearing on that.
Page 64.
Mr. Chaudhary, you please, because this says 20th and 21st May.
Yes.
Yes, the dates which are,
19th May we are going, the May trip is on 19th. All three are going on 19th.
yes,
and petitioner-
produce, I'm keeping the matter tomorrow. Produce the wedding card, please.
Very well.
The invitation card, all right? Or I can keep it at 2. Just
Lord,
produce it.
kindly keep it. My advocate on record is not there today. Kindly keep it day after tomorrow. I shall produce it.
Very well, but then that takes you closer to 7. If I have any doubt, I will not allow you. That is
No,
why.
my lord, there is no doubt. I
Yes.
shall satisfy. Lordship's conscience has to be
Yes.
satisfied.
Yes.
My lord, I am led by Mr. Bhattacharya, learned DSG.
The 3 petitioners have filed their respective undertakings undertakings in the form of affidavits enclosing flight tickets indicating their individual dates of travel. Stop. The petitioner number 1 intends to travel twice, once in April and the second time in May. Stop. The travel dates of the petitioner numbers 2 and 3 coincide with the second travel date of the first petitioner. Stop. Next, an objection has been raised on behalf of the respondent bank as well as the Union of India that the petitioners have not enclosed the what is it called? The invitation card for the wedding. Stop. The document annexed to the writ petition is within quotation marks, save the date and not the actual invitation card. Stop. Next, list this matter on 12th April 2023 for learned counsel appearing for the petitioners to produce the card. Stop.
I'm glad.
Next.
Item number 10.
I represent the writ petition in this matter.
Yes.
Should I appear for the key?
Lord, your lordship had the occasion to hear this matter. And Lord, we have filed our short notes also.
Which is this matter, Mr.
Lord, this relates to, Lord, maintenance of 2 underpasses.
Oh, yes.
Lord, this is relating to Beliaghata and Shobhum.
Yes, yes, I remember.
Lord, the contract was, a concluded contract was entered.
Mr. for? Give me your notes.
Yes,
And
it
then
is-
I can locate it from the note.
Yes, it is there. It is there. May I just indicate, Lord,
Yes, you had given the notes before, right?
yes, Lord,
yes.
because your lordship heard the matter, your lordship, Lord,
Yes, yes. And
us to submit the note.
respondent note to the.
Your Lord, only thing, there are little mistakes, Lord, typographical errors. If your lordship, Lord, kindly take page 1 of the note. The first judgment, Lord, page is to be corrected, Lord, as 595.
Yes.
As your lordship,
Yes.
Lord, I think I mentioned this.
Yes, yes.
If your lordship comes to the last page, page 4, Lord, the judgments, Lord, is 2021-19 SCC, Lord, 706. Lord, the paragraph is 23, it should be. 26, it should be, sorry. 26 or
No, the note says paragraph 26.
Yeah, it should be 23.
23.
Yes. And Lord, there is one other correction, Lord, paragraph L, Lord, last 3 line, the lordships will find the paragraph 149 to 153.
Yes.
Your lordship, instead of 149 to 153, your lordship, that is already mentioned at the top. This should be 159 to 165. Lord,
Yes, at both places. There are 2 places mentioned.
No. There are various paragraphs. Lord, on the issues, Lord, I have mentioned, your lordships.
No, 149 to 153 is
Remains.
mentioned in 2 places.
2 places. That the second one,
Yes.
kindly, Lord, correct it as 159 to
Very.
160. The last one. First, may I just, Lord, indicate the points, Lord, if your lordships, Lord, takes the first point, Lord, but the issue is, Lord, after a concluded contract is entered into, the tender is cancelled. Termination letter says the tender is cancelled. So, Lord, I say that, Lord, once the concluded contract is entered into, the tender, Lord, whatever terms and conditions of the tenders are, that gets merged, Lord, in a concluded contract.
Yes.
And I say that termination of tender does not, Lord, terminate the contract. And Lord, your lordships will kindly see page 192 of the petition, writ petition.
Yes.
This is the termination letter.
Yes.
It says cited tender is hereby cancelled by the authority in KMDA. We would state with regret that the tender has been found having technical fault, non-specific, not well defined, thus creating ambiguity for obvious reasons. By this, the authority is incurring financial loss. So, Lord, basically, Lord, there are 4 or 5 grounds taken. One is technical fault, non-specific, not well defined, ambiguous, and incurring financial loss. Lord, my contention is that, Lord, the contract clearly says, Lord, what are the grounds on which the termination can be affected. And Lord, these your lordships will get at page 72, clause 35. I think, Lord, I had indicated this on the last occasion. I think your lordship
Clause 35 II.
Yes, Lord. Your lordships
Yes.
will find that in the whole of clause 35, it proceeds, Lord, on the basis that, Lord, there has to be a breach of contract. And after the breach is committed, the time has to be given for the purpose of, Lord, remedying the breach. And then, Lord, the termination would come. The stages are fixed in the contract. This is not the ground on which, Lord, there is no breach alleged in termination. Even if it is assumed that, Lord, they are actually terminating the contract, not the tender, even then I say that it is not in terms of the contract. That is, Lord, my second point in the notes. And Lord, I also take the point that, Lord, in so far as non-statutory contract is concerned, Lord, if there is arbitrariness, if there is, Lord, a violation of principles of natural justice, Lord, then the writ petition is maintainable. And Lord, public law element, I had indicated, Lord, the paragraphs on the last occasion, is now, Lord, that MP power case, Lord, has been dealt with. That public law element means if there is a violation of my rights, fundamental right, then, Lord, I can always, there is a violation of Article 14.
Did Mr. Dotto raise a point of maintainability of the
Yes,
petition?
yes. In his notes,
Very
because we exchanged the notes,
Yes.
that's the reason, Lord, I have cited it, and my lord, that's my point. These are, my lord, my basic contentions. My lord, give me a chance to give a short reply after Mr. Datta is concluded.
Yes, Mr. Datta.
My lord, the ground, my lord, as your lordship has found,
Yes.
is that, my lord, the respondent, that is the KMDA, was inarticulate, my lord, in framing the terms of the tender. That is the reason. And, my lord, how, my lord, the advantage has been taken, my lord, I'll demonstrate, my lord, from the documents itself. Now, first, kindly take, my lord, page number 35, the corrigendum.
Yes.
What is the name of the work? Regular maintenance of Bilayaghata underpass, including upkeeping of the underpass proper, garden area at grade underpass area, and all electromechanical fittings against license fee of advertisement rights over 10 years.
Yes.
The next one is same in place of Bilayaghata, it is HON'BLE underpass. So, this is on license basis given to, at that stage, sought to be given to Millard without any interest created in respect of the property concerned. So, this is a grant of license, Millard, without creating any interest in the property. This is the apparent from Millard, the name of the work. Now, kindly take, Millard, page number 121.
Yes.
Clause, special terms and condition, clause number 1. Bidders will be allowed to install total 250 square meter inside and outside the area for commercial advertisement in the form of LED frontlet board, etc. 2. The underpass signboards at the approved locations are to be maintained properly as per direction of the KMD at the cost of the licensee for a period of 10 years from the date of commercial operation date in
Licensee in this case is the petitioner.
petitioner.
Yes. Yes.
Then, Millard, kindly takes paragraph number 5. The license may be cancelled by KMDA for any proven breach of contract, and the licensee shall neither be entitled to any compensation for any damage caused due to such cancellation, nor shall they be absolved of any liability incurred under this agreement, and executed structure will be the property of KMDA. All the underpass structures are the properties of KMDA, and the licensee will no longer have the right to use and sell the space for sponsorship purpose after a period of 10 years. Now, please turn the page. Clause number 10. There should not be any image, picture in the advertisement space which may distract the attention of the drivers and cause accident. But this is a clause which is relied by my learned friend's client. But here, Millard, what actually has happened is, Millard, they have not put up any advertisement boards inside the underpass. What they have done is, where they have, Millard, set up the advertisement boards, Millard, outside the underpass.
No, in the advertising space,
Yes.
that's the clause. Advertising space, according to you, is only the underpass.
Yes.
Not anything above that.
Now, why we said that it was inarticulate, this gives, Millard, a clause to the petitioner to come up and say that no, there was no condition that I have to put the advertisement boards in the underpass. It is outside as well. This is the clause relied upon by them.
So you're saying advertising space is vague. It should have mentioned, specified the location.
To my understanding, it is quite clear, but there are some inconsistencies here and there. One of which is this clause, which the advantage of which is being taken by the petitioner, saying that when it says drivers and may cause accident, it cannot be within the underpass. So it necessarily means, according to the interpretation of the petitioner, that it should be outside. Therefore, they are entitled to put up the advertisement boards outside the underpass and not inside. This is the clause which they seek to rely. But the other clauses are also to be taken note of.
Yes.
Those, Millard, which I have already placed. Clause number 1, clause number 2, then clause number 6, then kindly take, Millard,
yes.
clause number 11.
Yes.
The advertisement signboard attached to the underpass structures will be in retro-reflective materials. This is 11, then kindly take 14. The licensee shall not acquire any right or title to the land on which the underpass signboards are installed or any portion of the road, land, fencing, etc. This is 14. Please
Yes.
turn the page. 22. Necessary permission should be obtained from KMDA or other competent authority before displaying the advertisement. But the other two clauses your lordship would find, Millard, from page 152. Now, these clauses, Millard, taken together in my very respectful submission, do not leave any manner of doubt that, Millard, the advertisement boards are to be installed within the underpass. Please take, Millard, this is 18th of October at page 52. This is the work order.
Yes.
Please take clause number 5. The underpass signboard at the approved location is to be maintained properly as per direction of KMDA at the cost of licensee for a period of 10 years, etc. Then please take, Millard, page 153, clause number 9.
No, clause number 5 is at page 53.
152.
152.
Yes, ma'am. This is the work order.
Yes. Yes.
Clause number 5, Millard, once more. The underpass signboard at the approved location is to be maintained properly as per direction of KMD at the cost of the licensee for a period of 10 years, etc. Now, please turn the page number 153, clause number 9 of the work order.
Yes.
As there are two sites for such underpasses to be maintained, the area of display to be provided to the agency is 250 square meter each. That is approximately 2,700 square feet for each location. But there is an absolute problem of accommodating 250 square meter in Shobhumi underpass area, and hence it has been decided to compensate the same around Beliaghata underpass area and others to resolve the issue. As for both the cases, fortunately, you have got both the maintenance contract, and there we will not be required to look separately for two different tenders, and total permitted area of display will remain 500 square meter for the two different tenders. Location for 6 numbers of, rest is not important for me. Now, these are the clauses, which all read together, can only lead to the conclusion that it was for only the underpass signboard display that has been conferred upon the petitioner. But, the petitioner takes refuge to clause number 10 at page 122 and says that, no, we are entitled to put it beyond the underpass.
That is that
drivers, so that drivers are not, distracted and no accident take place.
Yes.
Now kindly take, the impugned order. Which is, the last page number 192.
179.
192, last page.
192. Why have I flagged 179? Yes, that is a stop work.
Stop work, yes.
That
Yes.
is now merged into the
Yes.
final.
Very well. Yes.
But here, we have said the cited tender is hereby cancelled by KMDA. We would state with regret that the tender has been found having technical fault, non-specific and not well defined, thus creating ambiguity for obvious reasons. By this, the authority is incurring financial loss as well. We regret for the inconvenience caused to you and are ready to reimburse the cost you have so far incurred in the work. This has been decided that the license be deposited by you and the cost incurred for construction activity and maintenance work would be refunded as per the actual assessment by the divisional engineers based on the approved drawing and execution. This is for your information, etc. So, we have been, two things. First is, we say that we are inarticulate in the tender conditions. And second is, we have decided to refund the license fee as well as compensate them for the cost that they have incurred. Now, my lord, therefore, my lord, this is a case where I raise all these points, my lord. Number one, my lord, this is a non-statutory contract, my lord. Therefore, my lord, it is by its very nature not enforceable. And my lord, it is a contract pure and simple, and my lord, there is no public law element involved in it. Number three is, my lord, this is a pure license granted without any interest, not coupled with any interest.
Why do you say there's no public element, public law element, Mr. Datta?
Milord, the public element, Milord, in the sense, Milord, that here, Milord, two underpasses were constructed by us. This is not a construction contract which has been awarded to my learned friends. In an underpass already constructed, it is only given to them in exchange of license fee, Milord, to display advertisement. So it is pure and simple, Milord, a contractual contract. It has got no public law element into it. For example, when is it called up a contract having public element? When the public is interested in it. For example, infrastructure project.
MP power helps you or it's against you?
Milord, to an extent, Milord, I'll tell you what, to be honest, MP power, Milord, is possibly the only decision, Milord, which detracts, Milord, from all the previous line of decisions, which says that a non-statutory contract can also be looked into by the court and rights may be enforced provided there is arbitrariness. Now, what is arbitrariness? If, I think that in paragraph 75, Milord, the Honorable Supreme Court has collated the instances where, Milord, an action may be branded as arbitrary. But this is not, Milord, one which fall within that category. But today, Milord, with respect, Milord, the Supreme Court has departed from all the other previous judgments that in a non-statutory contract also the court has to go into it, but it can go into it. But the caveat is arbitrariness.
Yes.
Therefore, Milord,
and MP power has departed from that.
MP power has departed from the previous line of decisions to some extent.
You can read it out. MP power,
yes.
In the other decision you have given
Yes,
it.
yes.
Yes.
I have also handed up.
Yes. Well, if your lordship may kindly take, to my recollection, it is possibly para 75 or 77. 77. Achhe.
Yes, 75.
Yes. Yes. We would therefore sum up as to when an act is to be treated as arbitrary. The court must carefully attend to the facts and the circumstances of the case. It should find out whether the impugned decision is based on any principle. If not, it may unerringly point to arbitrariness. If the act betrays caprice or the mere exhibition of whim of the authority, it would sufficiently bear the insignia of arbitrariness. But pausing here for a moment, Milord, the Supreme Court puts it to whether, Milord, there is any whim exhibited by the authorities.
Yes.
In this regard, supporting an order with a rationale which in the circumstances is found to be reasonable will go a long way to repel a challenge to state action. Again, Milord, pausing here for a moment, what I say, Milord, I say that I was inarticulate. And therefore, you have taken advantage of that. You have not set up any advertisement boards in the underpass. You have gone beyond, taking note of only one clause, which appears to be contrary to all our other attending clauses, which I have placed for my lord. In that circumstances, the Supreme Court says that it will go a long way to repel a challenge to the state action. So if your lordship finds, Milord, there is some rationale in the decision, Milord, it can repel a challenge to a state action. Then, Milord, the next sentence. No doubt reasons need not in every case be part of the order as such. If there is absence of good faith and the action is actuated with an oblique motive, it could be characterized as being arbitrary. A total non-application of mind without due regard to the rights of the parties and public interest may be a clear indicator of arbitrary action. A wholly unreasonable decision, which is little different from a perverse decision under the Wednesbury doctrine, would qualify as an arbitrary decision under Article 14. Ordinarily, visiting a party with the consequences of its breach under a contract may not be an arbitrary decision. So it all points out that the court should find out whether it is absolutely whimsical or not. If there is some rationale, the court will repel a challenge to a state action. Then, my lord, if your lordship may kindly take note, then Joshi and etc. are considered. And please take page 8, paragraph 81, which I say, my lord, the Supreme Court is going somewhat different from the earlier judgments.
Mr. Dotto, would you like a glass of water?
No, my lord, I have developed some problem in my throat. I suffered from fever last week.
No, if you want, you can come back tomorrow or day after.
It goes on throughout the day, and I do not know, my lord, whether I've got infected by COVID in the meantime or not. Because now the doctors, what they are saying about.
So you want Mr. Kaur and Mr. Kundalia to also disappear from the court now?
Yes. No, it has happened. Yeah, this is the after effect, I feel.
I missed Mr. Sen. He's closer to you. Whether in ideology or otherwise, I don't know, but at least in terms of distance. Yes.
No, but Mr. Kaur says that he was already infected.
Yes.
No, I said that I had the same viral and this persists for a while.
Where 81 where I was placing, we have already concluded that PPA is not a statutory contract. However, that would not be the end of the inquiry. Dr. A.M. Singhvi, learned senior counsel, will point out that the contract, being a statutory contract, assumes relevance only for the purpose of deciding as to whether the court should relegate the writ applicant to alternate remedies. In other words, while the court would retain its discretion to entertain the petition or decline to do so, in the facts of each case, there is no absolute taboo against the court granting relief, even if the challenge to the termination of a contract is made in the case of a contract which is not statutory in nature, when the offending party is the state. In other words, the contention is that the law in this field has witnessed an evolution, and what is more, a revolution of sorts, and a transformatory change with a growing realization of the true ambit of Article 14 of the Constitution. The state, he points out, cannot play the Dr. Jekyll and Hyde game anymore. Its nature is cast in stone. Its character is inflexible. This is irrespective of the activity it indulges in. It will continue to be haunted by the mandate of Article 14 to act fairly. There has been a stunning expansion of the frontiers of the court's jurisdiction to strike at the state action in matters arising out of contract, based undoubtedly on the facts of each case. It remains open to the court to refuse to reject a case involving a state action on the basis that the action is per se arbitrary. But this is the only window, my lord, which has been left open, my lord, in this judgment in a case of a non-statutory contract, that the court should find out in the facts of every case, number one, whether it is whimsical or not. Number two, my lord, whether there is some rationale behind it or not. And number three, my lord, which is per se arbitrary. So
Like,
this is
like paragraph 82.6 says
Yes.
that payment can be made provided it's
can
a
also
genuine dispute.
Yes.
Yes.
My lord, paragraph 82, my lord, your lordship has found, my lord, which lays down the various situations. Now, in regard to termination, please take 82.11.
Yes.
Termination of contract can arise in a variety of situations. If, for instance, a contract is terminated by a person who is demonstrated without any need for any argument to be the person who is completely unauthorized to cancel the contract, there may not be any necessity to drive that party to unnecessary ordeal of a prolix and avoidable round of litigation. The intervention by the court in such a case where there is no dispute to be resolved would also be conducive to public interest apart from ensuring the fundamental right of the petitioner under Article 14 of the Constitution. When it comes to a challenge to the termination of a contract by the state, which is a non-statutory body, which is acting in purported exercise of powers, rights.
Mr. Dotto, I have read the paragraph.
Yes, yes.
Thank you.
Yes.
So your point is that termination, arbitrariness, everything is fact specific.
Correct.
Depends on the
Correct.
case. It's not that every action of the state can be questioned, or at least MP power cannot be used
Yes.
across the board.
Yes.
Anything else, Mr. Dotto?
Milord, this is Milord on Milord the challenge that this is a non-statutory contract.
Yes.
Milord, the other points Milord which I have taken, Milord, these are all Milord in my short notes. Kindly have a look to this Milord. We have given the citations also.
Yes, Mr. Dotto, it's public interest and all of that,
Yes.
policy decision.
That these are Milord in the first paragraph, I mean first page. Then if your Lordship may kindly take the second page towards the middle of that page.
Yes.
That Milord obligations flowing from a contract is not always binding and enforceable. For that Milord, we have relied upon this Bihar Eastern Gangetic Fishermen Cooperative Society.
Yes.
77-4. Then Milord, duty arising out of a contract cannot be enforced. 1966 Supreme Court, page 334. Then on that public law element missing, Milord, the last judgment is Milord BCCL versus AMR Dev Prabha, 2020, volume 60.
Very well. And have you distinguished their judgments, Mr. Dotto?
Milord, no, Milord, we have not distinguished their judgments, Milord. Kindly permit me to place Milord one page note, Milord, on the for distinguishing.
Mr. Kaur, you have done that.
I have Milord, only Milord, I can. But Milord, most of the judgments that Mr. Dotto has cited has been taken note of in MP power. I
Very
can
well.
also Milord cite, I give a one-page note, Milord, saying which are the judgments which have been noted, and one of them has been distinguished in MP power. The judgment that Mr. Dotto is relying upon.
Very well.
Milord,
Very well.
only thing is, factually, Milord, may I just point out one
Yes.
thing? Mr. Dotto's argument largely depends on Milord, the fact that Milord, I have put on advertisement outside, which is outside the scope of the contract.
Yes.
Milord, please take page 159. Kindly, Milord, come to page 159.
Yes.
Yes. Approved. Lord, each advertisement, there are 7 Lord sites. Each advertisement is approved by the respondent. Your Lordships will find on the right-hand side,
Yes.
you'll that it is approved
I
by
see
the
that. Yes.
both executive engineer and superintending engineer.
Yes.
Therefore, Lord, I have never Lord
So what is being approved? The location?
the location.
Because these are blank placard, the boards.
The boards, Lord, are approved.
Very
Then,
good.
Lord, what the contract says that I have to, Lord, maintain the underpasses at my cost.
Yes.
I'll also have to pay a license fee to KMDA. And Lord, I recover both the license fee and Lord, the maintenance cost out of these advertisements. There are 7 spots which are given to me. And these hoardings are not all approved by the respondent. Your Lordships will find from 159 to 165. These are the 7 hoardings which are approved.
And Mr. Kaur, you're not happy with refund of whatever expenses you have incurred and the
No,
deposit?
Lord, I tell your Lordship that there are 2 issues. One is financial loss. The financial loss issue, if your Lordship kindly takes my note, that has been, Lord, there is a judgment, Lord, which I have kindly, Lord, come to internal page 3.
Yes.
Subparagraph H.
Yes.
This is an issue which is well covered. This is Lord 2022-16 SCC 527. Has
Yes.
your Lordship found that?
Yes.
Paragraph H.
Yes.
Which says that doctrine of fairness is required to be applied, and when a contract is being evaluated, the mere possibility of more money in the public offer does not itself serve public interest. A blanket claim by the state claiming loss of public money cannot be used to forego contractual obligations. So, my lord, basic question is, he says, I faulted myself when I drew up the contract. Lord, the contract was drawn, it is a 30 or 50 pages contract, which has all the clauses. And Lord, it clearly spells out what I have to do. And Lord, how much money I have to spend for the purpose of recovery. So Lord, they were well aware of the commercial aspect of the matter. When I was awarded the contract, the commercial aspect of the matter was completely known to them.
Yes.
And Lord, the other grounds of termination is totally vague. If your lordships, Lord, kindly sees the termination at page 192, your lordships will find these are grounds which are completely vague. He says that I failed in drawing up my contract. After a concluded contract is entered into, can that be a ground for termination? Lord, I ask this question to myself. This is one of the most arbitrary, Lord, action on the part of the state. Apart from the fact of violation of principles of natural justice. And Lord, I have given a case where, Lord, what is, Lord, arbitrary, that is also, Lord, discussed. Your lordships will find that in paragraph F, page 2.
Yes.
That also deals with a judgment which says that what is arbitrary action.
Yes.
When there is a, Lord, agreement which prescribes how a termination is to take effect, Lord, they terminate the contract not in terms of the termination clause. This itself, Lord, is an arbitrary action. When there is a concluded contract, the parties, Lord, they know the terms on which they have to work.
Very well. I will keep this matter. Today we are on 10th. I will keep this matter on 13th for your one-page note and then make it reserved for judgment. Yes, heard learned counsel appearing for the parties. Stop. The respective notes are with the court. Stop. List this matter on 13th April 2023. Stop. Yes, call on the next matter, please.
I'm grateful.
Item number 11.
Item number 11, I am appealing for respondent number 6, the High Court Administration.
Law clerks of Bushirhat.
Yes.
Yes, what do you want?
Matter is, Milord, the additional chief judicial magistrate, Milord, Bushirhat, passed an order on 27th of January 2022, allowing the advocates to stand as sureties in favor of the accused. This is, Milord, not permissible. Milord, your lordship, Milord, just kindly have a look, Milord, page 16 once. The order, Milord, passed by the additional chief judicial magistrate Bushirhat.
Page 16.
Page 16.
Yes.
Now, Milord, may I just place it?
Yes.
Peruse the application.
I can't even read what is written.
Yeah, that's why I'm just placing.
No, why? I don't need to rely on what you're saying. What is, give me where is a legible copy of this?
This is the problem. Okay. Legible copy.
It's completely unreadable.
May I just place it?
But no order today. You can place it if you want. Yes. No order today. No. What is the relief you want?
But this order was passed by the London Additional Chief Justice.
When?
On 27th of January 2022.
Yes.
A similar situation arose, Similar situation arose in the year 2006 also. Similar order was passed by the London Additional Chief Judicial Magistrate Baripur. A writ petition was filed before this Honorable Court.
Saying that advocates can
Yes.
stand in as guarantors.
As sureties.
As securities.
Now,
Yes.
that order was stayed by this Honorable Court. Your lordship, if your lordship kindly takes page 18. When a single judge of this Honorable Court had the occasion to consider the similar thing, And on 20th of July, my lord, 2007, my lord, this order was passed.
Section 35.
Section 35 and my lord, Rule 128 of the my lord, Calcutta High Court.
And the
Criminal sub-
interim order was confirmed later on.
Yes, is still containing, my lord, my lord, page 20, my lord, lordship would find, my lord, the order passed on 28th of
What is the date? You have given such unclear copies. I will dismiss the writ petition with costs.
28th of
Look at page
March.
18. I can't even understand the date of the order.
My lord, page 18, my lord, 20th of July 2007. I mean, next, my lord, page 20. That is on, my lord, 28th of March 2008.
Yes.
Now, my lord, if your lordship will not kindly consider, my lord, these rules once.
What is your case? Section 35 of the Advocates
My
Act.
case is, my lord,
Read with
Rule 128. And kindly text, my lord, Rule 128. That is page 156. Well, a lawyer shall not be allowed to stand as a surety for or certify the soundness of a surety of his own client in any criminal proceedings in a court.
Of his own client.
Of his own client.
And what does the impugned order say?
Impugned order said, my lord, irrespective.
Can't understand. Say.
Irrespective, my lord, he can stand.
So Rule 128 will apply.
Well, it is contrary to Rule 128.
No. The impugned order says of their own sureties, of their own clients.
Yes, including inclusive. Well, that is not specified in the impugned order.
Because I can't read the impugned order.
Well, may I come back tomorrow?
Yes, absolutely. What is the urgency?
Urgency, my lord, the clerks are not in a position, my lord, to stand as surety. Well, lawyers are taken, my lord, everything. And this is, my lord, absolutely, my lord, in contrary to the, my lord, Advocates Act also.
So this is West Bengal Law Clerks Association.
Yes.
Very well. So they have been deprived for what, over 1 year now?
Yes, my lord. 1 year, 3 months. 27th of January 2022. Now we are in April 23.
Yes, Mr. Sen, what do you have to say?
Lord, the principle, Lord, is that when granting bail, Lord, when granting bail, the court usually requires somebody to furnish a security. Now, Lord, the rules which have been shown to your Lordship says any person. The bar is, if the person is an advocate, he cannot be a surety for his own client. There is no other, Lord, subject to, Lord, what my learned friend may say, there is no other impediment in an advocate being a surety.
Yes.
So, Lord, so far as this order is concerned, by which, Lord, the Boshirhat, Lord ACGM, the Additional Chief Judicial Magistrate of Boshirhat is concerned, he has enlisted 83 advocates who, according to him, have sufficient solvency and satisfy the requirements of Rule 128, which specify what are the eligibility criteria. And he says, I enlist these persons who would be entitled to stand as sureties in case the bond is up to a sum of 50,000. Now, this, of course, will have to be read subject to Rule 128, which says that if it concerns the clients of these gentlemen, then in those cases, they cannot stand as sureties. Of course, it will be subject to Rule 128.
So what did Justice Pal say?
Lord, Justice Pal's Lord, order does not really reflect any reasons for, Lord, the grant of an interim order. That interim order, my learned friend says, is still continuing, but the interim order does not otherwise give any reasons except saying that in terms of Rule 128. Rule 128 carves out an exception that in case of one's own client, one cannot be a surety. But that does not contain an omnibus restriction on the advocates being sureties in other cases. Now, there is one other aspect of the matter.
And what about the deprivation or the alleged deprivation on the law clerks?
Lord, this is a statute.
What is the system? The law clerks is to stand as sureties.
Lord, in every court, not any person can stand as surety so long as that person satisfies certain eligibility criteria. That is laid down in the rules.
No.
If your Lordship sees the rules, which has been handed over to your Lordship,
Yes.
kindly see Rule 126. Kindly see Rule 126.
Yes.
These are the, my lord, the parameters, list of properties, documents of ownership, etc. He'll have to give. Then the divisional judicial magistrate makes an inquiry under Rule 127. 126 gives the criteria to be submitted. 127 gives the procedure, the inquiry which must be made with regard to financial soundness and general fitness of the applicant, and thereafter enlist the persons as persons from whom sureties can be given. Nowhere does it, not subject to being corrected by my learned friend, says who can be such a surety. Now, my lord, if your lordship considers this order of enlistment, which is under challenge to be an order in terms of Rule 127, Lord, kindly have a look at 127(4). Any person aggrieved by any order of the subdivisional judicial magistrate under this rule may prefer an appeal to the chief judicial magistrate within 30 days from the date of the order, and the appellate order of the chief judicial magistrate in this regard shall be final.
Yes.
There's a statutory remedy which was provided to my learned friends as clients, the association or the individual members, if they were so aggrieved.
Yes.
Now, my lord, so far as Rule 128 is a restriction, but only in respect of one's own client. That is really obvious, because one cannot be a surety for one's own client.
Yes.
It has to be an independent person having the necessary, my lord, requisite financial soundness and, my lord,
Mr. Sen, please read out page 16, which I can't read. Yes.
16 top says,
Microphone, please. Yes.
Office of the Additional Chief Judicial Magistrate, Boshihat, North 24 Parganas, Order number 3, dated 27 January 2022. Peruse the application documents submitted by the learned advocates of the local criminal bar association, who have submitted their respective enrollment numbers along with their respective application for getting of their bail bond capacity. Considering all and for the interest of litigant public, the bail capacity of the following advocates of rupees 50,000. The order will be effective from 1st February 2022. Look, these 83 persons have been enlisted by the additional chief judicial magistrate as persons from whom bail bonds would be acceptable, so long as they are of 50,000, up to 50,000 as sureties. It has to be subject to, Lord, the rule which says that it cannot be for one's own client.
Yes, it has to be subject to Rule 126.
Yes, Rule 126.
Yes.
Rule 128, I'm sorry, Rule 128.
No, 126 has to be eligible under 126.
Yes. No,
127 procedure, 128 bar.
Yes, Lord, yes.
Yes.
And 127(4) is the appeal provision.
Why have you not gone under 127(4)?
No, my lord, so far as 127(4) is concerned, my lord, we already made a representation before the concerned authorities, as well as, my lord, the learned Registrar General of this Honorable Court.
Why? Registrar General is not the designated authority. 127(4) is
Chief Judicial Magistrate.
Chief Judicial Magistrate.
It was not done to the Chief Judicial Magistrate.
Then why will you not do it to the Chief Judicial Magistrate?
My lord, kindly turn page 24 once.
Yes.
Lord, this letter was addressed to, my lord, additional Chief Judicial Magistrate at Boshirat. The representation was submitted on, my lord, 24th of March 2021.
But that is not the designated authority under 127(4). So go before the designated authority. I am giving you the time.
Kindly consider two things. Well, I will go. We will also. Lord, kindly see, my lord, Advocates Act once. Advocate Act says, my lord,
go to the appellate forum, then come to the court if required.
Similar circumstances, kindly visualize the situation. In similar situation, I kindly see, my lord, which was the subject matter of the order challenged before this one. Page 17 once. Page 17.
I have seen the order.
Page 17, this order was stated.
Page 19 does not give the reason or the particular facts, whether 128 bar will apply or not.
Page 19, my lord, learned judge consider, my lord, 128 as well as section 35 of the Advocates Act. Well, I have.
Yes, but it should. I don't find that exception to 128 being given at page 19. That is not there.
128.
Where does it say that?
Learned judge proceeded on the basis considering the statement made in the writ petition as well as the grounds, particularly the grounds number such and such, and going through the provisions contained in section 35 of the Advocates Act. I will not Advocates Act, there is a bar.
Yes.
In the Advocates Act, if you lordship, kindly consider
go to the appellate authority.
There is a bar. Clear bar.
The petitioner is
My lord, one thing, my lord,
West
30 days
Bengal
time.
Law Clerks Association of the Bosirhat Criminal Court and claim to be aggrieved by an order passed by the Additional Chief Judicial Magistrate, Bosirhat, North 24 Parganas on 27 January 2022. Stop. The impugned order gives a list of 42 advocates practicing advocates of the local Criminal Bar Association.
83, my lord, 83 advocates.
83. This paragraph, this
Two
page
columns.
has only
It's in two columns.
83. Yes, thank you. Yes, 83 advocates of the local Criminal Bar Association who have applied for who have applied for
But enlistment as sureties.
sorry?
Enlistment as sureties.
Yes, who have applied for enlistment as sureties in various matters, in criminal matters. Stop. Next, learned counsel appearing for the petitioner is aggrieved by this order, submits that the petitioner is aggrieved by this order since the order is contrary to Section 35 of the Advocates Act, as well as Rule 128 of the Calcutta High Court Criminal within brackets subordinate courts close bracket rules, 1985, as also the fact that the law clerks of the Petitioners Association have been deprived from acting as sureties in the by reason of the impugned order. Stop. Next. Learned counsel as well as the learned AAAG appearing for the state have placed the relevant rules of 1985. Stop. Prima facie, it appears that the bar in Rule 128 is applicable to a lawyer from standing as a surety for his own client in any criminal proceeding in a court. Stop. The order passed by a learned single judge on 20th July 2007, as his lordship then was, now it is not clear from the order passed by a learned single judge on 20th July 2007 of a learned single judge, as his lordship then was, on dated 20th July 2007, whether the bar, whether the facts of the case related to the petitioners standing as sureties for their own clients for attracting the bar of Rule 128. Stop. Even otherwise, Rule 127 within brackets 4 gives the petitioner an alternative statutory remedy where an aggrieved person, where a person aggrieved by any order of the subdivisional judicial magistrate can prefer an appeal to the chief judicial magistrate within 30 days from the date of the order. Stop. This is the additional chief judicial magistrate, Mr. Sen, not the SDO.
No, the impugned order is possible additional. The additional chief judicial
Yes,
magistrate.
and 127 relates to an SDO. So the designation is different. কি বললাম লাস্ট প্যারাগ্রাফে? না, even otherwise কেটে দাও। Rule 127 within brackets 4, which gives, which, comma, according to the AAAG, comma, gives an appellate forum to the petitioner, will not be applicable in the present case, since the first order must be of the subdivisional judicial magistrate, whereas the impugned order in the present case has been passed by the additional chief judicial magistrate. Stop. Next. However, comma, this court is of the view that the impugned order, comma, does not appear to be contrary to Rule 128. কি বললাম? আরেকবার বলো তো। However, comma, needless to state, comma, any order passed by the SDO or the additional chief judicial magistrate, comma, as in the present case, comma, must comply with the requirements of Section 35 of the Advocates Act, comma, 1961, as well as Rules 126, comma, 127 and 128 of the capital, the Calcutta High Court Criminal, within bracket subordinate courts, close bracket rules, comma, 1985. Stop. WPA 6175 of 2022 is accordingly disposed of with a direction on the additional chief judicial magistrate to revisit the impugned order upon strict compliance of Rule 126, which sets out the eligibility criteria of the applicants, comma, Rule 127, which casts an obligation on the subdivisional judicial magistrate / chief metropolitan magistrate to make an inquiry on the financial soundness and the general fitness of the applicants, and thereafter ensure that the procedural formalities are complied with. Stop. The concerned authority shall also clarify that the lawyers shall not be allowed to stand as sureties for their own clients in any criminal proceedings, which is the only bar under Rule 128. Stop. The entire exercise shall be completed within 8 weeks from today, and shall be communicated to the petitioner within a week thereafter. Stop.
My lord is right. I missed it out. I'm very sorry. I missed
That's
it,
all right.
Lord.
Yes. Yes, the affidavit service is kept on record. Next. Dakota.
Pass over matter item number 6.
And I appear for the respondent. And I'm grateful my lord has accommodated.
You're the husband?
Yes.
Microphone, please. Yes, I can't hear you.
According
Microphone,
to me, my
please.
lord, the writ petition is not maintainable, my lord. This is purely a private dispute, my lord. And secondly, my lord, the parallel proceeding is also not maintainable because, my lord, on the self-same issue, he has gone before the my lord, domestic violation.
You can't
court.
understand that I'm
My- It is
pointing to
not
the
coming,
microphone.
my lord, I'm telling you. it is
No, then make an effort so that you can be heard.
not-
Yes.
My first submission is that, my lord, the writ petition is not maintainable. This is a purely a private dispute. My lord, this is a matrimonial dispute. Several proceeding has been going on in the court below. She has suppressed all the facts before your lordship's court. And secondly, my lord, the parallel proceeding is going on. My lord, before the, my lord,
Don't make vague submissions. What is a parallel proceeding? What are several proceedings? Please
why-
be specific. Yes.
I'll specific, my lord, before the domestic violation court, my lord, he has also prayed for paying EMI of this, and that issue is pending. But unless you, well, if your lordship holds that.
The respondent husband wants to make EMI, pay
No, my lord.
EMIs.
No, my lord.
No.
Your wife has made an application to compel the husband for payment of EMI before the domestic violation court under section 31.
Domestic what court?
Domestic
Domestic violation court. Never heard of such a court.
DV.
Domestic violation court.
My lord,
Under which act?
I tell you, lordship, my lord.
Domestic Violation Act.
Domestic Violation Act, my lord, I tell just a minute.
I'm going to impose costs on you for saying Domestic Violation Act.
The document about.
What is the 2005 Act called?
Under the Domestic Violation Act, section 31, my lord.
What act?
And, just a minute.
What act? What is the name of the act? Hurry up.
Just by section 30. What about that?
Don't be so flippant, please, in front of a court. Your client will help you find out the act.
No, man. Our documents with me, that's right.
What is the name of the act?
That's okay, I will tell you. Domestic. Domestic Violation Act.
Learned counsel appearing for the.
Domestic Violence Act, my lord, that is the
You
section
are not
30.
aware of the act.
Yeah.
You're saying Domestic Violation Act. What are the parallel
Domestic
proceedings?
Violence Act 2005, my lord. This is my lord.
What are the parallel proceedings?
31, section 31, he has lodged a complaint for payment of EMI before that authority. And in that view of the matter, this is a parallel proceeding. This is second submission. And third submission, my lord, she has dropped my 75-year-old mother, ailing mother, and me from that flat. She is a very influential lady in the locality.
She has roped. What does that mean?
She is a very influential lady in that locality.
I can't understand. She has roped my ailing mother means?
She has drove away my ailing mother, my 74 years old ailing mother, from that flat in question along with me. Well, I am living Baranagor at a residential place, a tenanted place, my lord, at the cost of paying high amount of my lord, monthly rental. My lord, the promoter of the building where I used to reside with my wife, my lord, his cousin brother is one of the promoter. And he's
What
around.
is all these incestuous relation submissions? Just tell me on the facts, please. What is the parallel proceeding under the Domestic Violence Court?
Yes, my lord.
What is that court?
My lord, section 31, he has lodged on FIR. I can hand up to your lordship, my lord, the proceeding he has lodged, my lord. And if your lordship give me, my lord.
Just give me the facts. Don't hand documents.
I can
Just give me the
file this by
facts.
way of affidavit in opposition before your lordship's court, my lord. If your lordship give me, my lord, opportunity to file opposition.
The fact is that you don't want to pay the EMIs.
And I cannot pay because she has driven me. She is having his own accommodation. Her father has given her a flat within the close vicinity. She is carrying on business at that flat, my lord. She is reasonably earning. She earned huge amount, my lord. His own document will prove it, my lord. Your lordship kindly produce, my lord, the bank statement of her, my lord, that she is earning a huge amount. Your lordship kindly produce page 68. Page 68.
Mr. Paul, why is this not a matter? Why is this a matter which a writ court can entertain?
Lordship, actually,
Is it a private dispute or not?
What happened, Lordship? The bank,
Yes.
the husband is not paying the money, the EMI, Lordship.
No, Mr. Paul, that is on the facts.
Lordship.
Is this a matter which a writ court can entertain?
Lordship
That
can
is my
direct
question.
the SBI to deduct EMI from the direct salary of the petitioner husband, Lordship, because the petitioner is the co-borrower. And the petitioner husband is the main person, Lordship, and he is housewife. That is the thing. That is why, Lordship, approach the writ court to direct the SBI SBI will no longer lose a, Lordship. SBI will directly deduct the amount, EMI amount, from the salary of the petitioner husband, Lordship, because the
Mr. Very well. Mr. Paul, I remember that you are assisting the concerned lawyer.
I have not seen him, Lordship.
Yes, but he's not here.
He is not here.
Mr. Paul, first, the preliminary question has to be answered, whether the writ court can
Lordship.
entertain this matter or not. If you make the SBI a party, that alone will not invite the court to get into the dispute. It appears prima facie to be a private dispute.
Lordship.
All right. So because you have kindly agreed to assist the concerned lawyer, please talk to him. I don't want to tax you
No, no.
for the matter. Please talk to the concerned lawyer, and you tell me when you want to come back.
Monday,
But
Lordship.
that answer must be given first.
Lordship, next Monday, Lordship, I don't know whether he has come or not, Lordship, today. Next Monday, Lordship,
Very well.
I shall contact with him.
Yes. Learned counsel appearing for the private respondent takes up a point of maintainability on the ground that not only is the writ petition result of a reflection of a private dispute, but that proceedings before a court, which court is this?
Srirampur Court.
Srirampur Court.
Domestic Violence Act 2005, Srirampur Court. On the learned fifth judicial magistrate.
Yes,
Srirampur.
before the Srirampur, SERAMPORE, Srirampur. Srirampur Court is pending under the provisions of the Domestic Violence Act, 2005. Stop. Since the instructing advocate is not present, lists this matter on 17th April 2023 as prayed for.
Next. Lordship will consider whether.
Next.
Grateful to Lordship.
Item number 12.
Lord, I appear for the petitioner.
May I appear for ECL, respondent number 1.
Lord, I appear for the respondent number 2. Lord, I appear for the respondent number 2. Lord, this is a tender floated where, my lord, the private respondent number 2, my lord, is the L1 bidder. I am the L2 bidder. My lord, I have challenged, my lord, the credential, my lord, of the respondent number 2 insofar as the financial
You are
portions.
the L2.
I am L2.
So if L1 is out of the way, you get the tender.
Yes, that is my cause of action or my interest in respect of this matter. Now, my lord, clause 9.2 at page 31, kindly have a look to this. Sorry, my lord, I keep on, my lord.
Mr. Dotto, if have some water, or if you're not feeling well, I can take up the matter.
This problem is when I speak, I keep on, my lord, cleaning my throat in this way. Well, it's, I'm sorry, my lord, causes some, my lord.
And you also, you should also be fair to Mr. Bose that you suspect it's COVID, which you said in the other matter.
Yes.
Have you made Mr. Bose aware of that?
That's why he has covered himself.
Very well. Yes.
But I knew that people cover their face for other reasons.
No, but Mr. Bose should know that you think it may be COVID. Because I can take up the matter on some other day. And Mr. Bose, I'm sure, will agree for a restraint on the respondent.
Restraint for the respondent. Millard, I am losing 800 crores by not awarding this contract to which decision was taken. Millard.
Mr. Bose, have to wait. Yes, Mr. Dotto.
We're clause 9.2, my lord, at page 31.
What is the prayer?
But my prayer is to, my lord, cancel, my lord, the acceptance of tender in favor of the petition number 1. I'm sorry, respondent number 2. And to disqualify the respondent number 2.
No, prayer B is what is tender dated 21st December.
Yes.
And where is the impugned order?
My lord, here, my lord, my lord, I have made a representation.
Not to award the contract in favor of the respondent number 2.
Respondent number 2. But I had made a representation on 13th of March 2023, stating that the respondent number 2 does not meet the financial qualifying criteria. To which, my lord, there is a reply on 15th of March, a vague reply saying that we are following the terms and conditions, nothing else. Now, before that, my lord, if your lordship may kindly take the clause is at page 31, which according to me, my lord, is not being fulfilled by the respondent number 2. Nine point two, my lord, for qualification requirement with respect to financial capacity, bidders are required to refer to clause 2.2.3 or etc. Kindly skip over this. Each bidder is required to choose any 3 financial years from the 4 immediately preceding completed consecutive financial years as on the date of invitation of bids. The 3 financial years chosen by the petitioner shall be the same for the member if the bidder is a consortium and the associate whose financial capacity is furnished and relied upon by the petitioner. The bidder shall have a minimum net worth of rupees 200 crores at the close of the latest financial year, etc. A is not attracted as such, we are on B. Average total income of the bidder in the 3 financial years as chosen by the bidder shall not be less than rupees 280 crores. Then, my lord, it is very important. For the purpose of the bidder documents, purpose of the bidding documents, the term total income shall mean the aggregate value of the realization of amount made from the sale, supply or distribution of goods or on account of services rendered or both by the company entity during a financial year. Therefore, total income means whatever you actually earn.
So what is your complaint?
My complaint is, my lord, they have given a certificate which provides for the income on mercantile basis. Now, what is the mercantile basis? Mercantile basis is I do a work, or say I do 10 works. In 2 of the works, I get the actual payment.
Yes.
In 3 of the works, I may get the payment next year. In 2 other works, I may get the payment next the year to the
So
next.
it gives a projected income.
Projected income, which is on accrual basis.
Yes.
The tender condition says that it will not be on accrual basis. It will be on the basis of actual profit earned or actual income. Now, please take note the certificate, my lord, which my learned friend client, Mr. Chakraborty's client has provided. Please take page 109.
Mr. Dotto, you're not really aggrieved by a rejection, so to speak. You are aggrieved at the selection of the private respondent.
Right.
Isn't there a line of cases, Mr. Dotto, that you cannot, writ petition will not lie? Some J.M. Patel or something.
G.J. Fernandez.
G.J. Fernandez.
G.J. Fernandez, there's a Patel also before that and followed by, I can't remember.
Well, G.J. Fernandez is the case and now recently followed in some.
Yes.
I'll give you the paragraph numbers.
Now, my lord, please take, my lord, page 34, my lord. My lord is absolutely right, my lord, in saying that I am challenging the qualification of a person.
Yes.
Page 34, my lord, kindly take, my lord. 3 II. Certificate specifying the average total income of the bidder during the last 3 financial years as chosen by the petitioner, bidder, from a chartered accountant based on the financial statement audited by the statutory auditor, exhibiting information submitted by the bidder online, and also specifying, this is very important, and also specifying the methodology adopted for calculating the average total income. Then Roman 4 is a duly filled in Annexure 3 provided in Appendix 1 of so and so. Now, where is this Annexure 3 at page 104? My lord will find that at page 104.
Yes.
Clause number 4, my lord, at the bottom. The bidder shall provide a certificate from a chartered accountant or equivalent, etc., and also specifying the methodology adopted for calculating the total income. So this certificate is required. Now, kindly have a look to the certificate at page 147. Here, my lord, the methodology is not stated. And my lord, respondent number 1 accepts this. Certificate of total income, name of the bidder, etc., etc. Then my lord, the table is there after the table. Total income of the entity is the aggregate value of the realization of the amount made from the sale, supplier, distribution of goods or on account of services rendered or both by the entity during the financial year. The total income for the 3 financial years has been considered and the average total income has been calculated. So, my lord, the system of accounting is not provided, which is a mandatory requirement under the financial my lord, eligibility clauses. Now, what is the actual system, my lord, maintained by the respondent number 2, my lord will get, my lord, from the tender documents which the respondent number 2 has submitted. Please take page
So
1.
you're saying this 4 at page 34 has not been complied with
Not been complied with
in 147.
at page 147, and that is, my lord, a mandatory requirement. Eligibility criteria conditions are, my lord, essential conditions, my lord. I need not dilate on that. Now, first is, my lord, there is a separation as to what is the system of accounting which is being maintained. My lord, we can gather this from the other documents which has been filed along with the bid.
Yes.
This, my lord, will find at page 194.
Yes. Yes.
Can you take, my lord, serial number 1 at the top, accounting process policies. The concern is following mercantile system of accounting. This is his own declaration.
This is the private respondent, RK Transport.
Yes.
Yes.
The chartered accountant of the private respondent, this is what has been, my lord, annexed or schedule J over there. It says the concern is following a mercantile system of accounting wherein sales, purchases, expenses are accounted on accrual basis. This is important. However, taxes, duties, and other cess demands, if any raised on completion of the assessment proceeding, is accounted for as and when they are raised. My lord, we get 2 things. Number 1, my lord, the certificate does not disclose the system of accounting maintained. Other documents suggest that they are following the mercantile system of accounting.
Yes.
The tender condition requires that it should be a cash system of accounting,
Yes.
which is page 31, read with 34 and 104.
Yes.
Therefore, my lord, this is a violation, my lord, of the eligibility criteria, my lord, and, my lord, the respondent number 1 ought to have, my lord, rejected the financial bid of the respondent number 2.
Very well. So what is the malafide or the arbitrariness?
My lord, here, my lord, as your lordships have held, my lord, in fact, my lord, in one judgment, my lord, your lordship has also held that these tender conditions, which are essential in nature, they are to be strictly adhered to. The respondent number 1 has framed the tender condition. The respondent number 1 could have allowed any system of accounting.
Been a case of rejection.
It ought to have been a case of rejection.
No, I'm saying whichever judgment you're referring to must have been a case of rejection.
Yes. Now, where, my lord, it is said that essential conditions are to be strictly adhered to.
Yes, but the cases which I'm referring to is whether you can complain and come to a writ court saying that the competition has been narrowed down. That you can't probably, or has been broadened. So more people are coming into the fray and you have kind of become one of many. That cannot be a matter before the writ court or cannot be entertained.
Well, my case is a bit different. My case is that as a bidder or the respondent number 2 as a bidder, they have a fair or a right to be fairly dealt with at the bidding stage. None of the bidders or the intending bidders have a right to bag a contract. Now, if somebody has been given an advantage which he or it is not entitled to in terms of the contract, or if, my lord, there is a departure from the terms of the contract, my lord, then, my lord, the writ court can step in. But again, my lord, Justice Frankfurter's quotation. that an administrative authority is rigorously held by the standards by which they profess their actions to be judged.
Yes.
And they have to scrupulously observe them on the paper of invalidation. You have laid down the terms. The respondent number one has laid down the term. The respondent number one could have said, okay, mercantile or cash system, anything would have done.
The moment you say Justice Frankfurter is distracting. That's why I forget the quote. Yes, very well.
Similar.
Very well. So you're saying that is the arbitrariness.
Yes.
in the-
You have departed from your laid down norms.
Yes. Mr. Bose?
Yes. My lord, just a few things. Your lordship will kindly note.
But only one, before me, Lord, Mr. Bose starts,
The guy-
only one. But I had made a representation Lord, at page 268, and kindly see the reply.
268.
Yes, ma'am. This is my representation.
Yes.
Where Millard at the first paragraph, second paragraph, I quote the provision. Then I say, Millard, I give the chart. I need not, Millard, trouble your lordship with those. And finally, I say that he is not qualified. Now the reply comes to me at page 273 to 272.
Yes.
Not dealt with. It says with reference to the above mentioned letter, this is to state that the evaluation of the bids by the tender committee is being carried out as per the eligibility criteria. That's all. They have not said that what I have said is incorrect, or that the respondent number 2 is maintaining the proper system of accounting as per the requirement of the tender.
Yes.
Therefore, my lord, I'm told, my lord, subject to correction by Mr. Bose, but the work order has not yet been issued in favor of the respondent number 2. But if your lordship wants, my lord, I've got one decision word which says what is the distinction between cash system and mercantile system. If your lordship requires, I'll place it. Otherwise,
Not required. Yes.
My lord, just take down a few dates on behalf of the statutory authority, I'm saying.
Microphone, please, Mr. Bose.
My lord, the first tender notice, this is the third tender notice. There are 2 previous tenders which failed. My lord, the first tender notice was 24th March 2022. My lord, this is for development and working of mine for 18 years. For 18 years, mine, when then coal would be extracted. My lord, on 24th June 2000.
Without an overburden here.
No, this is not the overburden. They'll work the mine. A developer would, this is the first time this area, the mine is being worked. And my lord, coal would be generated. For 18 years, he's being given the job.
Where is this? Very, yes.
Well, at the coal belt area, but Itapara.
Yes.
But this is a new place where for 18 years. So, Millard, as I told your lordship, 24th March 2022, first tender notice. Tender opened on 24th June 2022. No bidder participated.
Yes.
The tender was cancelled.
Yes.
Now, my lord, the second tender notice was 21st July 2022.
Yes.
My lord, the tender was opened on 26th November 2022. Tender opened,
Yes.
only one participant, MB, that is the writ petitioner.
Yes.
My lord, the price bid was of MB was opened on 16/11/2022. And it was rupees 1893 per ton, which we thought was very, very high.
Yes.
My lord, on 16th December 22, we persuaded MB to reduce. They reduced it only to rupees 1840 and per metric ton. Therefore, we cancelled the second tender.
Yes.
My lord, the present tender is dated 21st December 2022.
Yes.
Now, my lord, it has 2 parts. First is technical bid and the second is financial bid, the price bid as such. Now, technical bid, part 1, was opened on 15th February 2023, paragraph 8 of the writ petition.
Yes,
My lord, 3 bidders qualified.
yes.
The summary of the bidding you will find at page 144 of the writ petition. 3 names of 3 bidders. So he was aware as early as on 15th February 2023 that there are 3 people who are entering into the competition. Whatever is being said, my lord, yes, that I came to learn that this is what he submitted. He never, no protest.
No, but how will you know at that stage
My
that
lord,
this
it is
what being-
uploaded, the names are uploaded, and then he himself has said.
No, what about the way of computing the aggregate
That
income?
is, I'm coming to that, my lord. The price bid
Yes.
was opened on 13th March 2023, almost 1 month later. May not if you're
Yes.
13th March 2023, my lord, at 1:15 p.m.
Yes.
And my lord, his protest letter, which he has annexed at page 268,
Yes.
is also of 13th March 2023. But my lord, sent at 2:25, that is 2:25 p.m. My lord, immediately after that he has this protest letter, he has not qualified.
So you want to show that the petitioner has been very prompt?
No, I am trying to say he had full knowledge. It's a question, my lord. He took a chance that he who is the person who would succeed, and there will no one who can beat his bid. He has entered into the competitive field.
Yes.
This is what, my lord, competition is about. And this is what J.J. Fernandez is about. It's not that, my lord, he has quoted a less rate, but we eliminated him, my lord, in the price bid stage. He is saying he's aggrieved because someone has quoted much less than him. And as a result of which, the authority, my lord, is gaining 800 crores.
Sir, Bose, if he has written that letter in 1 hour precisely.
He knew everything that
Yes.
he
So
knew.
you're saying that it's not possible to write it in 1 hour?
No, these are the particulars of my income tax. He has annexed everything. The respondent number 2's income tax returns, everything chartered, whatever it is, it was there before him. He knew, my lord, and therefore he never complained. He took a chance. Now, my lord, selection of bidders under the clause, my lord, of my lord, is clause 3.9, page 89.
Mr.
Bidder
Bose,
has to substantially be
you
responsible.
want to come back at 2?
Yes.
At 2?
Yes.
Very good.
Item number 12.
Yes, my lord, I was a few more submissions only. My lord. I have told your lordship that the technical bid was opened on 15th February 2023.
Yes.
And my lord, the price bid was opened on 13th March 2023 at 1:15 p.m. And the protest letter is at 2:25 p.m. on 13th March itself. My lord, what is important is paragraph 17 of the writ petition, and I am reading to your lordship paragraph 17.
Which page?
My lord, page 12 of the writ petition, that all this, that incorrect things have been given, my lord. Kindly see the fact that such false and incorrect information and material made by the were brought to the notice of respondent number 1, my lord, please note the new words, by another unsuccessful participant bidder, Elite Enterprise. Now, Elite Enterprise did not even qualify after the technical bid. My lord, technical bid was opened on 15th February 2023. Elite was not one of the 3 bidders who qualified in technical bid. That means, my lord, unsuccessful bidder Elite had access to all the documents which were uploaded of every single bidder of bidder, and that is how Elite got it and showed it to AMBI. My lord, but the difference between Elite and AMBI is, my lord, that after 1 month elapsed, and he wanted to see whether took a chance, whether he is the lowest bidder or the highest bidder or whatever, my lord, it is. Now, my lord, in light of this, my lord, the writ petition is affirmed on 23rd March 2023.
Yes.
Writ petition is affirmed on 23rd March 2023, and we are now here. My lord, certain terms and conditions of the tender, I must draw your lordship's attention. My lord, is my lord, kindly come to the document, my lord, page 32 to 34 of the writ petition, certain clauses. I won't draw your lordship's attention to all the clauses, 32 to 34. My lord, I draw your lordship's attention to clause, my lord, 12, which is,
Milord, may I reply on some other day, Milord?
Yes, yes.
Could it, Milord, after Mr. Bose and Mr. Chakraborty finishes, could it be day after tomorrow, subject to the convenience of the court, Milord?
Yes, Mr. Bose?
I have no issues.
Very well, yes.
Yes. তুই 10 মিনিট আমরা চলে আমি 5 মিনিট বলবো 5 মিনিট তুই চলে আয়
Yes.
Yes. My lord, please come to clause 12(1).
Clause 12 of which
Of
page?
at page 38, my lord, of the what they call as RFB. RFB is request for bids. My lord,
As opposed to request for proposal?
RFP.
Yes.
My lord, of course, what your lordship is seeing is the NIT, notice inviting tender, but your lordship will find in clause 12, for details in relation to bid opening and evaluation, refer to section 3 or of RFB.
Yes.
My lord, and very important, my lord, is clause 15, my lord, in this regard. My lord, the authority, this is most important. The authority reserves the right at its discretion to postpone the bid due date and date opening, or reject any or all bids without any reason, or accept any bid, which, my lord, this is important, in the authority's sole judgment and discretion is most beneficial to the authority. My lord, the tendering, this is why I say that the writ petition is cause of action is not justiciable.
And authority is ECL.
Yes, the tendering committee, the authority is ECL. That is what I, my lord, wanted to tell. It is not justiciable. And
Yes.
my lord, but to substantiate that it is not perverse, or my lord, it is not whimsy, which your lordship, irrespective of a clause, can, my lord, interfere. Perversity. I show you, my lord, the RFB, some terms and condition. My lord, kindly come to page 85, where this RFB section 3 is set out. Page 85. RFB, page 85, 3.9.
Yes.
My lord, 3.9, my lord, is selection of bidder.
3.9. That is
Yes.
not page 85.
89, at
89.
89.
Yes.
My lord, section 3 starts at 85,
Yes.
which I showed you, lordship, clause 12 referred to section 3 of RFB, my lord, NIT.
Yes. Yes.
And my lord, this is most important, 3.9.1. My lord, this is very important. Kindly see, subject to the provisions of this RFB, the bidder, my lord, whose bid has been determined, my lord, to be substantially responsive, and who
What does
is
that mean?
substantial. So, my lord, it's a discretion given, my lord, what are essential terms. My lord, we go back to Poddar Rashmi and recent judgment of 2022. This is where I say, my lord, it is not justiciable. The ultimate authority to judge all this is the authority itself, the tender committee. The
Yes.
writ court does not interfere. That's the
As the Supreme Court says, the author of the tender document.
yes, yes.
Yes.
My lord, so I say it is not justiciable. My lord, at times, like Ramana case, your lordship remembers?
Dharam Shetty.
Yes, Ramana Shetty, my lord, it is possible to interfere because if you shut out a person, then you are preventing competition. If you shut out a person, but if you are, I mean, this is not a question of shutting out a person. That is exactly, my lord, what G.J. Fernandez says. My lord, and you, lordship, kindly see page 89 also, 3.9.5, same clause, that bidders are advised that assessment of qualification will be entirely at the discretion of the authority. Now, my lord, I've shown your lordship this. Now, what is most important, I didn't give you the figures, my lord, figures, which is most beneficially. Now, my lord, there were 3 bidders. Now, my lord, who qualified in the technical aspect. Now, RK Trading, my lord, RK Trading,
That
has-
is
that is
successful.
Mr. Kothai geli?
Yes.
Mr. Chakraborty's client has bid rupees 1565 per metric ton.
Yes.
My lord, MB Mining, which is the writ petitioner, has bid rupees 1739 per ton. My lord, as compared to rupees 1840, which was its bid on 1612 in the second tender, which, my lord, he reduced it to 1840. So he bid something less. No, you go, I'm sure that he'll get it.
Second tender is 21st July 2022.
21st, that is the notice. My lord, he price bid was, tender was opened on
16 November.
16 of his price bid was opened when it was 1893 per metric ton. He, by negotiation, he reduced it on 16/12/2022 to 1840, but we found that it is too high. So this time he bid less, 1739 per share. There was a third one, my lord, GRN Construction. Why he did it, I don't know, but he bid 2849 per metric ton. That's very high my lord. But 156.
To force the private respondent.
My lord, I don't want to speculate. How can I, my lord, say all this? My lord, so for this, the loss which ECL would suffer, my lord.
Loss from what?
He has to make payment of money, because whoever quotes less, my lord, has to for 18 years. The loss, my lord, the total, because the total quantity.
Mr. Bose, the loss hasn't occurred till now.
No, in saying because by awarding, by rejecting this person and giving it to him, the loss which the amount extra we have to fork out, my lord, is for 4602 million tons, which will for the 18 years, my lord, will be 800.748 crores.
Mr. Bose, this is not required. This is only to show that you, as the author of the tender document, have a right to choose.
For which is beneficial.
And provided, of course, there is no malafide selection
Correct,
of
correct.
the
My lord, which is beneficial. I am showing it is beneficial.
Yes.
Yeah, now, my lord, in light of this, your lordship, I will just rely on a few cases, if your lordship permits
On what
me.
point?
My lord, on this, it is not justiciable. Writ court, my lord, does not, my lord, sit in appeal of the decision of a tender committee. They are the sole judge, my lord.
Yes.
And secondly, my lord, the if it is there is a marked distinction between, my lord, what is if you are shutting out competition, and, my lord, which is, and whether you are my lord, actually inviting more competition. So if a person gets rejected because I have not, you have it's a different considerations apply, my lord, in this case. Now, my lord, in the case, my lord, it's very well discussed. I'll give you the paragraph numbers of G.J. Fernandez. My lord, they copy the my lord, 1990, volume 2, SCC 488, and the paragraph numbers, my lord. My lord, the paragraph numbers. My lord, paragraph numbers are 2, 3, 5, 6, 7, 14, and 15. 2, 3, 5, 6, 7, 14, and 15. My lord, just 14 and 15, my lord, would do at this stage. My lord, your lordship, I need not, my lord, shall I read it, my lord, here now? Or
Just 1 minute, I'm trying to find out the.
কপি চাই এই আরেকটা কপি দিয়ে দে তো ওকে
Just give me 1 minute, Mr.
Yes.
Yes.
In 15.
It is,
sorry.
Mr. Bose, just, I don't know whether it's relevant, but it's Jasbhai Motibhai Desai versus Roshan Kumar.
My lord, the second case এর নামটা কি?
JM Desai, Jasbhai Motibhai Desai versus Roshan Kumar.
তাহলে সেটা দেখ এখানে ওইখানে ইয়ে করে
On this point.
My lord, the latest case is, of course, Jasbhai.
Jasbhai Moti, what did I say? Jasbhai Roshan Bhai JM, Jasbhai Motibhai Desai.
By Motibhai Desai. I'll just check, my lord, in the latest case.
No,
which has
that's fine. I had this case with me.
My lord, it is lordship's judge.
No, it's an old case.
Oh,
Yes.
Just my lord.
Yes.
This fact which I'm saying is mentioned. I gave you the paragraphs, especially if you see paragraph 15. They conclude you will get it. My lord, I gave you the paragraphs 2, 3, 5, 6, 7.
Paragraph 15 at which page?
My lord, at page 501. May I just read it once?
No, not the whole thing.
No, my lord.
Just tell me.
Thirdly, conditions like have two types of consequences. First is that party issuing has a right to punctuously and rigidly enforce it. Thus, if a party does not strictly comply with para such as it is open to decline to consider the party of the contract. If a party comes to court saying that KPC should be stopped from doing so, court will decline relief. The second consequence indicated by this court in earlier decisions is that KPC cannot deviate from these guidelines at all in any situation, but that any deviation, if made, should not result in arbitrary or discrimination. It comes in for application when non-conformity with or relaxation from prescribed result in substantial prejudice or injustice to any party involved or to public interest in general. For example, in this very case, KPS made changes in the time frame originally prescribed. These changes affected all intending, this is all intending applicants alike and were not objectionable. In the same way, changes or relaxations in other directions would be unobjectionable unless the benefit of those changes, elections were extended to some but denied to others. The fact that a document was belatedly entertained from one of the applicants will cause substantial prejudice to another party who likewise wanted an extension of time for filing a similar certificate or documents, but was declined the benefit. It may perhaps be said to cause prejudice also to a party who can show that it had refrained from applying for the tender documents only because it thought it would not be able to produce the document by the time stipulated, but would have applied had it known that the rule was likely to be relaxed. But neither of these situations is present here. See, Vaidyanathan says, in this case, one of the applicants was excluded at the preliminary stage, but it is not known on what grounds that application was rejected or has the party come to court with in such grievance. The question then is whether the course adopted by the KPC has caused real prejudice to the appellant and other parties who had already supplied all the documents in time and sought no extension at all. It is true that relaxation of time schedule in the case of one party does not affect such a party in the sense that he would otherwise have had one
Mr.
less
Bose, I was
competitor
sorry
less.
to interrupt you. I was more on the narrowing down of competition.
Yes,
Whether
here it is said, narrowing down on competition. It is true that relaxation of the time schedule in the case of one party does affect even such a person in the sense he would otherwise have had one competitor less. But we are inclined to agree with the respondent's contention that while the rule in Ramanujan will readily be applied by courts to a case where a person complains that a departure from the qualifications has kept him out of the race, injustice is less apparent where the attempt of the applicant is only to gain immunity from competition.
very well.
This is, my lord, the principle, my lord.
Difference between a case of rejection
Always.
and a case.
Always, my lord, that is, if you see Poddar point or whatever, and this Rashmi metallic, it's essential. What are essential terms? What are non-essential terms? My lord, always relaxation is done to invite more people. My lord, the relaxation here it's everyone has been given full opportunity. That is when relaxation you come to the
No, and Mr. Bose, the fact that the successful tenderer did not produce the documents which were there in those conditions which were required, that is not a point of prejudice.
No, my lord, he did produce.
No, that
is what he's saying, accrual, mercantile. It is a question of interpretation of the whether Miller substantially he has complied. And that is the order.
194.
Yes, my lord.
Page 194.
Yes. That methodology is not mentioned.
No, that 194 is contrary to pages 34, 104 and 147.
My lord, according to the tendering committee, it is substantial compliance. According to the tendering committee, it is substantially and my lord, what is relevant is clause 10 of the NIT. Whether, my lord, if you see, my lord, in clause 10 of the NIT, it is, my lord, which was also amended, my lord, I'll show you, clause 10. At page, I am told 31. For substantiating, we are required to furnish the following information online. Now, this has been complied with.
Yes.
This is complied with. My lord, I mean, he's trying to interpret mercantile.
No, he's just saying, Mr. Dotto is just saying that there were certain conditions in the tender
Yes.
which all successful bidders were required to
Right, my
fulfill.
lord.
And the documents given by the private respondent here did not comply with those conditions. That's all.
My lord, the tendering committee has replied, although it was not obliged to do so by that 15
No, the
said.
reply is very insufficient, Mr.
No,
Paul.
no, we are complying with the terms and conditions. My lord,
All the
anyway, my lord,
points raised
this
in
is,
the
I showed you the clauses, my lord, substantial compliance. Now, my lord, I gave you paragraph 2, 3, 5, 6, 7, 4, 15. It's a very good discussion, my lord, whether it is justiciable or not. My lord, the previous paragraphs I did not show you.
Yes.
Paragraph 2, 3. My lord, there is a very recent judgment where all these cases, my lord, there's a summary more or less. My lord, it is reported in 2022, volume 5 SCC 362. My lord, may make a note. Okay, of paragraphs. My lord, may I make a note of the paragraph? My lord, 1.1, then 1.1, comma 2, then 9, 16, 19.2, and very important are 24, 25, 26. My lord, these are the very important, and also 27, 28. May I straight away draw your lordship's attention to paragraph 24, 25, and 26. Okay, ekta de.
Which page?
My lord, 24 will begin at 379. My lord, this is whether it is justiciable or not.
Yes.
The scope of judicial review
Yes.
in contractual matters, and particularly in relation to the process of interpretation of tender document, has been the subject matter of discussion in various decisions of this court. My lord, have you got this?
Yes, yes.
Yes. We need not multiply on the subject as suffice.
Bose, I'm familiar with this judgment.
Yes.
On
My
the-
lord, you will see, that is why I said this is not justiciable. My
And
lord,
this takes into account all these NG projects. and
yes,
everything.
yes. My lord, that's what I said, my lord. Those we used to always cite that Rashmi, that my lord, Rashmi metallic, what are essential terms and what are non-essential term, etc. My lord, to discuss whether it's essential or non-essential, it is always the tendering committee.
Yes, and it takes into account SILPI also. SILPI.
Yes,
This
yes.
judgment.
Yes, all.
NG projects, SILPI.
That one I only don't remember. The lordship said he just.
No, that is a very old decision, but started this line of reasoning, narrowing down of competition.
Now, otherwise, Tata Cellular, everything. I mean, everything. My lord, as a statutory authority, my lord, I am not aware whether it is already because they had 180-day period to take a decision after objection to award the contract. 180. It's written.
They as in you.
Well, not we had a 180-day period from the date of the bid to award the contract. So whether it has what decision has been taken, I do not know. My lord, I cannot assist you maybe because I'm told that it is going to be it, but I cannot say until the decision is there. But whatever it is, the writ petition with respect is not maintainable in the sense It is maintainable, but not justiciable. My lord, as is inside. Judicial review, my lord. My lord, I have nothing to.
Mr. Chakraborty, 5 minutes, not more than that. You have nothing to say anyway. Yes. Except to say that your documents are in order. Microphone and speak clearly. Yes.
Lord, I may not even require 5 minutes, Lord. I will only show one document. Lord, my lord was at page 31. Mr. Bose was showing a lordship clause 10.
Yes.
But kindly have a look at Lord the clause 10 for once. Lord, this qualifying criteria, Lord, has two parts. One is Lord technical capacity, one is financial capacity.
Yes.
Technical capacity is that Lord, in 1 year amongst the last 7 years, I excavate, or one tenderer has to excavate 8.9 million of coal in 1 year. Lord, I submitted document of 11 million of coal. That's not even their case. Now in the financial capacity, it has two parts. One is net worth that required initially 200 crore, then it was amended to 100 crore. I submitted document of more than that. So that is not their case. With regard to net income, they said that, Lord, I have not submitted the relevant document which I was required to do. Lord, I will show your lordship, Lord, that I submitted document as per the tender, and the document submitted by Mr. Dotto's client is absolutely the same document that I have submitted.
Please, I'm not going to get into that point
Yes,
at all.
kindly take page 31 once.
Yes, clause 10.
Clause 10.
I've seen that. Yes.
Clause 10 says, I will A, net worth document, then B, value of total income in 3 financial years as chosen by the bidder to be submitted in Indian rupees and format annexure 3, that is at page 103. Now, if my lord takes page 103.
Yes.
Now that format.
Yes. Yes.
Is mentioned. That format is mentioned on page 147, which is my document, page 145.
Yes.
Kindly take page 145. I have exactly followed the same format annexure 3. So, Lord, I have followed what is there in the contract or the RFB, request for bid. Lord, I was supposed to, Lord, submit a certificate of a chartered accountant, and secondly, audited balance sheet of the 3 financial years, which I want to rely on to show that I have done, Lord, I have earned total income of 287 crore on an average. Now, Lord, page 145 is the annexure 3 that I have submitted, and the certificate that I have submitted is at page 147.
Yes.
Page 147 is the chartered accountant certificate. Now, my lord, Mr. Dotto has relied on page 194 to show that I have followed mercantile system. Well, the tender doesn't say which system is to be followed. It doesn't say that I have to follow cash system, cash flow system, or mercantile system. Now, I am to submit a certificate issued by a professional chartered accountant along with my audited balance sheet, which I have submitted before the income tax authorities. Now, these same documents, Lord, these online tenders, this was technical bid was opened on 15th February. So everybody could view the document submitted by the other party. So as Mr. Dotto has annexed, I have also carrying the document submitted by him. So similar documents were submitted by all the parties. Now the tender committee, Lord, considered all the similar documents, and Lord, then Lord selected 3 persons as technically qualified bidder. Lord, that was done on 15th of February. He waited till the opening of the financial bid.
Don't repeat
And
anything
then
else.
Now,
Don't
Lord,
repeat
this is-
anything.
Oh, yes.
Yes.
Now, this is with regard to this. Now, my lord may kindly have a look at this document, my lord, and kindly.
What is this?
Not kindly, this is
Your learned friend also.
his document. This is his document.
What
which
is document?
Lord, his certificate, chartered accountant certificate. My lord may kindly, my lord, take the pen to compare it with page 147. It is absolutely the similar. So there is no perversity or arbitrariness. So similar document, same set of
What is
documents.
the point? I could not follow.
Lord,
What is the
Mr.
point?
Dotto has said, Lord, that there are arbitrariness, perversity because I did not follow. Lord,
Yes, what is this document?
Lord, it is Mr. Dotto's client's, Lord, financial certificate issued by the chartered accountant.
Yes.
In terms of annexure 3.
Yes.
Lord, I have, Lord, perused it, compared it with my document. It is absolutely the same. And with the 3rd successful tenderer. So, Lord, the tender committee has visualized all documents at par. There is no perversity, number 1. Number 2, this is, my lord, a mining development contract. So, my lord, 4 crore 60 lakhs ton coal I have to excavate. I have given a bid of, Lord, 1565 rupees per ton, which is 7,200 crore. His bid is 8,000 crore. The moment he got to know that his bid is higher
Very
than
well.
me, he
Any,
filed.
any other point?
Number three, the rejection, my lord, whether that is reasoned or unreasoned, that has not been challenged.
Rejection. Whose
But the
rejection?
ECL, my lord, has
There's
responded.
no rejection, I thought.
No, not rejection. Page 272, the response of ECL. That my lord, Mr. Datta has shown your
Yes,
lordship.
yes,
15th March, the
yes,
response to his letter.
yes.
That has not been challenged. Whether that is reasoned, unreasoned, not challenged. And it is not a case that his bid is rejected.
272 is under challenge.
No, not challenged.
What is
Not
272 anyway?
Lord, 272, his Lord ECL's reply to Mr. Datta's representation, which was filed after losing the contract.
Yes, yes.
That has also not been challenged. Lord,
Why should be challenged?
no, Lord, he has not, Lord, he said that it's unreasoned, but that
Yes.
has not been challenged. Now, Lord, I have submitted document of technical qualification, financial qualification, and one more thing, Lord, Mr. Bose has, Lord, shown your Lordship's Agmatel. Lord, NK project, Lord, was delivered after
NG.
Agmatel. NG projects were delivered after Agmatel. My Lord, may I have a copy of
NG project, paragraph 23.
Yes, NG projects.
That you can sue for specific the damages.
Yes, yes. Para 21 to 23. Para 21 to 20, even if there is malafide, the court, and this is a development tender, mine development order. Look, this is 2022 6
Yes, yes,
SCC
yes.
127.
Yes.
Look, this was delivered on March 21 and Agmatel came on 31st January.
Very well. Anything else?
Now, Lord, only one aspect, no? No. Only one aspect, no?
Mr. Chakraborty, don't waste time.
No, Lord, I'm
You know what happens if you waste time.
no, I'm not. These are my submissions, and Lord, I have complied with all Lord qualifying criteria, Lord, of the tender. So there is no
And,
adversary.
you should be advised not to raise questions on Mr. Datta's bid.
No, I'm not raising for a minute. Not even for a minute.
Yes.
I said that, Lord, there is no perversity or arbitrariness.
Very well. Heard learned, when did Mr. Datta want to give his?
After if Manoj.
Yes, the petitioner is aggrieved by award of the tender for excavating coal mines to the private respondent. Stop. The petitioner was the second bidder in order of qualification, whereas the private respondent emerged the successful bidder. Stop.
My lord, I don't believe, my lord, they've been declared successful bidder as of yet, my lord. They're the
They have
lowest.
not been declared.
L1. They are L1 bidders.
Oh, very well. Ki bola, whereas the private respondent was declared as L1. L1. Stop. The petitioner complains that the private respondent did not fulfill the tender conditions, particularly in relation to furnishing of documents for showing the financial capacity of the bidder. Stop. Next, heard learned counsel appearing for the Eastern Coalfields / respondent Eastern Coalfields as well as the private respondent. Stop. List this matter on paragraph karo. List this matter on 12th April 2023 for hearing the petitioner as prayed for.
Much appreciated.
Much obliged. Yeah.
Yes, call on the next one.
Item number 13.
Your Lordship, Advocate HON'BLE is appearing in this matter. He is on his legs before courtroom number 25. I am praying for a short passover, Your Lordship.
Is it urgent? Then I can
Yes, Your
keep it
Lordship.
tomorrow. It is urgent.
Yes, Your Lordship.
Very well, at 3.
Oblige, Your
At
Lordship.
2:45.
Oblige, Your Lordship.
Next.
What is it? এটা কি হচ্ছে? হ্যাঁ, সেটাই বলছি।
Item number 14.
This is my writ petition, my lord. Challenged, my lord, the declaration as a willful defaulter of the petitioner. The petitioner was declared as a willful defaulter.
Yes.
The ground of challenge, my lord, was that the master, in terms of the master circular, the identification committee's decision has to be communicated to the petitioner, and so that an opportunity is given to the petitioner to go before the review committee. Now, this did not happen in this case. Now, the petition, after it was filed, my lord, it was pending for some time. There has been a subsequent development, my lord. In the meantime, my lord, the dues of the respondent, my lord, has been paid off, and there's a no due certificate issued only subject to, my lord, all these proceedings, my lord, which we had initiated, my lord, being I was humbly praying, my lord, since the no due certificate we have already paid, but the legal question still remains, my lord, that this, my lord, this entire declaration of willful defaulter, my lord, was not in terms of the notification.
But
Therefore,
Mr.
it can be,
Rai,
my lord, quashed, my
if
lord.
all the
By mistake.
outstanding amount has been paid, then what happens to a declaration of willful default?
Lord, if the outstanding amount has been paid pursuant to a
Because
compromise.
the substratum goes.
Yes, my lord, pursuant to a compromise, my lord, then in view of the RBI, sir, Lord, in view of the RBI master circular also, my lord, which governs, my lord, willful default declaration proceedings, my lord, if compromise is reached between the parties, my lord, then the bank should not, my lord, send the name to the civil or, my lord, to the committees or the companies, my lord, which record, my lord, names of willful defaulters, my lord. If that be the
So
case, my
that
lord,
is
here-
the final stage.
Yes.
That the bank sends a name to the companies. Which
To CIBIL,
companies?
CIBIL, my lord.
To CIBIL, that is for the score.
Yes.
And what else? What is the
Lord,
final
CIBIL
outcome?
CIBIL is the only company, my lord, which where, my lord, the names are actually, my lord, they are captured. Once, my lord, a willful defaulter declaration is made by the review committee, my lord, the bank has to upload it on a particular site to which, my lord, companies like CIBIL have access. Now, my lord, these capture from those websites directly, and, my lord, against the name of a borrower, my lord, the word willful defaulter, my lord, is inserted. My lord, this
Great.
is, my lord, here in this
So it's
case, my lord,
basically a name and shame kind of thing.
yes.
Yes.
Lord, because the Lordship knows, Lord, the object is dissemination of information, Lord, by the willful defaulter declaration guidelines of Reserve Bank of India, Lord, has a stated object. Lord, the object says that dissemination of information as regards willfulness and default. I have capacity to pay, or I have siphoned off funds. The four criteria, my lord, which are mentioned. If I have fallen within the mischief of any one of them, then in that case, I should not be, my lord, blessed with any more financial assistance by any other financial institution. That is the idea. Now, my lord, here, since, my lord,
So, Mr. Rai, if the petitioner has paid the amount, then what
should
remains
not
of the? So you have not given the no objection. What is
Yes,
it that
my
you are
lord,
supposed to give?
we have, no, my lord, we have given the no dues, my lord.
No dues.
No
yes.
dues has,
certificate we
no
have
dues letter was given that you have received the full payment, but we will give the no dues only after you withdraw. But the only other thing I'm wanting, which I've spoken with Rai, is also let the willful defaulter be quashed. Because I've got legitimate grounds. Otherwise, so long as my name remains, and with the no dues, it will serve no purpose. So a name has to be true to
Got
be
an honorable acquittal.
honorable. After all, honorable acquittal, because and also here I'm covered by the Supreme Court judgment. The orders were not made available to us. The identification committee's order was not available to us, so I couldn't approach the review committee. So legally, I have grounds to have it quashed also.
Lord, on that ground, my lord, I would have argued, my lord, although, my lord, it's no stage now, my lord, because we have already, my lord, that ground will not hold good, my lord, because that is another case, my lord, where my learned senior friend was opposing me, my lord, where, my lord, it has been held, my lord, that the JAR developers order, my lord, was legislation judicial in nature, my lord, where it says, my lord, the Honorable Supreme Court has said that we hereby insert this provision, my lord, in the regulation.
Justice Nariman.
Yes. So we hereby insert. Therefore, it will not take, my lord, retrospective effect. My lord, it will apply prospectively. Therefore, this willful defaulter proceeding, my lord, is prior. My lord, otherwise it will render chaos. My lord, all the proceedings, my lord, will reopen, my lord, on the basis of JAR developers. My lord, that there I could have argued, but here I will not argue, my lord, because that point also is not open now. Since, my lord, we have already, my lord, washed off our hands. We have given a
So
notice
very well.
certificate.
Mr. Mithru, what is it that you want now?
Well, I want that my name should be removed from the list of impute of the
Yes, Mr. Rai, what do you say to that?
Yes, my lord, it should be removed, my lord, because I was just, my lord, looking
Where is the declaration? Which page?
Page 504 is all we have got.
504. Which volume?
So that's the last volume, my lord. Page 504, volume 2, I think. 504.
And this is the letter.
That is,
written
this
by
is the identification committee.
Communication from
Yes,
the.
Mr. Rai, I am quashing this.
Yes, my lord,
declaration.
and my lord, to quash this, my lord, your lordship can take, my lord, into consideration, my lord, page 550. My lord, because that I think, my lord, is an answer to this. Although, my lord, I'm arguing against myself yet, my lord, this.
Yeah, that's what I'm saying.
But willful defaulter circular, my lord, begins from page 537.
Yes.
And my lord, page 550.
Yes.
Lord, my lord will find an explanation given. Page 550. In this connection, it is clarified that banks need not report cases where, my lord, II, in respect of cases where banks have agreed for a compromise settlement and the borrower has fully paid the compromised amount. Lord, this stands in favor of my learned friend, Lord, today. So
Thank you, Mr. Rai. You have always been of assistance to the court.
Very. And lordship, their letter, my lord, if I may keep on record the bank's letter.
Yes. $7.99. 17.99 crores.
Yes, 17.99.
Very well. The petitioner seeks quashing of a declaration of the petitioner as willful defaulter by the identification committee of the Allahabad Bank. Stop. Next, the reason for seeking the same is a letter placed before the court and issued by the respondent bank. One minute. Allahabad Bank has become Indian Bank now. Very well.
Allahabad Bank.
Yes, issued by the respondent bank, within brackets, now Indian Bank, close brackets, on 28th March 2023, recording that the petitioner has paid the compromise amount of rupees 17.99 crores in full, and there are no dues remaining outstanding to the bank in the subject account of M/S Kaiser KAAI SER Oil PVT Limited Ltd. Stop. The letter further states that the NOC is to be issued. NOC will be issued subject to withdrawal of all pending proceedings in filed by the petitioner in any court. Stop. Next, the parties are represented. Stop. Besides, the settlement of the compromise amount is directly relatable to clause 2.9 to the explanation II, choto I, to clause 2.9 of the master circular issued by the Reserve Bank of India dated 1st July 2014. Stop. Explanation II provides that banks need not report cases where the banks have agreed to a compromise settlement and the borrower has paid the compromise amount in full. Stop. This is exactly, this is precisely the case before the court. Stop. Since the petitioner has paid the amount in full, comma, as recorded by the bank's letter of 28 March 2023, comma, the petitioner's name as a willful defaulter and any connected declaration cannot remain in the records of the bank. Stop. the communication of 17th February 2017 declaring the petitioner as a willful defaulter is therefore quashed. Stop. The letter issued by the bank on 28th March 2023 is kept on record. Stop. What is AST 347? What is this? Is it WP? What is it?
Tender number.
WP
26208.
26208W of 2017. Just find out, has the name number not been changed? Now it's all WPA.
But this will,
Yes, WPA 26208 of 2017, and all connected applications are disposed of in terms of this order.
well, only one other direction, though I know Sybil is not a party here, but Sybil should also have my name removed. Sybil, who they've reported to Sybil,
Mr. Mitros, if Sybil is not a party, how can I issue that direction?
Your Lordship can ask the bank, direct the bank to write to Sybil so that Sybil may remove the name. It was that.
Not specifically. The respondent bank shall take due steps in accordance with the order.
Great. Okay.
Pass over matter item number 13.
Lordship, I am for the petitioner, Lordship. I have challenged the cancellation order of my tender bid, Lordship. Lordship, kindly turn, Lordship. Lordship, brief is not there. Page 34, Lordship, at page 36.
Documents not submitted.
Lordship, two documents. They have stated, Lordship, item number 4, left-hand side, and 5. Attested photocopy
Yes.
of certificate professional tax for the certain year, and attested photocopy of uploaded trade license certificate challenge for trade in the field of catering license for supply of cooked diet and food items compulsory, otherwise the bid is liable to be rejected. These are the two things, Lordship. Lordship,
This is coming after affidavits.
Lordship, they have submitted their report and I have filed my exception, Lordship. Lordship, in their report, Lordship directed them to submit other bidders' document in respect of trade license and food license, Lordship. Lordship, kindly turn, Lordship, affidavit submitted by them, Lordship. There are 5 successful bidders, Lordship.
That is the report of Abrojit Mukhopadhyay.
Abrojit Mukhopadhyay.
Yes.
Lordship, I have submitted my municipal tax
So,
certificate.
what was the order that they will order dated?
Order dated. Lordship, কোন date এ বলেছিল?
Yes, I found it.
Lordship.
Furnished by the other bidders.
Other bidders, Lordship.
Very
Lordship,
good.
I have submitted trade license named caterer and food license, food supply caterer, Lordship. Lordship, kindly turn, Lordship, page 16. The trade license of Arun Kumar Nandi.
Yes.
Lordship, 4th line. Trade or calling of enterprise dealing with food items category, catering service. Nature of business. This is the West Bengal municipal tax, it is, Lordship. Trade license. And Lordship, food safety license, Lordship, page 19, Lordship. for the same bidder, Lordship. He is one of the successful bidders, Lordship. Page 19, Lordship.
Yes.
Third column, caterer. Follow me. And Lordship,
Third
now
column?
third, Lordship. Page 23, Lordship.
No, page 19 is what?
Caterer service, only caterer. Food license, Lordship.
Yes.
Third column, Lordship, caterer. First name, address, and third column, caterer. Nature of business.
Yes.
And Lordship, another bidder, Lordship, page 23.
Yes.
Lordship,
yes.
First para, last line. General order supplier and catering service.
Where are you seeing this? Page 23?
First 23, first para, last line. And exercising or intending exercise of professional trade out calling contractor supplier, contractor, general order supplier, and catering service.
Yes.
And Lordship, page 26, food safety, Lordship, which is not readable. That
So
is
this
why
is all for one bidder?
Lordship, this is different bidders. They are the five successful bidders are there.
No, so all the documents you're showing me are in respect of one
Successful
bidder.
bidders.
One bidder.
No. 5 successful bidders. First,
So
I have
all
shown
these documents are relating to one party or what is?
5 parties.
So how will I know that that these documents are relatable to
Name
these
is their
5
Lordship.
parties?
I'm sorry, Lordship. Page 16, their name.
Yes.
Page 16, first, Arun Kumar Nandi.
Very well. Page 26 is what?
Lordship, page 26, page 23, Lordship, the name is another party, yes, Lordship. Ratan Ghosh. This is another bidder.
Yes.
Lordship, page 26 is not readable, Lordship. I cannot say what he has stated in his food safety license, Lordship, it is not readable. They have said. Lordship, kindly turn page 36 for another bidder, Lordship. Lordship, this is Bama Podo Jana. 36.
Yes.
Bama Podo Jana. First. Nature of trade, caterer.
Yes.
Trade license, this is. And food safety license, next page, Lordship, page 37.
Yes.
Same, the Jana Enterprise, Bama Podo Jana. Lordship, food service, caterer. Kind of business. And what documents I have submitted? Lordship, kindly tell, Lordship. Page 40 in my deed petition, Lordship.
Yes. So you're saying that caterer is not enough. What else do they have to give you?
Caterer is sufficient. Caterer is sufficient. That is
Yes.
why I have my trade license bears the endorsement caterer, food supply caterer, and that is sufficient.
So you're saying that you also gave
I am
caterers
also.
and the other successful ones also gave caterers. But you were not qualified.
I am disqualified.
And how are there 5 successful tenderers? There has to be one.
No, Lordship, after technical bids, there is a 5 successful bidder. They have not yet opened the financial bid.
Very well.
After technical bid, evaluation, 5 successful bidders are there, Lordship. And Lordship, my trade license is page 40, Lordship, caterer, Lordship. Page 40. My deed petition.
Yes.
Nature of trade, caterer, Lordship. And next page, Lordship, food safety license, Lordship. Food services, caterer. 41.
Yes.
Lordship, so Lordship, the person whose trade license bears the endorsement caterer and food safety license bears the caterer services were allowed.
Yes. Give me the page numbers once again, please.
40 and 41.
Yes.
40 trade license, 41 food safety license.
Yes. Very well.
They
Anything
are
else?
carrying the same trade license, they were allowed. But my technical bill has been rejected. And another ground is there, Lordship. Lordship, that is, I have not submitted the professional tax receipt for certain year, Lordship. I am showing again, Lordship. 3 years, Lordship, they have stated. Lordship, kindly turn the terms and condition. Page 36.
Yes.
Lordship, page 36, Lordship. That is the first clause which is attested photocopy of professional tax payment certificate challenge for last 3 years. That is the another reason for cancelling my tender bid, Lordship.
Yes.
Lordship, what have stated in the tender documents itself, Lordship, your Lordship will get it from page 18, Lordship.
Page?
18, 1-8,
Yes,
Roman 4.
yes.
Attested photocopy of professional tax payment certificate / challenge for last 3 years. Within bracket financial year 2018-19, 19-20, 2021, otherwise the bid is liable to be rejected. Lordship, I have these are tender 2018 August 2022.
Yes.
I have submitted last 3 years. But Lordship, they are saying that I have not submitted 18-19 because the last 3 years from August 2022, 21-22, 2021, 19-20. So 18-19, they have stated that I have not submitted financial year for the financial 18-19. So they have another reason, they have rejected my technical bid, Lordship. Lordship, I shall show Lordship one thing, Lordship. The government had issued a memorandum, Lordship, whereas it has stated that all the tender procedure will be guided by that tender notice, Lordship. Lordship, kindly memo dated 7 June, Lordship, 2022, page 47.
Yes.
Because there is a misunderstanding created, Lordship. Last 3 years I have submitted, but they are specifically harping on 18-19. I have not submitted, admittedly. Lordship, page 47, Lordship. This is a memorandum dated 7 June 2022. One, Lordship, in supersession of all the orders published earlier in the regard, the governor is pleased to prescribe the following laws for acceptance of tender, Lordship.
Yes.
And what it has stated, Lordship, kindly tell page 50.
Yes.
3C. Sorry, 3D. Sometimes it is seen that tenders are being rejected in pre-qualified stage due to minor clerical rectifiable deficiencies in the uploaded documents of the bidder. In such case, the tender inviting authority may give an opportunity to the bidders whose technical bids are found defective due to minor clerical mistake, rectifiable deficiencies, to explain their position within 7 working days through email. And after receiving the clarification of deficiency, the TIA may take appropriate decision on the admission of the bid concerning the merit of the case. That has not followed in my case, Lordship. That has not followed, Lordship, in my case, Lordship.
Yes.
And Lordship, kindly turn, Lordship, page 39, Lordship. Professional tax payment certificate. Lordship, that is eligible, Lordship. That is why I have given your Lordship the fresh copy. Lordship, within bracket, Lordship, financial year 2021-22, 2021, 19-20, 18-19. That means I possess that. This I have submitted. That means I possess the 18-19 certificate, Lordship. Because there is a misunderstanding, because there it is written the last 3 years, so I have submitted for last 3 years. That is the reason, Lordship. But
Last 3 financial years.
Last 3 financial years. And I possess this, and Lordship, 7 June notification squarely apply in my case, Lordship. They ask me to produce the documents. If I fail to produce, they can reject my case. Because 7 June memo is saying this for deficiency which can be clarified by the bidder. The authority should ask the bidder to clarify the same. And if I fail to clarify, then they can reject this. Lordship, this is my humble submission, Lordship.
But there are 2 grounds for rejection, as your Lordship has seen. Lord, may I take the first ground first, Lord? Lord, the first ground as argued, Lord. The first ground, Lord, relates to, Lord, whether the bidders have the requisite eligibility in the same line of work. Lord, this is a tender for supply of cooked diet to patients. So, Lord, the requirement is that the bidders must have experience in this line of work. Lord, we are not looking at general caterers. We are not looking at people who can run fast food shops. Now we're looking at caterers who can supply to weddings. We're looking at people who can supply and have supplied cooked diet to patients in hospitals, because it requires a special expertise and special skill sets.
Yes.
Now, my lord, insofar as the document is concerned, Lord, if your lordship has a look at, Lord, the tender conditions at page 16.
Mr. Sen, if I have been able to just let me place what Mr. Paul has said. His point is that whatever documents, not the tax part, the other part.
Yes.
The whatever documents he has produced shows that he is a caterer. Apparently, you have rejected him on that basis because he could not fulfill the tender condition. But your report says that all the other bidders also furnished similar documents, which say that they are also caterers. So therefore, why would you suddenly discriminate against him?
My lord. Lord, if your lordship
number
is
one.
pleased to, Lord, may I deal with this point, Lord,
Yes.
at the very outset? If your lordship is pleased to come to the report in the form of the affidavit,
Yes.
this gives the details of the 5 bidders who are successful at the technical bid stage. Lord, my respectful submission is from the documents submitted by them, it would be manifest that they have experience in the field of catering in hospitals. I just indicate the 5 bidders and the relevant document. Lord, the first bidder is Shondeep Haldar. In sequence in which they are annexed to this affidavit, the first gentleman is Shondeep Haldar.
Which
Lord,
page?
Lord, his documents start from page 6. If your lordship is kind enough to come to page 9. This is the Lord certificate of enlistment. If your lordship is pleased to come to the 4th line, it's in bold letters.
Yes.
Other enterprises category cooked diet supply.
Yes.
Lord, thereafter, Lord, please come to page 10. This is the MSME certificate of Shondeep Haldar. Page 10, Lord, please see at the bottom of the page the classification codes under which he is registered. Number 3, operation of canteens, in brackets, example for factories, offices, hospitals or schools. Lordship has seen that. So Lord Shondeep Haldar certainly has the past experience. At least his statutory documents show him to have the experience. Now then is Arun Kumar Nondi.
Udyam is what? MSME?
MSME.
Yes.
Udyam registration certificate is registration as a MSME enterprise.
Yes.
With this certificate they give to ensure they don't have to put in any earnest money, security deposit, all that. Now the next one is Arun Kumar Nondi. Lord, please come to page 16.
Yes.
This is the certificate of enlistment. 4th line, your lordship will find it says food items category catering service.
Yes.
Then, Lord, please see the clarificatory document at page 17. Again, the classification codes under which he is registered at the bottom of page 17. Lord, please turn the page over to page 18 and please see serial number 6. Your lordship will find operation of canteens, in brackets, example for factories, offices, hospitals or schools.
Yes.
Now the next is Sharup Kumar Ghosh. His documents start immediately thereafter. And if your lordship is pleased to see page 24. Again, the MSME certificate. Page 24, right at the bottom, Lord, the classification code serial number 4.
Yes.
Similar classification, Lord. Lord, the next is Geeta Rani Jana.
No, operation of canteens.
Lord, canteens in brackets, Lord, it
Yes,
says
yes,
factories,
hospitals.
offices, hospitals.
Yes.
Lord, next is Geeta Rani Jana. Lord, please see 2 pages, pages 30 and 32. 30 is a certificate of enlistment. The 4th line in bold says cooked diet. Page 30, Lord. 4th line
Yes.
in bold, middle of the line, Lord, cooked diet supply. And page 32, your lordship will find the MSME certificate, similar MSME certificate with regard to operation of canteens, etc. in hospitals, in brackets. And finally, my lord, the next one is Bama Podo Jana. Lord, please see page 38.
Yes.
Lord, serial number 3 at the bottom of the box. Lord, similar code, classification code, page 38.
Yes.
Page 38, serial number 3 at the bottom, the box at the bottom. It says operation of canteens, hospitals. So, my lord, so far as
And where is the petitioner's document?
now the petitioner is document is at page 40. Typo. Problem? Tomar document. Which says caterer. And the next document says food services caterer. Lord, he has also obtained a certification under the Food Safety and Standards Act at page 42, 3 classification codes, prepared foods, page 42, Lord, prepared foods, ready to eat savories and beverages, excluding dairy products. So, Lord, critical to supply in hospitals, Lord, is past experience of having supplied in such establishments.
Which clause is that?
Lord, if your Lordship is pleased to come to page 18 of the writ petition. Page 18, Lord, serial number 4, clause 4.
Yes.
And Roman 5.
Yes.
This is a trade license or certificate of enlistment for trade in the field, catering license for supply of cooked diets, and food license compulsory. So, supply of cooked diets.
Yes.
Lord, the pith and substance, Lord, is past experience in this line. Because, Lord, we can't permit even 1 day's delay or 1 day's default.
You're the ESI hospital?
Lord, I am not for a state, Lord.
Yes.
The ESI hospital, Sirapur, Lord.
Yes.
Lord, this is the first condition for which we rejected. It's an essential condition.
Yes.
Now, the second condition, Lord, your Lordship, again, please comes to page 18. That's serial number 4. Clause 4, serial number Roman 4. Attested photocopy of professional tax payment certificate or challan for last 3 years in brackets, financial year 2018-19, 2019-20, and 2020-21. Otherwise, the bid is liable to be rejected. Lest there be any ambiguity, Lord, we have specified the specific financial years for which we wanted the trade licenses. Lord, it is really no good in saying I have it, but I have not given it. Lord, we can't open the Pandora's box by allowing, Lord, unsuccessful bidders to now say we have documents, please allow us. Now, Lord, what was shown to your Lordship, Lord, is the memorandum at page 47. Now, this is a memorandum of 7th of June, 2022.
Yes.
Lord, what was shown to your Lordship is at page 50, general instructions.
Yes.
Lord, please see serial number 3D or clause 3D.
Yes.
Sometimes it is seen that tenders are being rejected in pre-qualification stage due to minor clerical or rectifiable deficiencies in the uploaded documents of the bidders. It is in these circumstances that 1 or 2 will apply.
Yes.
Non-furnishing of a document in its entirety is not, in my respectful submission, a clerical deficiency or a rectifiable deficiency. If
You're saying it's an essential condition?
There is no argument that it is not.
Yes.
But if it is an essential requirement or a condition, I have to impose it. If it is an ancillary condition, I can permit relaxation, but that relaxation has to be given to all bidders. I cannot pick and choose amongst the bidders to whom I will give the relaxation.
You mean you cannot pick and choose amongst the unsuccessful bidders?
Amongst the unsuccessful bidders. Now, Lord, please see Roman 1. The tender inviting authority may give an opportunity to the bidders whose technical bids are found defective due to minor clerical mistakes or rectifiable deficiencies.
Yes.
If he says, I have a document, but if he does not say that he has the document in his bid, later in the affidavit filed in court, he says, I had the document in my possession, but I did not give it. No, that is not, in my respectful submission, not a clerical mistake or something we could have rectified at that stage, knowing that it's a mere ministerial mistake which can be rectified. But if the document shows that the eligibility criteria is of 100 lakhs, and he says by mistake 99 lakhs or 90 lakhs, whereas the document shows it is 100 lakhs previous experience, then it's a clerical mistake. Not insofar as these documents are concerned, Lord, there is no dispute between the parties. Not in my respectful submission, on both or any one of these two grounds, the Lord
And these are what, either or both of them have been, have to be taken?
Both are there. Even if your Lordship finds that I satisfy any one of the two, it is good enough for the tender to be rejected. My
Or
learned
if
friends
the, if the bidder dissatisfies one of the two?
is disqualified under any one of the two. Any one.
Very well. Yes, Mr. Paul, in one sentence, please.
Lordship, one sentence, Lordship, because the
Very
document.
well. Two sentences for either, for the two clauses.
Lordship,
Either or.
first thing, Lordship, kindly turn, Lordship. He cannot improve the grounds of rejection, Lordship. Ground of rejection is that trade license I have not submitted as per the clause, Lordship. I have shown your Lordship that other trade license is same, Lordship. And so far as MSME certificate and others, Lordship, kindly turn, Lordship. Page 36. Everything will be clear, Lordship.
36.
36, Lordship.
Yes.
The cancellation order, Lordship.
Yes.
Lordship. First clause, left hand side.
Yes.
Registered firm, registered with MSC, MSME, cooperative society, etc., or not, Lordship. My name is appearing last but two, Rupa Enterprise.
Yes.
MSME. That means I am also MSME qualified, Lordship.
Yes.
I have not submitted that document because that is not relevant, because that is not the reason or the ground for rejection. And Lordship, bottom, Lordship. He is saying about credential, Lordship. Credential certificate. Participant should have at least 3 years experience as per verdict to the Honorable Supreme Court, that is from April 2011 to till date in supplying cooked diet in any government hospital, Lordship. I am successful, tick mark. That means I am also supplying the cooked food to government hospitals. They admitted. And now my learned friend is saying that they are searching for an experience. I am also experienced as per the terms and condition of the contract, Lordship. And the persons who are situated in similar situation, Lordship, they have stated caterer, I have stated caterer, even trade license, Lordship. And on the basis of the trade license, I am doing this work. That will be evident from the documents. They have admitted those documents. So that is not the real ground for rejection. And Lordship, number two, that financial year, Lordship, kindly tell what is the intention, Lordship. Kindly tell, Lordship, page 24. Their intention is last 3 years.
Yes.
Clause 40, Lordship. The calculation of rates of acceptable bidders will be on the basis of overall monthly financial implication for supply of all categories to diet based on weighted average of monthly consumption figure of last 3 previous years. Their intention is last 3 years, Lordship. So they have asked for the credential for last 3 years from 2011. And this is for last 3 years. And there is a confusion, Lordship. Because in the terms itself confusing. Last 3 financial year and stated 1890. So 7 June memo squarely apply in my case. They could have asked me whether you have possessed this document or not. If I fail, then they can reject it. This is my humble submission.
Very well. Thank you. Heard learned counsel appearing for the petitioner and the state respondents. Stop. List this matter on 18th April 2023 under the heading for judgment.
Much evidence. Deeply.
Next. Okay. Done.
Application. Application item number 145.
So we are respondents. Lord, we're suffering interim orders brought about because of our conduct.
What are you doing, Mr. Arifin? What are you doing?
We have filed that application, so that must be in my mind that
He must be doing something peculiar.
Yes. Yes.
Lord, I'll just give a brief indication.
You will
Milord.
not let Mr. Chakraborty start.
Milord.
Whose application is this?
I have vacating. I thought about this situation where he'll preempt me from
my
starting, but
petitions-
I have vacating applications.
But I have filed 4 writ petitions. I was compelled to file 4 writ petitions. Now they have filed lot applications in
But
3 writ
Mr.
petitions.
Chakraborty, applications are for the applicant to have the right of way.
Absolutely, absolutely.
Are you the applicant here?
No, I am the writ petitioner. Let him start. Not. I have
Very
prepared a
well.
list
Yes.
of that. I'll give it to him.
Yes.
I'll just take,
Vacating application against what?
but I'll just give a brief background, Milord. There are 2 tenders. One is, Milord, for extracting coal, and the other is from carrying coal from the point of extraction, which is at the mine, to the railway siding. Now, my learned friend's clients, Milord, participate in both tenders, and he is successful in both tenders. Letters of award are, Milord, allotted. Tender conditions say that once I give him, Milord, possession of the mines and in the first matter, possession of the mines, he has to open a performance bank guarantee within 14 plus 7 days maximum. 21 plus 7 days maximum. He doesn't open up a performance bank guarantee. He, Milord, gives us 3 letters saying that the situation at the mine is such that it is impossible for him to perform the contract, and he wants extension to open the performance bank guarantee, and he wants protection for the purpose of performing the contract.
No, that is the case in the writ petition. You have filed a vacating application against an order saying what?
No, there are 2 orders. First is, Milord, dated 11th of August 2022.
Which page?
That I'll just tell you, Lordship.
You're for ECL?
I'm for ECL. May I just take 2 minutes, Milord, and I'll just tell you, Lordship. I'll come to this immediately. So, Milord, he doesn't perform the contract, and he says that I have a problem with the law and order situation. He writes 3 letters. We write 5 telling him that please come and first you give your performance bank guarantee. Time has come to an end. Doesn't do that. We terminate his contract. We give him a notice of hearing and we blacklist him. Now, Milord, in between comes the writ petitions. The first writ petition, which is 7470 of 2022, that is, Milord, for extension of time to put in security deposit. That and the second writ petition, Milord, challenging the blacklisting, which is 17023, are taken up together, and a common order is passed on 11th August 22. The point taken is that there was no notice given for the purpose of, Milord, that there was no notice given for blacklisting. And on the first day, Milord, we were not in a position to show that notice was in fact given. We filed review proceedings, etc. That's, Milord, pending.
Review against
of
that
the
order.
11th August interim order.
Yes.
Next, Milord, before, Milord, the blacklisting is done, the contract has been terminated also. So, Milord, we proceed with a new contract, with new tender. When we issue the fresh tender, he comes, Milord, and he challenges. This just before a vacation, Mr. Arifin was there. He agreed that till the matter is taken up in vacation, we will not, Milord, issue any work order. And that's, Milord, stuck, Milord, from then till now. That is recorded in an order of 20th September 22. Now, before the vacation bench, I'm told, Milord, matter was adjourned for some reason. And now, Milord, the undertaking has prevented the new tender process from carrying on. After that, pursuant to advice, they gave a fresh hearing on 12th of October 22 and again terminated. So,
They
Milord,
or as in
Coal
you?
India, the Coal
Yes.
India, we, Milord, again terminated.
Yes.
So that infirmity, if at all was existing, is gone. Plus, I'm in a position to show that the termination precedes the blacklisting. Now, long and short of it, my lord, the situation is this. There are two tender processes.
So you are against which order?
I am against the 11th August order and against the 20th September
What
order.
did the 11th August order say?
My lord, preventing, my lord, blacklisting.
Order can't
Because-
say preventing
No, I'm
blacklisting.
sorry,
What does
no,
it say?
But staying the blacklisting, staying the blacklisting.
Very well. And what is
No,
the
this
other
is-
order?
I'm sorry, my lord.
What is the other order?
The other order is records my undertaking not to proceed with the tender process or issue, my lord, a letter of acceptance. Now, kindly, my lord, if your lordship appreciates,
Yes.
the order of 11th August was really on three grounds. Today nothing survives because the petitioner has not, my lord, proceeded to perform the contract during its subsistence.
Yes.
He said, my lord, that there was a law and order problem, I can't proceed.
Yes.
If that is the situation, he can't prevent somebody else from, my lord, being awarded the tender and from proceeding, because I need to get my coal out of my mine. Secondly,
Of your mind.
of, my lord, we are, my lord, mine owners. So, my lord, excavation has to be done. He, my lord, doesn't perform the contract himself. He's in breach because he doesn't open the bank guarantee.
Very well. Where is the reason?
So kindly take, my lord, can number 1 of RVW 214. This has the interim order at page 13.
Yes, I have
So
it.
he's effectively, my lord, prevented mines from becoming operational.
Yes. Where is the
My lord, please, facts are noted. Now, my lord, kindly come to the
yes.
my lord, page 15.
Yes.
With regard to the first paragraph, with regard to the issue of partnership, the petitioners have brought the relevant facts on record, deed of partnership. My lord, let me, my lord, omit that and go to the next paragraph. The impugned decision to blacklist the petitioners appears to have been made by ECL on A, the petitioners failing to deposit the performance security deposit within the period stipulated under clause 4.2 of the general terms and conditions, etc., etc. Then, my lord, in fact, I'll read it. Secured within the period stipulated under clause 4.2 of the general terms and conditions of NIT. Clause 4 of the NIT dated 29 December 21 relating to security deposit requires submission of performance security within 21 days of issuance of letter of acceptance by the successful bidder. Clause 4.2, however, ends with the company having the option to approve submission of performance security beyond 21 days on a case-to-case basis. It is hence clear that ECL has power to extend the period stipulated in clause 4.2. The impugned communication does not reflect whether ECL exercised this power or the reason why ECL did not opt to extend the period for submission of performance security. The second basis for the banning is the petitioners failing to be present in the personal hearing held on 20th June 22. While the petitioners say that they did not receive any notice of hearing, ECL says the opposite. Even if it is a disputed fact, it is indeed curious as to why the petitioners were banned in respect of one of the tenders, while the hearing date for the other tender was changed to a future date. This reflects the unreasonable stand of ECL. If the petitioners were banned from participating in one of the tenders for failing to appear on a particular date, permitting the petitioners to appear on another date in respect of a different tender does not stand up to the test of reasonableness. In this context, the guidelines for banning of business in the tender document specifically require observance of the principles of natural justice before banning the business dealings with any contracting entity. The impugned communication makes it clear that the petitioners were not given a hearing, far less an effective hearing, before taking the decision of banning the petitioners from participating in the tender for 2 years. Third, clause 4.2 of the NIT provides that the company ECL shall debar a defaulting contractor from participating in future tenders for a minimum of 1 year from the date of issuance of such letter. The petitioners have been banned for 2 years without showing any justification for the same. It also appears from clause 6 of the tender conditions that the engineer in charge and the contractor shall agree upon the time and progress of work prepared on the basis of a schedule to be submitted by the contractor. This clearly indicates that the time for completion of contract and extension would be decided on mutual consent of both the contractor and ECL. This was admittedly not done in the present case. The fact that the petitioners face disturbance from antisocial and asked for police help is also documented. This court has also taken into account the fact that the banning of business of a contracting entity can only be done with the approval of the competent authority under clause 7 of the guidelines for banning of business. This clause further provides that in case the accepting authority of the work is up to the level of the board or impart committee or officer, the competent authority for banning shall be such and such. Now, my lord, these were the reasons. And last paragraph was these two, my lord, hold that the action of ECL banning the petitioners for 2 years cannot be sustained. Now, I am, my lord, today not really on banning, my lord, whether he works the contract or somebody else does. My lord, we need the coal. It's been stopped for more than a year now, about a year now, not more than a year. So, my lord, if your lordship directs.
From about a year means from the date of the
My lord,
blacklisting?
Yes, because no, from December 21 is the tender process.
Yes.
There are, so my lord, round about that time, my lord, this, I'm sorry, from March 22, which is the date of the letter of acceptance. So he was supposed to be working from March 22. We are, my lord, in March 23. So we need, my lord, the coal from the mines. Now, if your lordship, so I can show your lordship that he did indeed receive notice prior to the hearing. If your lordship wants, I can give him a further hearing. I have nothing against him. That, my lord, that's a completely separate matter. It has nothing to do with, my lord, me proceeding with the tender process. Now, my lord, if your lordship sees the termination, he files a writ petition.
Yes.
Yes, I'm going to complete my submissions. My lord, there are 2 letters your lordship can, my lord, see. In the first writ petition, 7470, my lord, pages 224, 222 and 224. My lord, there are 2 letters which are relied upon by the petitioner. His complaint saying that there are antisocials, etc., etc.
Yes.
After that, my lord, we have issued 5 letters. Pages 226, page 230, and in the affidavit in opposition, pages 22 to 24.
Yes.
Now, these show that we have been consistently asking him to put in his performance guarantee. He has not, my lord, put in his performance guarantee because he says that antisocials are preventing me from performing the contract. It is at this stage, my lord, that I proceed for termination. Termination, my lord, is effectively state. I give him a hearing and do another termination. He doesn't come for the second hearing also, subject to correction. Now, that my lord, order is there. So today, my lord, he can't prevent me from proceeding. I am, my lord, humbly submitting. Kindly, my lord, consider and permit me to proceed and call for a fresh tender process. I'll give him a hearing and decide blacklisting. That there's no urgency in that. But the real urgency is that I need to, my lord, have these mines worked. Now, his excuse is that because of the law and order situation there, it was not possible for him. And time should be extended.
You have been waiting for the mining since when? Give me that.
Since, my lord, 28th of March 2022, which is the date of letter of acceptance for both tenders. So from March 22 till today, my lord, the mines are
by the private respondent.
Yes, given to the private respondent.
Yes.
So kindly, my lord, let me proceed with the a fresh,
No,
because
but
now
the order
everything
is
is gone.
order is of August 2022.
Yes, that's just, my lord, the first one is of August 22. That is the blacklisting order. The second one, my lord, is 20th September 22.
No. But then from March to August, what were you doing?
March to August, my lord, he didn't do the work.
Very well.
He didn't do the work. He didn't even give in his performance guarantee. I don't want a full-fledged hearing today. My lord, the clause for the performance bank guarantee is 4.1. He's got 21 days.
Yes.
4.2. He's got another 14 days.
Yes.
So, my lord, 21 and 14 and not beyond.
Yes.
He's not put it in at all. He's not interested. Now, rights in damages, etc., that can be decided in arbitration, civil proceeding, whatever he chooses.
Yes.
No, these are my humble submissions. Okay, shesh korte dao.
Lord, I'm a little confused, my lord. I thought Mr. Chaudhary was arguing my writ petition. Lord, he filed review petition. Lord, the law that I have learned from your lordship, Lord, he has to show error apparent on the face of the record.
Mr. Chakraborty, you don't know that you don't start with lines like this in this court?
Lord, I should never start with any court, Lord. But Lord, he filed a review petition.
Don't say things like arguing my petition and all that. I don't like those lines.
Lord,
Yes.
I should not say it,
Yes.
Lord, before any your lordship, Lord. Lord, the first, second matters, your lordship, Lord, passed a detailed judgment, Lord, of 7 pages. In the writ petition, they filed opposition. We filed a review petition is taken out. Now, Lord, a review, Lord, in a review, he Lord, placed the matters on merit, Lord, of the writ petition. Now, Lord, I will, if my Lord allows me, I will try to, Lord, seek your lordship, Lord, sanction, Lord, to use an affidavit against the review and vacating. Number one. The first two writ
What
petitions.
is the status of the review pending?
Yes, he is moving a review today. He is moving the.
Vacating.
I have completed my submissions in 4 writ petitions. I'll file a small note, not crossing what I have said. I have to get that order, my lord, out of the way so that I can proceed to work the mines. My learned friend will say he wants.
No. What did you place just now? The review or the?
No, my lord, this is, my lord, effectively my submissions in all the 4 writ petitions, because to blacklisting, I don't want to enter into the merits. I will give him a fresh hearing.
Mr. Chakraborty, how do you respond to what Mr. Chaudhary is saying, that you will be given a fresh hearing?
Lord, the same submission was made by Mr. Arifin. In your lordship, last order is recorded. They took us to the hearing. Lord, in the hearing, to overreach your lordship's order of vacate, Lord, staying of the blacklisting, they, Lord, cancel the tender. Lord, I tell you, lordship, I have prepared a list of dates.
Just tell me whether you are willing to go for a hearing.
I am always willing, but what he will give me this question to myself, Lord, the situation, may I just explain to your lordship? Lord, 2 tenders were floated. I participated, I became L1. I was not being able to perform. I came to your lordship's court with a writ petition. During the pendency of the first writ petition, they blacklisted me with regard to the first contract, contract 1, contract 2. Lord, I challenge that before your lordships. 2 writ petitions were taken up together. On 11th of August, the writ petitions were decided by your lordships, Lord, at the interim stage. My lord, stayed the order of banning. On that day, Lord, Mr. Arifin did not disclose, or ECL did not disclose, that they have floated another tender for the same work without cancelling the existing tender. It was not brought to your lordship's notice. Now, I had to come up challenging the first tender, because my case in the 3rd writ petition was that without cancelling an existing tender for which the blacklisting is stayed, where I can work, you cannot float a new tender. Your lordship took up the matter. He said that we will not proceed with the tender and we'll give them a hearing. I went there to, Lord, circumvent your lordship's court, Lord. On that particular day in October, when the 3rd writ petition was pending, he passed an order of cancellation, which is dated 23rd May 2022. So order which was passed 10 months back, which has never seen the light of the day, was handed over to me. Not brought to your lordship's notice in 3 proceedings. I challenge that in the fourth writ
No,
petition.
you go before them for a hearing on the blacklisting.
Lord, blacklisting, your
What,
lordship,
what are you hurt by now most? The blacklisting order?
blacklisting order is stayed by your lordships.
I'm asking you, what I have passed is a different question.
Blacklisting one and the cancellation is second.
Cancellation of the?
Cancellation of the, Lord, my LOA, letter of acceptance. They have cancelled, candidated by 23rd May 2022 order, which was passed without hearing me.
Very well. Now you want to, let me understand, you want to do the work or you don't want to do
Lord,
the
I
work?
want to do the work. My case in the writ petition was that the collieries are to be guarded by the CISF.
Your case was that you wanted to do the work, but you could not because of certain problems.
Absolutely.
All right.
Absolutely.
So you are today hurt by A, the order of blacklisting, and number two, the cancellation of the tender.
Cancellation of the tender.
Very
And
well.
they are floating a third tender. Now my right to work under the tender.
So if I direct them to give you a hearing with regard to the blacklisting, then that will, whichever way the decision goes, if it goes in your favor, you will be able to participate in the third tender.
Lord,
Then what
subject to correction,
prejudice remains?
May I just come in for a second? Subject to correction, we will say blacklisting will take care of the fact that whether I will be able to participate in third tender or not.
Yes.
But my right to work in the existing tender, whether that could be taken out by floating a further tender without cancelling the tender. Once a tender is floated, I become L1 without cancelling that tender, they cannot float another tender. So what?
You participate in the tender?
Lord, I am already the L1 bidder. I am successful bidder. I have declared successful bidder. LOA is executed. Now that LOA is cancelled. Now a successful bidder is being not asked to participate in a third tender when
No,
he is.
but if the LOI is cancelled, then how can you remain the
But that
successful bidder?
cancellation is under challenge before your lordship, and your lordship has stated that.
Very well. Yes, Mr. Chaudhary.
He, my lord, had been by first
Two issues. One is a blacklisting. One is a cancellation of the tender, despite what he's saying is being declared as the L1.
I'll take this first one first, blacklisting. I'll give him a hearing, let him come and pour his heart out, and we'll consider fairly and pass a reasoned order. Till the time the order is passed, your lordship's order may continue, my lord. We have no objection.
Yes.
Second matter is where the urgency is, my lord, the mines, my lord, have to be worked. There, my lord, he had obtained a contract for us. He was in breach because he didn't submit his performance bank guarantee. He has no defense to that. Number one. Number two, that, my lord, contract was for 1 year. That period of 1 year is over. Now, we terminated, floated a fresh tender. That tender has been stayed pursuant to because of an assurance and undertaking given by us. We want to withdraw that undertaking, cancel everything, proceed with a fresh tender process. This is all. Because
till you decide on the blacklisting, Mr. Chaudhary, you will not proceed with the tender, with a fresh tender.
Yes.
Yes.
Absolutely. Because if we are not to hold him guilty, my lord, then he has a right to participate. So there is no difficulty.
May I suggest something, Lord, to Mr. Chaudhary, my lord? If they could foreclose the tenders that they issued, then, my lord, just
I have advised them to proceed for damages.
Chaudhary, let him
Hear me
complete.
for a-
I'm sorry.
Then you react.
If they foreclose the tenders, then, my lord, if they cancel, then I will have to face penalty. So I'll have to challenge the cancellation in whatever way that comes. If they foreclose the tender, there will be no penalty on me. And if the blacklisting is set aside, Lord, they can float a new tender. Lord, I should not suffer any prejudice. I should not suffer any prejudice whether blacklisting or
If they don't foreclose, then what penalty will you
Lord,
face?
if they don't foreclose, then they will not either cancel or terminate. The effect of cancellation and termination is blacklisting.
No, what cancel or terminate? They have already terminated, I thought.
That is under challenge for your lordships. So foreclosure has no penalty. Cancellation is the effect of cancellation is blacklisting. So they will cancel today. They have cancelled today. If I don't challenge that,
No, Mr. Chaudhary, what you're saying, it doesn't make sense. I will direct them to give you a hearing with regard to the blacklisting.
My lord.
Till they pass a reasoned order on the blacklisting, they will not give a fresh tender, issue a fresh tender.
My lord.
Because then that would be unfair to you.
Yes.
If they keep the matter hanging and then you are prevented from participating. Number one. Number two, with regard to what was the other point? One is the cancel. Yes. So that takes
That is
care
all.
of the
That takes
termination
care of
and
everything.
the
Perhaps that won't, not why I say lordship. Lord, they are floating tender for the same job that is allotted to me, that is awarded to me.
I am telling them, I am going to restrain them from floating any fresh tender till they decide on your blacklisting.
Lord, kindly take a situation that blacklisting is not waived by them. They don't blacklist me. So then I'll have to participate in the third tender.
Yes.
But I am already awarded that tender, that particular job.
But I thought that you have not paid your security deposit.
But your lord-
Your performance
Performance
guarantee.
Your lordships have ruled in categorically that they have a right to extend the time to submit performance guarantee. So my failure to submit performance guarantee is not wrong. The wrong is on their part. Lord, to circumvent your lordship's detailed order, these steps are being taken. Lord,
Mr. Chakraborty, I am of the view that if the LOI is of 28th March 2022,
my lord,
then this kind of order cannot continue for all times to come. I will, in any case, I will have to decide this is not a suo motu kind of thing that suddenly I wake up one day and I see that I have to pass an order. No, there is an application pending before my court for review and for vacating, whatever.
Fine.
I will have to decide that in any case.
My
So this order, I'm just giving you, I'm just expressing my views on it so
My-
that you have a chance to respond. That's all.
Lord, I am ready to go for the hearing regarding blacklisting. I have no objection. Now, my lord, I am more concerned about the cancellation. If the cancellation stays, then, my lord, I will face penalty under the contract.
What penalty, Mr. Chaudhary?
Penalty is, my lord,
Lord, he's
I will show you.
acted
lordship.
in breach under the
I'll
contract.
show you, lordship.
No, I'm sorry. The petitioner has been in breach of contract. The clause says that he had to submit performance bank guarantee within a particular time.
He did not.
He did not. And I don't have, my lord, the luxury of, my lord, extending time beyond the point. That wasn't placed before your lordship on the day he moved. Now, if he hasn't done that and he's not performed, he's not done 0.001%
Very
of
well.
the
So what is
contract.
the penalty which he
Penalty
can
is he
impose?
can be blacklisted for that. Number one, there can be pecuniary liabilities. I can proceed in damages.
Be blacklisted again. So
Yes, so
once
you
they will
not-
lift the blacklisting again, they will blacklist.
Despite,
Can
my
always
lord,
come to the court. Yes.
despite, my lord, every opportunity to, my lord, perform the contract, what he's done is he said CRPF is not guarding me correctly and properly, which is why I can't proceed, which is, my lord, the others were willing to perform.
Very well. Mr. Chaudhary, you please take instructions on the penal imposition.
তুমি ছেড়ে দাও আমাকে, আমি চলে যাবো, দরকার নেই।
So now, my lord, after blocking this for 1 year, now he wants me to foreclose so that there's no, my lord, he's
No, I
absolved
will
from
not
all
direct you,
liability.
I will not direct you to foreclose. Just take instructions on whether when I say that this is what I'm going to do. I'm going to direct you, I'm going to dispose of the vacating application and the review as well as the writ petition by directing you to give him a hearing on the
Yes.
blacklisting,
Yes.
which is under challenge, which I stayed. All right. And till you decide on the blacklisting, you will not issue a fresh tender.
I absolutely, my lord, agreed.
And once you decide on the blacklisting, and if that's scenario number 2, depending on one, you issue a fresh tender, then obviously that will depend on the decision. So I cannot say that the petitioner will participate because that will depend on the decision.
Yes.
So this is all that I will do.
I'm absolutely clear.
But
Yes.
provided that this kind of an order will not automatically invoke the penal provisions for the
Yes,
petitioner.
that will.
I'm going to,
That will.
there's an arbitration clause. I'm going to
That
proceed in arbitration against him.
Lord,
I have a claim in damages.
ex parte blacklisting, ex parte cancellation, both
It-
ex
no,
parte.
Mr.
Both without hearing,
Chakraborty, no further on.
both in
on
violation of
this.
natural justice.
No
But
further.
I'm agreeable to whatever fell from your
But
lordship.
I agree to whatever he said. I went there.
I will
participated in the hearing.
pass the order. এটা কবে থাকে? সোমবার. I will pass the order on 17th.
Grateful.
What you do is you just, Mr. Chaudhary, you just tell me on 17th what your instructions are on the penal provisions.
Lord, my fourth writ petition, which I have filed, Lord, challenging the cancellation order, Lord, if they do not agree on the penalty and all that, but that will not become infructuous if your lordship send me back.
No, I will proceed.
Because
in-
I have
take
challenged the
instructions,
cancellation.
but I'll proceed in
Lord,
arbitration.
in violation of natural justice, I show your lordships, my lord, they kept the order in their pocket from 23rd May 2022 and only served it on me in October 2022.
No, that's wrong.
Yes, I'll show that.
Very
I'll
well.
show
I
that.
will
In
pass
any
the order
case,
next
I'll
Monday.
show that.
Yes. How many applications have you filed, Mr. Chaudhary? Review or whatever?
One for review, one for
Not in
vacating.
first 2 writ petitions, 2 review,
And,
2 vacating, in the third,
the-
only vacating.
And the 4 writ petitions are
The
there.
fourth writ petition has
Yes,
not yet been taken up for
the
hearing.
the respondent ECL has filed 4 applications for review and vacating of an order passed by this court on 11th August 2022, by which the ban against the petitioner, as well as the step taken by ECL in terms of floating a new tender was stayed. Stop. Is that correct? Did you hear or did you not hear?
My lord, not 4 applications, not 3 applications.
4 এর বদলে 3 হবে। Stop. Learned counsel appearing for the parties have made detailed submissions on the various possibilities by which the petitioner's loss can be best, petitioner's injury can best be mitigated. Stop. List this matter on 17th April 2023. Stop.
Great.
Yes. Next.
Grateful to God.
Item number 149.
The last. অর্ডারটা কোথায় আমার? Yes, the registrar IT has given a report in compliance with the order passed on 3rd April 2023. Stop. Next, the report states that the orders and judgments passed by the courts prior to implementation of the case information system within brackets CIS, close brackets, are presently available in the quotation marks original site / appellate side - up to 31.08.2020, close quotation marks, under the major tab orders and judgments. Stop. Next, no one appears for the applicant today. Stop. The applicant is given one last chance to appear in the matter on 17th April 2023. Yes, original site.
Like item number 1, Continental Chemical Corporation.
Today's for filing of the written notes, my lord. Yeah, correct.
Your Honor, can I refer to a judgment of the Supreme Court?
Yes, you can, but I have to give the respondent a chance to reply. Yes.
It's the Azam Jahi Jute Mills Workers Association versus the National.
Yes, yes, you cite it, but give me a copy, please.
Judgment. बाकी कोথায়?
Isn't this reported now?
It's this has been downloaded from the Supreme Court website.
Oh, you have to give me a citation. Yes, please find the citation of this. Have you given him a copy?
Yes, yes, Your
Not
Honor.
the entire copy, my lord. Only 2 pages he has given.
I've given him the first page and the
Last page. my lord.
relevant page.
Very well. Then I'm keeping it on what point?
Right to equality, Your Honor.
Which paragraph?
On page 32. Page 31, Your Honor. Paragraph 9.2. Fifth line. Right to equality guaranteed under Article 14 of the Constitution of India is vested right in favor of a person who claims
Very well,
equality.
I've read it, yes. And what did the Supreme Court find?
And the second point which I want to refer to is on page 32, 9.3.
Yes.
The concept of equality before the law and equal protection of laws emerges from the fundamental right.
Yes, 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 that is fine.
And the Supreme Court found that
Where have you referred to this case in your note?
in the note sheets, my lord, in page 3. Case law referred to.
These other judgments we have referred to before.
Which other judgments, Your Honor?
No, there is only one judgment you're
Yes,
referring to.
yes, yes, Your Honor.
Paragraph 31 and 32.
Page 31 and page 32.
Yes.
Paragraph 9.2 and paragraph 9.3.
Very well. I'm keeping it. You just come and respond to this judgment. All right. Yes. The petitioner appearing in person and the respondent have handed up their short points. Stop. List this matter on 17th April 2023 for learned counsel appearing for the respondent to react to the case cited by the petitioner today. Stop. Yes, next.
Item number 2, MOUSHUMI Industries.
My lord, I am for the petitioner, my lord. My lord has directed us to file the written notes of argument, my lord. May I? My lord, I appear on behalf of the second respondent. This is my written note, my lord. Lord, we had raised a point of preliminary objection, and your lordship was pleased to hear us on the point of maintainability.
The notes are only on the point of maintainability.
They are.
What was your point? What was the point raised?
My lord, the point raised is the challenge in the writ petition is an arbitration proceedings which is pending adjudication before the Facilitation Council under the Micro, Small and Medium Scale Industries Act of 2006. So my learned friend's contention is that by the writ petition, he seeks the arbitration proceeding to be quashed. He says that I am not a MSME. So the MSME Act, initially when the facilitation took place, which there was no
Relying on Shilpi.
Shilpi.
Mr. I must tell you, I've passed a judgment on this point. I think last week or something. Last week. তা কি সব্যসাচী চৌধুরী কোন ম্যাটারটা আগে করছে? Last week. Mr. Sabyasachi Chaudhuri had argued that.
My lord, even otherwise, my lord, it is the allegation is factually incorrect because the registration certificates are all a part of his own petition. So, my lord, so he has to first satisfy either the facilitation council or this court factually that I was not a registered. So there has to be some prima facie case that I was not registered, but the facilitation council exercised its authority and took the facilitation. Then it terminated because there was no settlement, and thereafter it proceeded to adjudicate. So his second point was that the facilitation council cannot become the adjudicating authority, and the other point was the point of limitation. So well, all
Very well. Mr. Bose, please look at my judgment because
Yes,
then
ma'am.
I can't pass a judgment without considering my own judgment.
Fine.
All right. 5th March. Declared on, pronounced on 5th March.
I will find out. That's fine.
5th April, sorry, 5th April. Yes, yes, thank you.
Okay.
I remember Mr. Chaudhuri and Mr. Siddhartha Banerjee, I think, was for Garden Reach.
Okay.
Yes, all these points about the registration, that everything has been dealt with.
Right.
Yes,
We'll consider and come back before your lordship, my lord.
yes, because I will have to refer to my own judgment anyway, if there is any point to be referred to. Yes, Learned Counsel have made over their respective notes as directed. Stop list this matter on, you are representing Mr. Vaidyankar?
Yes, my lord.
Yes, list this matter on 19th April 2023 for council to make their closing submissions. Stop. Next.
Great.
Three, Dilip Kumar Bosha.
No one appears for the petitioner.
I am for
List-
the respondent bank.
List this matter on 19th April 2023. Next.
Item number 4, Hindustan Club.
My lord, I am appearing on behalf of petitioner, my lord. This is group 3 matter, my lord. It has been come wrongly in the list, my lord. Kindly may it go out the list.
Learned Counsel of the petitioner submits that this court does not have determination to hear the matter. Stop. WPO 476 of 2023 is accordingly released from my list.
Grateful, my lord.
Next.
Item number 5, Secure Point Solutions.
Petitioner. This matter.
For the respondent, my lord.
The petitioner is involved in the business of printing SIM cards and recharge cards, my lord.
I can't hear you. Speak clearly. Yes.
The petitioner is involved in the business of printing SIM cards and recharge cards, my lord. Now, my lord, petitioner falls under the scheme of, my lord, West Bengal State Support for Industry Scheme 2008. My lord, under the scheme, they became entitled to the sum of rupees 350 lakhs under the fixed capital statement. My lord, that has been recorded in the letter, my lord.
What is the relief you want?
My lord, I'm being led by Mr. Rashid in this matter.
Yes. You can sit down and take your breath, Mr. Dotto. You want them to disburse, who will disburse this amount? 3.20 crores or 3.
My lord, the admitted amount is, my lord, 350 lakhs. My lord, there is a document from, my lord, the respondent number 2, which says I am entitled to fixed capital investment subsidy in terms of the 2008 scheme. My lord, kindly
That
see.
scheme is still running?
My lord,
Or
that-
it's expired?
no. After 2008, there has been another scheme. My entitlement is under that scheme. My lord, there is no, my lord, document. Why, my lord? This, my lord, we have been receiving, my lord, part payments in terms of that admitted
But
document.
Mr. Dotto, if that scheme is no longer in place, what direction can I give?
My lord, even lordship, there is a clause in the scheme that even if the VAT regime changes and after the introduction of GST also, my lord, the scheme says that entitlement would be, my lord, protected.
Clause 19.
Clause 19.2. And lordship had the, my lord, occasion to consider it, and lordship was pleased to pass orders, my lord, directing disbursement in similar circumstances. My lord, I can understand, my lord, today, my lord, I am not in a position to, my lord, press for any interim protection unless your lordship feels that lordship is going to dispose of the writ petition. My lord, I just wanted to show your lordship two provisions from the 2008 scheme and two documents, my lord.
So you have been receiving the benefit of that scheme for how long? You received for how long?
The last benefit when I received this, my lord, kindly comes to, my lord, page 79, my lord. In fact, my lord, before 79, kindly see 73. This is, my lord, in 2015, I received this check of 29,28,365. And then if your lordship takes, my lord, page 79.
What is the date of that?
My lord, this date is, my lord, 18th of May 2015 is the date of the check.
Yes.
And my lord, kindly comes to, my lord, page 79. This is again addressed to me, my lord, I mean the petitioner, my lord, August 31, 2016.
Yes.
Which says in terms of the subject and reference above, this is to inform that after making disbursement of 30.13 lakhs to your company against total VAT paid for 2008, 9 and 9, 10, amount of balance fixed capital investment subsidy will be rupees 319.87 lakh, which will be processed and disbursed only on the receipt of sales tax certificates from Directorate of Commercial Taxes for the financial year so and so. And these certificates are all, my lord, there. I have disclosed it, my lord, in the writ petition. And the admitted document which I was talking about, my lord, that lordship will find at page, my lord, 72. The scheme requires me to apply, and my lord, based on my application, the fixed capital investment subsidy would be sanctioned. With reference to your application, my lord, is at page 72.
Yes.
With reference to your application for fixed capital investment subsidy under WBSSIS 2008 for your printed prepaid mobile recharge card so and so, covered under Part 2 certificate dated 30th August 2011 issued by DI Government of West Bengal, we would like to inform you the corporation has admitted 350 lakhs towards the said fixed capital investment subsidy on the following terms and conditions. So out of this 350, my lord, the document at 79 says 30.13 has been, my lord, disbursed. Balance is 319 lakhs and odd. My lord, I am today only, my lord, seeking, my lord, an enforcement of this, my lord, document issued by the respondent authority admitting, my lord, the subsidy. And my lord, when I have, my lord, disclosed all the certificates, my lord, showing, my lord,
And
payment of sales
why
tax.
have you come after 7 years?
My lord, I have, my lord, been writing, my lord, the representation, my lord, if your lordship sees at page 103 in 2021, my lord, I have, my lord, wrote to the authority for disbursement of the subsidy. My lord, that is the reason why I say, my lord, interim possibly, my lord, because of the delay, lordship may not.
May it please your lordship, my lord, I am appearing on behalf of all the respondents, my lord, as it has fallen rightly from your lordship. My lord, there are few representation which is, if it falls from your lordship, that we consider their representation. My instruction is, my lord, probably the claims which they are making are time barred, which will be considered. We are making payments, but my lord, we required few documents to process their payments. It has been submitted before the authorities late. Few documents were not even paid, my lord.
Go for WBIDC.
For WBIDC, my lord. So these things are there even on the point of limitation, whether, my lord, your lordship knows, my lord, there is a limitation.
Let them consider your last representation.
My lord, we will consider the last representation subject to, my lord, all the points being kept open. My lord.
Let them consider the last representation and my entitlement in terms of the documents, my lord, by which they have admitted the, my lord, subsidy.
Where is your representation?
22. My lord, 103 is, my lord, the representation of 14th of January 2021, and there is one last representation at 110, my lord, 21st June 2021.
Yes. The petitioner claims a direction on the state respondents to disburse a sum of rupees 3,20,71,635 as recorded in a letter of the respondent WBIDC dated 31/8/2016. Stop. This letter records that the amount of that the balance amount in terms of fixed capital investment subsidy of rupees 319.87 lakhs will be processed and disbursed on the receipt of the sales tax certificates from the Directorate of Commercial Taxes for certain for 6 financial years. Stop. The petitioner claims next, learned counsel appearing with the petitioner submits that the petitioner is covered covered under the fixed capital investment subsidy, 2008, and which would be evident from the letter from WBIDC dated 31/8/2016 referred to above. Stop. Next, there has, however, been palpable delay in the petitioner coming to the court. Stop. The letters relied on are of 2014 and 2016. Stop. The petitioner made representations, the last of which is of 14th.
Well, it should be 21st June 21.
21/6/2021. Stop. Next, the respondent is represented. Stop. Next. Considering the material placed before the court, this court is of the view that the petitioner may at best be entitled to a reasoned order from the WBIDC concerning the eligibility of the petitioner under the scheme, capital S. Stop. The respondents hence shall consider the representation made on 21/6/2021 and pass a reasoned order after hearing the petitioner as to in terms of the eligibility of the petitioner for the balance amount, giving particular attention to the letter issued by the respondent on 31/8/2016. Stop. Next, the reasoned order shall be passed within a period of
6 weeks.
6 weeks from date, and a copy of the reasoned order shall be made available to the petitioner within 7 weeks from today.
All points kept open and nothing is admitted.
Yes, this court, it is made clear that this court has not gone into the merits of the case.
Great.
Much obliged.
Next.
My lord, I am filing the affidavit of service.
This court makes it clear that this court, it is made clear that this court has not gone into the merits of the case. Next.
Grateful.
The affidavit of service is kept on record.
Six. Surjo Das.
But I'm for the petition.
I'm appearing for the respondent state led by Mr. Oyan Banerjee.
আগের ম্যাটারটাই কি আগে থেকে মেনশন করেছিল? তুমি যেটা ছিলে না এটাই কি মেনশন করেছিল আগে? Yes.
Lord, at page 20, annex P2, Lord,
Page?
page 20.
Yes.
Lord, there was an advertisement, Lord, by the Canara Bank for sale of, Lord, one property. And I participated in the auction, Lord, and I purchased the property. Certificate of sale, Lord, is appearing at page 20, annex P2.
Yes. What is the prayer?
My lord, what happened, my lord? This property, my lord, as per the special bench judgment, if, my lord, I want to register this property, then the value mentioned
What
in
is
the
the prayer in the writ petition?
that's, my lord, I'm telling.
Show me come to the page of the prayer.
Lord, this is at page, my lord, 15, and my lord, page 16.
Which prayer do you want?
My lord, I want, my lord, the prayer appearing at page 16.
Yes, which one?
My lord, the amended prayer, my lord, read in the nature of mandamus be issued directing the respondent authorities to refund the balance amount of the stamp duty and the registration fee paid by the petitioner while registration of the sale deed dated 17/9/2022 of the property in question in excess of the amount mentioned in the sale certificate being annexed P2 to the writ petition.
Refund the balance amount of the stamp duty and the registration fee.
Yes.
What is the balance amount?
My lord, the balance amount is, my lord, the amount mentioned is 2 crore and odd, and they have charged me 3 crore and odd.
Where? Which document?
My lord, your lordship kindly comes to the page 21, annex P3.
Yes.
My lord, this is the query. My lord, there set forth
Page
value.
21. It's
Page-
illegible. Where is a clearer copy? 21, 22, completely illegible. 21 and 22, can you read?
My lord, this is, my lord,
Yes. Documents which learned counsel appearing for the petitioner proposes to rely on, learned counsel appearing for the petitioner proposes to rely on certain documents which are completely illegible. Stop. When will you come back?
my lord, 1 week, my lord, your lordship kindly.
Council prays for 1 week to replace these documents with clearer copies. Stop. List this matter after a week as prayed for. Next.
Good.
Item 7, Swastika Steel and Allied Products.
So item 7, I am appearing for the petitioner lordship.
Can't hear you, microphone.
I am the
For the
respondent.
petitioner lordship, as directed, direction was given by your lordship, an amendment petition was filed by the advocate on record, but the amendment petition was served with other side is the affidavit of service.
You are appearing for?
I am for the bank, respondent bank.
But in the amendment petition lordship,
Speak clearly.
in the amendment petition lordship, the advocate on record failed to lordship annexure P1. And if your lordship kindly take the G.
So you want further amendment?
Lordship, I am praying before your lordship to withdraw this amendment and with liberty to praise to file a first amendment petition.
I will not give you that liberty. When did you file the writ petition?
2022 lordship.
22.
22nd November 2022.
And when did you file the amended writ petition? Very well. Counsel was given, the petitioner was given leave
13th March of
to file an amended writ petition on 16 March 2023. Stop. This was not the amended writ petition was not served on the bank, as would appear from an order dated 30th March 2023. Stop. The position remained unchanged on the next date of hearing, which was 4th April 2023. Stop. Next. Learned counsel appearing for the petitioners submits today that the amended writ petition does not contain a vital document. Stop. Counsel seeks to withdraw the amended writ petition on this basis. Stop. Next. WPO 305 to 2022 is accordingly dismissed as withdrawn. Interim orders, if any, shall stand vacated. GA 1 of 2023 is also disposed of on the above basis.
Lordship, kindly allow me, Lordship.
No. No, dismissed of it. GA 1 of 2023, which is
File on 13.
for amendment of WPO 3052 of 2022 is accordingly dismissed for the reasons stated above. Stop. Since the petitioner has been given sufficient time and opportunity to amend the writ petition, but has failed to take prompt steps, the prayer for liberty to file a fresh writ petition on the same cause of action is considered and refused. Next.
Nominated.
And refused.
Eight, Sri Sandeep Kapra and others.
Well, the challenge is to an order declaring me willful defaulter. Well, if your lordship will straight away come to page 51.
Lordship, before my learned senior is arguing the matter on merits, I am on the very maintainability of the this writ application, Your Lordship.
Mr. Shah, has a similar writ petition been filed in the appellate side?
Your Lordship, connected to that. That is for cancellation, allowing the petitioner to go abroad since they have been declared as a willful defaulter.
That is for a lookout notice. That is a
this is for causing the declaration of willful defaulter, which has already been done 4 years back in the year 2018.
No, but I think who was moving that? Mr. Shobhushaji Chaudhary.
Lookout notice. Shobhushaji. Yes, I understand, Mr. Shobhushaji.
Then what?
That
Then
is
why
challenging a
file this
lookout.
in the?
Well, this is a declaration of willful default.
After 4 years, Your Lordship, the entire process of willful
Kindly
declaration
have a look at the order. I will not make any further submission beyond that.
Lordship has already been completed by way of.
1 minute, I will come to you, Mr. Singh.
Well, just kindly see page 51 once.
No, what is the prayer?
Well, the prayer is to quash this order 25th October 2018. Well, at page 51. Well, by one common order, the willful default identification committee and the review committee.
So why have you filed this after 5 years?
Well, this company was in CIRP. And today, really nothing was happening till they issued the lookout notice. Well, it is then that the whole thing got reactivated. Very candidly. But so far as this order is concerned, on the face of it, the order is completely
No, but Mr. Shah, you are complaining now of a willful defaulter declaration, which was made in 2018.
Yes, but
so you have survived happily for the last 5 years. Why have you suddenly come up?
well, so far,
It doesn't seem to have hurt you.
This October 2018.
Yes.
October 2018, normally the effect of this lasts for 5 years. But till October 2023. Now they are on the basis of declaration of willful default, also proceeding to publish lookout notices and so on and so forth. And otherwise threaten me with all the other harassive steps.
So one is being filed in the appellate side, the other on the original side.
Well, I'm not aware of that writ petition, but I'm told that that is confined.
I remember my matters. I'm telling you.
Yes,
It's on the appellate side.
Yes,
Three writ petitioners, 2 brothers, 1 sister-in-law. I'm telling you.
Yes. But that is specifically challenging the lookout notice. That has nothing to do with the challenge to the order declaring them willful defaulters. But I just want to have on a very short point. It'll just take half a minute.
Yes.
By this same order, by one common order, the willful default identification committee and the review committee has both disposed of the representation. Well, kindly just see page 51. This is where it starts. And my lord, may I request your lordship to straight away come to page 54?
Who are the petitioners before this court now?
My lord,
Same
same.
three.
Same.
Two brothers and one
Yes,
sister-in-law.
yes, my lord, same.
Yes.
Well, at the third paragraph, thus the committee members are of the opinion that the above acts of the company and its directors fulfill the criteria of RBI for declaring them as willful defaulter. The company's directors have been afforded opportunity to explain their position and in response thereto reply, etc., etc. Then, my lord, next paragraph. As per RBI guidelines, the above order of willful default identification committee was placed before the bank's willful defaulter review committee of the board. And after reviewing the
Where
said
are you
order,
reading from?
well, page 54.
Yes. Yes.
Well, the third paragraph, my lord, the committee forms the opinion that, my lord, they are willful defaulters. And then, if your lordship sees the next paragraph, as per RBI guidelines, above order of the willful defaulter identification committee was placed before the bank's willful defaulter review committee of the board, and after reviewing the said order, willful defaulter review committee of the board by its resolution dated such and such is approved for declaration of the borrower company, Seabelt Limited, and its directors Sanjeev Kabra, Sandeep Kabra, and Shashi Kabra as willful defaulter. So, my lord, by one common order, my lord, the willful default identification committee and the review committee, my lord, dispose of the matter. Declare me to be willful defaulter. And, my lord, no
And you want
opportunity.
this to be quashed?
Yes, my lord.
Very well. Yes, Mr. Singh.
Lordship, my first sensible submission before your lordship is that this writ petition is a product of afterthought and hit by the principle of waiver, principle of laches, acquiescence, and doctrine by waiver by conduct. Admittedly, your lordship, willful defaulter declaration has been declared by the bank as way back in the year 2018. And it was duly intimated to the petitioner that by way of letter dated, your lordship, appearing at page number 64, their name will be published in the newspaper. The petitioner was not only aware about their declaration 5 years back, but they were also aware about that their name is going to be published in the newspaper.
Which letter is that?
Lordship, the letter is appearing at page number 64 of the writ petition. 24th of April 2019. Let's see, hereby the bank has informed that since you being a willful defaulter has been declared by the bank, your name will be published in the newspaper.
Yes.
Despite of receiving this communication, the petitioner before your lordship sitting idle, not for 2 months, 3 months, or 5 months, for consecutive 5 years. And why
So what did you do? Did you publish their names?
Lordship, the publication has been done May 30th May 2019. This also the petitioner is well aware about. That name has been published as way back in the year 2019, May 2019. Despite of this publication, they did not turn before your lordship.
No, who are these faces?
Lordship, yes, these faces. Now Indian Bank.
There are many faces.
Yes, Lordship, yes. Sandeep
Yes.
Kabra, first two is Sandeep Kabra, and then Sasi Kabra, and Sanjeev Kabra. First three pictures of the petitioners. But despite of this publication, the petitioner choose sit idle. So may I put this question to myself, if though I have a legal remedy, but if a litigant sitting idle for a consecutive period.
So what do? If somebody sits idle, you go on publishing their pictures, or you just
No, Lordship, no. Lordship, kindly visualize what I'm going to argue before your Lordship. Not is that what I have done and done, they are in. I am not on that. Why this writ petition, your Lordship? Kindly see. The petitioner were not being affected by the willful declaration 2018, not being affected by the publication.
But they want to travel to Southeast Asia.
They want to travel abroad. Lordship, what is the declaration?
I'm telling you, it's Bangkok. I remember the writ petition.
Bangkok and Thailand for daughter's marriage. Here the declaration is willful defaulter. He is saying I am not a willful defaulter, but the marriage is arranging in Thailand. So there is a tactics. If this willful declaration done by the bank as way back in the year 2019 will go, automatically the LLC will go. So this is a tactfully taken part.
Is that how it happens? If the willful defaulter declaration goes, and the LOC also goes.
Lordship, the very purpose, as amended by the Ministry of Home Affairs Office Memoranda, that if a willful defaulter, if a person willfully not repaying the dues of the bank and trying to escape the foreign jurisdiction to avoid the repayment, the bank can issue the LOC. Now, if this LOC, this declaration, which has admittedly been done as way back in the year 2018, be quashed, that will certainly impact the decision of the court on merits of regarding LOC quashing. They will say, Your Lordship, their willful declaration since goes, kindly quash the.
Very well. That is on the alleged conduct. What about the merits of the case?
Also, the merits, may Lordship. There is two grounds. First on merits, other on technicalities. Your Lordship, the petitioner before Your Lordship come before Your Lordship only after the issuance of LOC. Not before that. Position ought to have been different if this writ petition has been filed much earlier before the issuance of LOC. This writ petition is a product of afterthought only after.
Don't repeat, Mr. Singh.
Yes,
Anything
and
else?
thereafter,
Yes.
second point, Your Lordship. The points taken by the petitioner before Your Lordship, they are not a willful defaulter, is mere technical. So there are certain judgments on the points. If the result of any adjudication will be the same,
It's
technicalities will not stand in
Mr.
the way.
Singh, I don't have to look at judgments. It's just that whether you're following clause 3 or not.
Your
That's
Lordship,
all.
the bank, Lordship, kindly see, I'm with due respect to the Honorable Court. I am submitting before Your Lordship the litigant who is not diligent to put their grievance in time,
Very
not
well.
entitled to
Very
get
well.
benefit.
That is all.
Lordship, if Your Lordship gone into the all these regards to the
No, on
maintainability.
this maintainability, anything else?
Maintainability. Lordship, these are my points.
Very well. Mr. Shah, you come back tomorrow or day after?
I'll come back tomorrow. I'll come back tomorrow.
Yes, learned counsel appearing for the petitioners seeks to quash declaration of the petitioners being willful defaulters by the dated 25th October 2018. Stop. Next, the declaration has been made by was made by Allahabad Bank. Hasn't the bank also changed now?
That relevant point in the year 2018.
This is now what? Allahabad
Has been
Bank?
done. Now Indian Bank.
Indian Bank. Stop. The next, learned counsel appearing for the Indian Bank within brackets, the erstwhile Allahabad Bank, close brackets, takes a point of maintainability on the ground of delay, latches and waiver. Stop. Next, list this matter tomorrow as prayed for. Next.
Let's say only Lordship subject to Your Lordship approval, obviously. If Your Lordship take any decision on maintainability and thereafter, if at all, then I must get given an opportunity of to.
Naturally.
Lordship, but since I have taken maintainability, Your
Yes,
Lordship will
next.
decide. May take Your Lordship. Much obliged.
9.
For the respondent.
By way of the writ petition, my lord, the writ petitioner has challenged the issuance of notices under willful default by the Bank of Baroda. My lord, the principal and only grievance that the writ petitioner has canvassed before your lordship is that this is in contradiction and in the teeth of the provisions of section 96.
Isn't there a judgment of this writ petitioner in a willful defaulter matter? Yes.
Yes, it was a different matter, my lord.
Different matter?
Different.
Very well. Yes.
But there is a decision.
My lord,
Same part.
the point that the writ petitioner has urged is that by dint of they being guarantors, my lord, not only has the bank proceeded under section 7 of the Insolvency and Bankruptcy Code, but they have also proceeded under section 95 and a moratorium under section 96 of the Insolvency and Bankruptcy Code has been initiated. The order is there. I had placed that order before your lordship. I am saying by dint of section 96 and the import of the order of the Honorable Company Law Tribunal, my lord, no proceedings in the nature of willful default could have been initiated because the order is of my lord, September and the and my lord, the show cause is issued on my lord, 4th of December. So after the order, kindly my lord takes section the order itself, which is my lord at page my lord,
Mr.
52.
Ghosh, you come back tomorrow or day after with this matter. All right.
My lord, actually, my lord, my learned friend had to, your lordship
Very
had
well.
heard
Mr.
me.
Chatterjee, tomorrow or day after? When you want-
Whichever date is convenient to my lord.
Very well, because now there's no time to hear yours.
My lord.
Yes,
There's
you had
one-
finished your submissions.
More or less on
There's
facts.
one judgment of a coordinate bench on this issue, my lord. Maybe I'll hand over a copy of
Which
the,
issue?
my lord, whether section 96 moratorium would prevent, my lord, proceedings from being instituted for declaring a willful defaulter. There is a decision of a coordinate bench.
Yes, place it. If it
I'll
helps you,
give him a
place,
copy,
yes,
my lord,
give,
maybe
give
we
him a
can
copy,
consider it.
copy. Yes. Place it.
Sir, Rajshekar Monta.
When do you want to come back, Mr. Chatterjee?
Whichever date is convenient to my lord.
Day after.
Yeah.
Yes, a learned counsel appearing for the respondent bank, Bank of Baroda, will make his submissions on 12th April 2023. Next.
Grateful, my lord.
10. Honorable Mondol.
Mr. Mukherjee was making submissions.
My lord, I was in fact, my lord, on the last occasion.
I can't hear you.
My lord, on the last occasion, Mr. Mukherjee was not here. I was addressing your lordships, my lord.
Very well. You tell me when you want to come back, Mr.
But,
Roger.
whatever, my lord, is convenient to your lordships, my lord. I can come back day after also.
Yes,
My lord, can it be on Thursday, my lord?
list this matter on 13th April 2023 as prayed for.
Grateful to your lordships.